Good morning, everybody. Welcome back. It's like so bright out now. You lose track this time of year how fast the days start getting longer. Is it just me, or other people kind of notice that? It really hits you like the days start getting like a minute, 2 minutes long, 3 minutes longer, like every day. Really shows up in the morning. Well, welcome back. We still got some cross to get through. It's been a challenge so far. But we have hope. We have hope. Every day is a new opportunity, new possibility to shift, transition, find a better way to do things. Every day is a gift, an opportunity. I gave myself a little bit of homework yesterday, and I did actually do it. I did do my homework. I have my little note here, my little sticky note, to look into a comment somebody had made about Richard Green's testimony from the first trial about Karen Reed having deleted location data. We've had so many questions come up. Why can't they just get the location data off of Karen's phone? So I went back and checked, and I looked through Richard Green's testimony, and I did not see anything. I didn't see anything in my notes about anything Richard Green had to say about Karen Reed and her GPS data. But so I did then go and look at Trooper Guarino. I reminded myself what old Trooper Guarino had to say about his extraction. He, of course, testified a lot more extensively in the first trial than he did in this one, because in the first trial, he was kind of the lead on the digital forensic stuff, and he, like the others, has been demoted this time around, rather like Trooper Paul. But so I did find in Nicholas Guarino's testimony where he mentioned that he did look for GPS location data from Karen's extraction, but there was very little of it. And all he had to say about that was that typically if there's very little location data, it's because location services is turned off. So that's what I saw when I went and looked, tried to revisit. I really did not remember anything about testimony about location data being deleted. Certainly wouldn't be shocked if that's a theory that folks have, but it's not one that I saw was asserted by the defense in the first trial, at least. Now it could have been another witness, but they didn't have like the stable of experts in the first trial like they did this one. So if Green didn't address it, Guarino didn't address it. Doesn't mean Hyder Whiffen couldn't have, but I just don't remember that. So Green is the one for sure I would expect to have something to say about that. So I didn't see anything. Take that for what it's worth. Didn't see it in my notes, but Guarino did say probably location services is off. So that at this point seems to be the best explanation that at least I can come up with for why we can't just look at Karen's phone and see where was she, when did she arrive at Fairview, when did she arrive back at Meadows, etc. Who knew that someday turning your location services on might be the difference between people wondering if you killed somebody versus knowing for certain that you didn't. Don't think about that kind of thing when you think about location services. At least I don't. So the other thing I wanted to do is look at some of the stuff that came out over the last couple days. We had a couple filings yesterday. So I did take a look at those, and ultimately the second one, we looked at the first one yesterday, and that was Hank complaining about, they didn't give me Shannon Burgess's CV before they confronted him with it. Well, if your witness doesn't lie on the stand, you won't have the problem of surprise rebuttal. Play stupid games. You know how that goes. The second thing that he filed was, I'm not going to read through it because at this point it doesn't matter. It was just a memo on what he wanted Judd Welcher to be able to testify to as far as the ultimate conclusions. They had that argument, day before yesterday about Alessi's arguing, he can't testify that there was a collision. It's the ultimate issue, etc. So this is just Brennan filing a memorandum where he's saying it's fine. We're allowed to do that. It's not a problem. Your cases aren't on point, etc. She's already ruled on it, so that's part of why I'm not sure that it's really that significant at this point. But then there was this other thing that was kind of cool, kind of interesting to see. So I am going to go ahead and pull that up. And that is this order in limine. So there's this other case going on, or went on. I guess it happened already. Don't know the outcome of it. But this is over in Suffolk County in Massachusetts State Court. And so there was an order excluding Mr. Welcher's testimony in this court. And so that is kind of interesting to go through. So the first thing that they do is they say that his analysis, so I'll just read through it a little bit. His analysis of how the force of this accident affected the plaintiff's anatomy relies on the delta V calculated by Carrie Alvino to determine the force of the collision. For the reasons set forth above, Alvino's calculation of the delta V is unreliable, thereby rendering the whole underpinning of Welcher's analysis unreliable. So that's just up here. That was this first decision that she made on the motions in limine. The delta V, when you're dealing with car accidents and car accident reconstruction, it's the change in velocity. When you have a collision, you go from moving to being a stop. And so the delta V is kind of one of the ways of calculating the stop. So apparently, Alvino used these different methods. They are not valid methods, or they rely on information that is unsubstantiated. They don't know where she got the information from. They just, there it is. So the court excluded it for that reason. So then, because his analysis relied on that, and it's not reliable, you're not reliable either. It's a derivative problem. So second, that's not all though. It's not the only problem. Second, the relevance of Welcher's opinion is questionable because his analysis is not sufficiently tied to the facts of this accident. And they have this, call it a C site. A consideration of relevancy is whether the expert testimony offered is sufficiently tied to the facts of the case so that it will aid the jury in resolving the matter. And then Commonwealth v. Patterson, expert testimony admissible if, in addition to the reliability of the theory and the process in general, the process is reliable when applied to the specific issue about which the expert is proposing to testify. So it's a relevance problem. Oh, my voice isn't very happy this morning. Give me a second here. Better? Maybe a little bit. Maybe it's just going to be that kind of day. It's very windy here. We got the dust in the air. I've been sneezing like a madman. Just part of the season. So they got a relevancy problem because he doesn't have enough to do with the specifics of the case. And so I'm thinking about this and I'm like, he keeps saying they don't have enough information to figure out like anything about John's case. So kind of seems like his analysis isn't all that tied to the facts of this case because they don't have enough facts. But then again, when he does take positions on things, he is able to point to, the taillight on the ground and the yada yada. So it's not like completely unmoored from these particular circumstances. But I was thinking about how those kind of interplay a little bit. While Welcher cites to one study involving a person of similar age with similar pre-existing conditions to the plaintiff, though he does not identify the size of the test individual, he does not identify the characteristics of any other individuals involved in the nearly 1,000 tests upon which he relies. In fact, Welcher's method of analyzing the impact of an accident on a particular individual by relying on how similar impacts have affected other individuals has been deemed unreliable by the Society of Automotive Engineers because of the variation in individuals' tolerance for physical force. Well, isn't that interesting? Because isn't that kind of what he did? Isn't that kind of what he did? Now, the issue here, though, is that this is mostly Cross that's eliciting this. This is Alessi asking him about like the force required to break bones and things like that. And so, kind of similarly, he's been talking about these studies and other studies, and not just people studies, but cadaver studies. And then something about one guy that was like similar. It was similar to John. I mean, let alone the whole cosplay and the paint. And I'm John's size, so that's, I guess, good. But yeah, he provided it as a range, and I wonder if that gets him outside of this particular criticism, because he said, some individuals this little, others would take up to 7,000 pounds, whatever it was, 2,500 to 7,000 pounds, something like that. And that seems to be incorporating the individual tolerance that people are going to have. We talked about that a little bit. Like, yeah, people are just different, guys. It's what might break one person's bone. I think we all know people like that too. I've never had a broken bone, at least not that I know of. I might have broken a finger, but I'm not 100% sure. It never got x-rayed and it healed and everything. So, but it is a little crooked now. I hit on my bike. But I have a cousin, that was like, since he was maybe 7 or 8, and fall out of trees, break a bone, constantly. I feel like he constantly had a broken bone when we were kids. I was just reading recently, one of my like kind of side interests. I'm fascinated with the biology of sports performance, like the whole physiological aspect of it, the nature versus nurture thing. There's this book I read a few years ago now. Wouldn't mind reading it again just to kind of refresh, but I really enjoyed it. It was called The Sports Gene, and that's basically what it's about. It's about nature versus nurture and athletic performance, and kind of looking at all these different factors that come into play. And this one section of it, they were looking at they call them the Tarahumara runners of Chihuahua, Mexico. They're basically a group of mostly indigenous people that live up in the mountains, and as part of their culture, they run a ton. Like, they run long distances routinely. They hunt by running. They like run animals down for hunting. So they have this ability to run extremely long distances. And so at some point, I want to say maybe in the 90s, I can't remember now, but at some point not all that long ago, when ultra marathoning started to become a thing, somebody, I don't know, got the idea, let's have some of these Tarahumara runners show up and run this. And so they did, and some showed up and ran this race, and they, have no special shoes or training or anything to show up, run the race, smoke all these, elite ultra marathon runners, and then go back home like it's nothing. So there was a lot of study of these particular folks, like what makes them such strong runners. Do they have like a gene for running? How is this worked out? And once they finally started doing genetic studies on these folks, what they discovered is that no, like, for one thing, athletic performance, it's way too complex a trait to just be like one gene. There's hundreds, if not thousands, probably of genes that affect athletic performance. So it wasn't like they had a special running gene or anything like that. But what they did have that stood out, because sometimes people will have different things. You might have bigger heart. You might have better oxygen saturation. Just things around the margins that make the difference between, the elite of the elite and then just like being really good. What they found was that these people had basically very strong skeletons. And that was really it. That was kind of the only distinctive genetic characteristic. And so the skeleton is going to give you better resilience for long distances. It's not just your skeleton; it's also your connective tissue. Is a big piece of running. It's why like everybody who runs gets injured very, very hard on your soft tissue. But so these people had particularly like tough skeletons and skeletal tissue. And the rest of it was just culture, just running culture. So build it on a platform of something that will sustain that kind of wear. and amazing what you can pull off, what the human entity is capable of doing. So anyway, that just crossed my mind because extra strong skeleton. People have all kinds of different resiliences to different kinds of things. So I'm not sure that Dr. Welcher fell in this particular trap again, even though it was on cross, and so it would be probably invited type of error anyway. You don't get to ask him the question and then object that he answers it. Okay, just because they tried it in depth he heard, doesn't mean that that's an actual way you get to practice law. But I was just thinking about this kind of as a matter of principle anyway. Like, does that even work? And I think with his testimony and the way he gave it, it probably does incorporate, because it provided that range, it incorporates at least some idea that there's going to be individual variance for these types of things. Similarly, there's no indication of whether any of the studies involved vehicles of the same size or weight as those involved in this accident. We don't have that problem. They got the exact same car. They got that exemplar, brought it all the way out from, was it Texas or California? Either way. Finally, one of Welcher's opinions, quote, no structural damage or failure of the cervical discs occurs, is based on cadaver testing, which is an unreliable method for analyzing how force affects live human beings. Well, look at that. Look at that. Just what we were wondering about yesterday. Is it fair to use cadavers to analyze how living human bodies are going to respond to different stresses? Maybe it is in some circumstances, maybe it's not. The one thing I really don't like about this opinion is that claim, it's unsighted. That last conclusion, the one that really interests me, they say it's unreliable, but it's unsighted. How do you know it's unreliable? What's your basis for saying it's unreliable? So many of these other conclusions that they reach, they've been evaluated in other cases. So they got case law we can just point to. Hey, this has been found to be unreliable. Or at least we have, if we didn't cite it, we at least attributed it to the Society of Automotive Engineers. Okay, I don't know where they said that, but given this information, I might be able to take that and go hunt it down and find what the source is. And then I can evaluate that. Is it unreliable? Why do they say it's unreliable? What basis, etc. So I don't like that they don't give me any information about the cadaver testing. It kind of makes me wonder, so many so many judges, they have clerks, that research and write their orders for them. And it's probably less common in state court than it is in federal court. Federal court, it's kind of just part of the culture, part of the institution that you have law clerks that work for the judges. State court, it's probably less common, but not unheard of. And looks like we're getting going. And so it did just kind of make me wonder if the sound. Hello.
And, all right, Mr. Alessi, I will hear you on your argument on the voir dire.
Right to argument.
Thank you, Your Honor. I'm just loading up my computer.
So it made me wonder if this judge has a clerk who has like a scientific background, went and got a BS in, biochemistry or something
Your
like
Honor,
that, and is particularly
I'm going to
offended.
address the Trooper Paul aspect, and then I'm going to address the Dr. Scorty Bello aspect of Dr. Welcher. With regard to Trooper Paul, I would like to draw the court's attention to the following documents for the straightforward proposition that Dr. Welcher has not only reviewed, he has not only considered, that he has adopted. I went back and looked at the documents, and the basis for this is as follows. Slides 22 and 23 do not just depict Trooper Joseph Paul himself. They show Trooper Paul conducting the CARS analysis on February 1st of 2022. Importantly, these slides highlight the mileage odometer of 12,665, and I respectfully request the court to anchor into that odometer reading, because I'm going to show the path that odometer reading takes through all of the documents, but I want to emphasize the genesis of the odometer reading of 12,665 miles is with Trooper Paul as he conducted the CARS analysis on February 1st. Now, here's where Dr. Welcher comes in. Dr. Welcher then uses this key data point, odometer 12,665, as the basis, the starting point for his determination of the locations and times for the events of January 29 of 2022.
Yes, he did.
Dr. Welcher uses his scenario analysis of Ms. Reed's travels, and that's detailed on slides 24, 25, 26, 27, and 28 to calculate and then deduct 36 miles from the odometer according to Trooper Paul on February 1st of 2022 to arrive at an odometer reading of 12,629, which obviously is different from the anchor I talked about of 12,665. So the assumed odometer of 12,629, again, is based on Trooper Paul's CARS analysis in slides 22 and 23, are then used as a tether, a connection to the events recorded by the VCH and the Lexus on the following slides: 28, 29, 30, 31, 32, 33, 35, and 36. I elucidate this and I explicate the slide numbers to show how many there are in Dr. Welcher's report that are rooted in the anchor point and then the change in the deduction of the odometer. So the events memorialized by Trooper Paul on February 1st, including the odometer reading, provide the foundation for Dr. Welcher's entire analysis of the VCH events. The entire analysis of Dr. Welcher's VCH events. That is the adoption aspect of what I started with. Two more points. In addition, Dr. Welcher testified on his voir dire that the image on the left of slide 36 from his January 30th, 2025 presentation came from a file marked carsj.pol. Now, he did contend that it wasn't the exact same image, but I want to go to this. In fact, the image on slide 36 is from the drone used by Trooper Paul, and the citation for that is page 4, item 11 of the CARS report. That's where the drones are from. Dr. Welcher didn't do any drone activity. He took the drone that he had in his report that was just a little bit different than the one I was showing him. It comes from page 4, item 11 of the CARS report. And I quote, "The crash scene was documented during the on-scene investigation by utilizing Alicia's GNSS GPS mapping system and a DJI Mavic 2 UAS. This data was input to a computer-aided diagram program, which is IMS 360. Here's the key: to produce a scale diagram of this collision. So the DJI Mavic is the CARS team drone. This image of Dr. Welcher's slide 36 is clearly and indisputably from the drone. And the only drone extant is the drone of Trooper Paul and the CARS team. Last point with regard to the Trooper Paul basis in adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow in the dark around 6 p.m. on January 29, 2022. Lieutenant O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone. And I again refer to slides 22 and slides 23, where Dr. Welcher said it was more likely than not that it was Trooper Paul in those slides, but whether Trooper Paul or not is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul. Unless your Honor has any questions, I would now move on to Dr. Scorti-Bello. Thank you.
It's a good argument, and it does seem to tell us her problem is she doesn't think Trooper Paul looked closely enough, or that Dr. Welcher looked closely enough.
Dr. Scorti-Bello will be much
We asked about it.
Mr. Woke, do we have the slide of the Dr. Scorti-Bello it's at the end of the slide presentation with her name on it?
The TV's off,
Oh.
but I have
If you just give the slide number, please.
131.
So it is slide 131. I almost know it verbatim, Your Honor, so I will continue. If Ms. Gilman has slide or someone could turn it on. Okay, thank you. Thank you, Your Honor. So with regard to slide 31, at the very top, and this again is a slide presentation of Dr. Welcher. So up at the very top, and so Dr. Welcher admitted that he not only reviewed the autopsy report, he admitted that he not only considered the autopsy report, he admitted that he adopted it, and I'm going to put adopt in quotes, to the extent that he used it in his slide presentation, and he actually, to show the depth of those three verbs, he's got in orange highlight under final diagnosis, multiple skull fractures, base of skull, and cavallarium. He testified, obviously, about the rear wounds of Mr. O'Keefe. He testified about how he believed those wounds came about, and he cited as corroboration the highlight of multiple skull fractures, base of skull, and cavallarium. It couldn't be any more obvious, his rooting in this document and reliance upon it. Why else would he have it in his slide presentation? And he's got the name of Dr. Scorti-Bello. And frankly, Your Honor, he didn't fight that whatsoever in the questioning of him. Then you go to underneath cause of death, blood, impact, injuries of head, and hypothermia. He essentially repeated that on his testimony. And then if we could, Mr. Wilk, just go to the right. And so you've got highlighted head, skull fracture radiating from the right occipital skull and into the right parietal bone, right and left occipital foci, and bilateral anterior foci and orbital plates. Again, the highlighted means something. He's adopting it. And lastly, the depiction of the skull here, I believe that's Dr. Welcher's handwriting. I believe that's his green, the LR, because I've never seen this green highlighting before. And it could also be Dr. Scorty Bellows. That's another possibility. I'm not sure. But let's assume sort of the most conservative part that it's Dr. Scorty Bellows. The key part is he's got it in there and he is referencing it. So, Your Honor, the last point really for both of them, and I wanted to save this point because it applies to both. With regard to experts, the law is clear. So I think the easiest part to show what our position here is the adoption. But it's clearly shown. Adoption doesn't mean you have to agree with it. You just have to put your expert hands around it, wrestle with it, deal with it. And there is no rule of law that I'm aware of that says you can't question an expert witness unless it's something that the expert witness agrees with. If the expert witness has reviewed it and considered it, and especially if they've rejected it. The easiest is obviously reviewed, considered, and adopted, but it's certainly permissible and important to a defendant's constitutional right, Sixth Amendment to cross-examination. If an expert says, or even infers, I reject this, I reject what Trooper Paul did, or I reject what Dr. Scorty Bello did, that is decision-making of an expert that the attorney has a right to be able to test. Why did you reject it? What was your thought process in rejecting it? And that applies to both Trooper Paul and Dr. Scorty Bello, because as I understand it, this witness, Dr. Welcher, is not, he says, I'm not relying upon Trooper Paul, which is completely false based upon what I just showed. But even if he just rejects it, in addition to what he has done, we have the right to test and get answers as to why he did it. And the same with Dr. Scorty Bello. Once he goes to this level, Your Honor, I believe it's a straightforward right, especially of a defendant in a criminal trial, and especially of the stakes and the charges this high, that we get to test it. What I think, lastly, my point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Scorty Bello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162.2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc. And with regard to Dr. Scorty Bello, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scorti Bello's autopsy report, cherry pick things to benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd. And it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request
it's absurd
that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial, cross-examination, and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
He's right. You don't get to just limit what you get to be crossed about by being like, no, I didn't agree with that. You get to ask them about why you didn't agree with that. You agreed with this part, but not that part.
By the defense is that there is no constitutional right to usurp the rules of evidence. There is no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right. There is no case law to support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer. And it is clear, and the court knows what they're trying to do. They're trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness. They have asked Dr. Scorti Bello what her opinion is. And although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful.
No, they get to ask the expert about it.
Uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion that's already in evidence to try to phantom cross-examine an expert. Dr. Welcher is clear. He did not rely on Dr. Scorti Bello's conclusion that this cause of death was undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified for that.
It's not what he said.
This is a simple
That
game.
kind of
Let's
person.
pit one witness against the other and suggest that the Commonwealth's witnesses are inconsistent. They take it a step further. They want to relive what they think is their past success last year in this case without actually calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welch these questions, which he did not rely on. We had a voir dire. He was clear. He did not rely on the analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Scorti Bello. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor, it's not a tether, it's not an adoption, it's no such thing. In fact, if you look at that photograph, it was taken by Zach Clark. So by the rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach Clark's opinions, efforts, what Zach Clark did. It is a photograph that he considered,
This guy's
not an
obnoxious.
opinion, not
Of course
an
it
analysis.
doesn't open
It
that
has
door.
nothing whatsoever to do with Dr. Welcher's analysis
could
or
ask about
opinions.
the
In
photograph.
fact, the evidence is to the
Indeed,
contrary.
they could.
He came out, conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what was part of his opinion and what was not. And this information was not part of his opinion. They turned to the Google map. Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at Dr. Welcher's PowerPoint, It's different. Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the car report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt, anchor, tether, use as any basis.
Well, he
in
did.
fact,
His
is
was
different
36.1.
and separate, as
I don't know
all
what
his
report you're looking
analysis
at.
is.
The
And so,
slideshow we saw.
the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case. Dr. Welcher did not rely on Trooper Paul's analysis or reports, and he did not rely on the conclusion of Dr. Scortibello of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher is not the right witness for it. These opinions to try to do a credibility value is a
They can
core
try.
preclusion in criminal law, a core preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking, did the police officer lie when he said the light was red?
It's not.
the absolute same analysis. It just has a lot of icing on it.
There's actually a case law.
Very
But I
briefly,
just
bring the
looked
jury,
at-
start getting the jury ready, please.
Where, yes, in fact, they
Your
can
Honor,
just adopt.
with regard to Trooper Paul,
an
Mr.
expert's
Brennan did
opinion,
not
another
address
expert's
80% of the slides that I addressed that showed the basis. When he talked about the picture, making it seem like the picture is the only thing we're relying upon, there's clearly other items, but even the picture, Your Honor, the purpose of the picture is it's got the odometer reading. That's why they took the picture, and that's the tether. So the photo is completely relevant. It's not who's in it, it's the fact that that's the odometer reading they're using. Next point with regard to case law, Mr. Brennan presents none to go against the common sense law that has been there for years. The other thing, Your Honor, is with regard to Mr. Brennan keeps trying to put my arguments into a credibility, like we're trying to attack the credibility of Trooper Paul. He says that we're trying to redo last trial. To the contrary, Your Honor, it's the Commonwealth that brought Trooper Paul into the second trial through Dr. Welcher and Dr. Welcher's reliance on all the work of Trooper Paul. They've brought it in here, and because of that, we get the right to cross-examine it. Last point. This is not about credibility. He keeps saying something that's not happening, that we're going to attack the credibility of Trooper Paul. What we want to do is to say to Dr. Welcher, you have brought up Trooper Paul. You have used his odometer reading. That odometer reading tethers through to Google. It tethers through everything you're doing. It's the foundation. But what you're ignoring, Dr. Welcher, are all the key cycle results that come from that odometer reading that you relied upon. Dr. Welcher himself can't cherry pick, grab things that he needs from Trooper Paul to do his analysis, and then the Commonwealth say, but you can't go after that because it somehow has Trooper Paul's name on it. It's illogical, Your Honor, and it's incorrect under the law. Thank you.
So I disagree with you, Mr. Alessi. I'm
We
not
know.
allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scortibello. So that's my ruling. Let's bring the jury in.
Your Honor, there's one very big issue to be addressed.
Well, come over here because they're on their way.
Yep, we knew that was coming. We knew that was coming. So get this, guys, okay? In Bev's courtroom, the rule is if you don't want to be cross-examined about something, all you have to do is say, I don't agree with it. That's it. That's it. And you don't get to be asked any questions about why you don't agree with it. Nothing. Nothing. You get to just completely take that off the table. You get a 500-page expert report, and all you have to do is testify. I only read these 2 pages. It happens to be the only 2 pages that benefit my argument. Okay, everything else is contrary to what I want to say, and therefore I cannot be asked any questions about what I thought about that expert opinion, because all I have to do is say I didn't look at it. I didn't agree with it. It didn't matter to me. So to me, yes, it's quite crystal clear that Alessi has the better side of this argument. Of course, as a matter of common sense, you get to question the expert about the basis for his opinions, what he reviewed, what he considered, what he didn't. If he says he doesn't think it's important, we get to ask about why it's not important. You get to do that. So this seems like a pretty unwarranted restriction on cross-examination to me, but just add that to the list of issues that don't seem to concern Judge Cannoni whatsoever when it comes to the fairness of the trial process. As it so happened, I just was doing a little Googling while I was listening to that argument. And I found this case. Now, of course, I can't find it again, but found this case that I just read through real quickly. And in fact, what it says is actually, yes, one expert can simply wholesale adopt the opinion of another expert. It's hearsay coming from that other person, but they can just go ahead and basically be a mouthpiece for it. And why did they reach that ruling? Well, because it came up in a context where cops wanted to do that. See, and so when cops want to do something, the law tends to find a way to bend over backwards to make that permissible and okay. The case, I can't find it. I can't find the name of it, but it had to do with whether this particular piece of paper that was found in the defendant's possession was like evidence of a gambling type of undertaking. And the original expert who was going to testify to that, the gambling expert, wasn't able to testify in the trial. So instead, they just brought in a person to adopt it and be the mouthpiece. And the court said, yeah, no problem. No problem. So as a matter of fact, you actually can do that in Massachusetts.
Justice of the Norfolk Superior Court before the county of Norfolk. Draw near, give your attendance, and
but I guess according to Bev, you'd only be able to cross that guy, if he agreed with it and all the basis for why he adopted it off the table.
We were doing work in here, but we appreciate your patience. So I do have to ask you those 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Everyone said no or should be. Thank you. Could we have Dr. Welcher back in, please? And Mr. Alessi, feel free to go to the podium.
You trying to equip with the computer and any electronics there so we don't have to address it?
It doesn't look like it's turned on.
Oh, okay, good.
And smartwatches.
Oh, it's not turned on. It should be gone.
Yeah. This one.
Sir, I'll remind you, you're still under.
Well, here comes our accident reconstruction troll. He's going to troll us some more today. Let's see what he's got.
And Dr. Welch, we're going to ask you to not turn on your computer yet.
Yet, if ever.
Your Honor, if I could, smartwatches that are receiving text messages during his direct, if we can make sure that that does not occur.
I get my email.
Okay, or just don't look at your watch.
Oh, just
Okay.
don't look at your watch. Yeah, because you're really policing him over there,
Dr.
Bev.
Welcher.
Good morning.
Do you know whether there was glass found on the bumper of Miss Reed's Lexus SUV?
My understanding there was, yes.
Did you reach a conclusion on whether the glass on the bumper came from the drinking glass that you assert Mr. O'Keefe was holding at the time of the alleged impact?
I didn't have an opportunity to inspect the glass, but the glass was broken and there was glass on the bumper. That's all I know.
So you, as you sit here today, you have no basis to conclude that the glass on the bumper came from the glass that you depict as having been held by Mr. O'Keefe at the time of the alleged impact. Is that correct?
Well, you're mixing a couple things.
No, Dr. Welcher,
So can
if you can just answer my question.
I'm
If
trying
I
to.
need to rephrase it, I will. I'll ask it a different way.
Please.
You have no basis as you sit here today to conclude that the glass on the bumper came from a drinking glass connected to Mr. O'Keefe, do you?
Well, we have a picture of a broken glass at the scene. So I wouldn't say we have no basis. We don't necessarily have enough to conclude it's from it, though.
Do you had depictions in your test with Mr. O'Keefe holding a glass, correct?
Correct.
My question is, you have no evidence to show at all other than, and I'm talking evidence, testing information. You're saying you have no evidence that shows that the glass on the bumper is not the same glass as you showed on your slides as being found supposedly at the scene. You have no test evidence that that's the same glass, do you?
So again, the one I have at my testing obviously was not the same glass. We have pictures of a broken bar glass in the snow near where Mr. O'Keefe's body was. And we have glass fragments on the rear of the bumper. That's the extent of my knowledge on the correlation between those two.
So do you said you reviewed the reports and testimonies of various Commonwealth representatives, correct? That's in your report.
Correct, in the initial.
In the initial, right, correct. And some of those reports included forensic scientists who work for the Massachusetts State Police, correct?
I believe that's correct.
And you put those in your report as documents that you reviewed, correct?
Correct.
And as you sit here today, it's your testimony, you don't know whether in any of the reports of the Massachusetts State Police, there is an answer to the question of whether there's any connection at all between the glass found in the snow and the glass on the bumper.
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the taillight fragments back together, they were able to deduce that the fragments were from the taillight. I don't think they attempted to do that with the glass.
Assume that there has been testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay.
Assume that.
Okay.
How would that affect your analysis?
I'd want to know where the glass came from.
Uh-huh.
But we still have
We
a whole bunch
all.
of other elements. So I don't think it would affect the end results.
So would it have any part in your analysis with my assumption that the glass on the bumper is not the glass that's associated with the broken glass that was supposedly found in the snow?
Yes, I mean, we always want to have as much answers or as many answers as possible. So I would want to know if we could figure out where it came from.
And wouldn't the fact, assuming that the test results show there's no connection, meaning the glass on the bumper is different from the glass in the snow, wouldn't that be contrary to your theory of what happened in some way?
It depends on when the glass was actually broken. The glass was in his hand, at least that's the testimonial evidence I have seen. So it depends on whether it's broken from contact with the rear of the vehicle or broken with contact on the ground.
Assume that the glass on the bumper is not the glass that was found in the snowbank. Doesn't that at least in part,
Yes, it does.
contradict your hypothesis
It's
as
unexplained.
to whether there was contact by the Lexus with Mr. O'Keefe at 34 Fairview.
So if you recall all my slides, nowhere did we discuss that in my slides. So no, it wouldn't contradict it. I would want to know where that glass came from.
But you didn't seek that information, did you, sir, in your analysis to determine where the glass came from?
Well, of course I did. I read the reports about it.
But
And
you
it was
sit here and you say
indeterminate,
you
you
don't
said.
know the answer. There's steps you could have taken to get that answer quite easily. Couldn't you have, sir?
Not me. That's a material science expert.
You've been communicating with Lieutenant Tully, haven't you?
Correct.
You couldn't have asked Lieutenant Tully that question?
To my knowledge, he's not a material science expert.
But could he have told you the result of testing on that glass on the bumper and whether it was any way associated with the glass found in the snow? Wouldn't that have been an easy question to ask him? Just has there been testing, and if so, what's the results?
Yes, but my knowledge from reading the reports was it was inconclusive.
But you didn't read all of the reports, did you, sir?
Apparently not.
Let's turn to another topic.
Imagine saying that like
Laser
that's a
scans.
win.
Part of your analysis involved conducting laser scans of portions of 1 Meadows Avenue, the house of Mr. O'Keefe, correct?
Correct.
Those laser scans were used, at least in part, to answer the question of whether the collision between Ms. Reed's SUV and Mr. O'Keefe's Chevy Traverse at 1 Meadows at approximately 5:07 a.m. on January 29, 2022, caused the right rear taillight of the Lexus to break, correct?
Correct.
And in that analysis, inches literally matter, correct?
You want to get it as accurate as possible.
And the reason why inches matter is because, and we're going to get to this, you try, and you did it in your slide presentation on Direct, you tried to see whether the Lexus lined up with the Traverse such that there could be a break of the taillight. That was part of your analysis, correct?
So the main part of the photogrammetry was to determine the speeds and the angles and the degree of overlap on the vehicles. And then we also looked at the damage from the video, or actually it's just where the snow was knocked off the rear of the Chevy Traverse, and document the height of that.
You said the main part. I don't want to engage in semantics. I want to go to my question of, isn't part of the laser scan analysis to determine whether or not those two vehicles align sufficiently such that the Lexus could break, the taillight of the Lexus could break coming into contact with the Chevy Traverse? Wasn't that part of your analysis, at least in part?
Yes.
Okay. And in that analysis, inches literally matter, correct?
It can, depending on which way you're going inches.
It just mattered to
the
your
ring
mom, dude.
camera at 1 Meadows, you're familiar with that ring camera, right? At
Correct.
1 Meadows? That ring camera at 1 Meadows was used as part of the laser scan process that you and your firm Aperture performed at 1 Meadows on October 2nd, 2024. Do I have the date correct?
I believe so, but like the videos were not literally used during the laser scans. We took the laser scans, the video, combined them together in a process called photogrammetry.
Okay, let's get this down to the fundamentals. You used, and that was my question, Your Honor, if we could publish the exhibit with regard to the ring camera.
Sure, what exhibit is it?
Yeah, I've got my, yeah.
Are we getting into the angle, the fact that the camera angle moved?
Dr. Welcher, you recognize
Not the inches that matter?
that ring camera as being at 1 Meadows. You discussed it, as a matter of fact, on your direct testimony, correct?
Yes.
Now, that ring camera was utilized as part of your laser scan process, correct? It was used.
So you're confusing laser scan and photogrammetry. The video, the laser scanners are together used in the photogrammetry. The camera and the laser scans are not used necessarily with each other.
Good to clear up the semantics.
Was that ring camera used for any part of your work?
Absolutely, the photogrammetry.
I just need to be able to finish my question, sir. Was that
Sorry.
ring camera used for any part of your work at One Meadows on October 2nd, 2024?
Yes,
And it was used for what purpose?
in the photogrammetric process to establish the position and dimensions of various things in the video. So then we could go back and overlay the vehicles and track the tracks in the snow, as well as look at the damage to the vehicles.
Right. So this was
Right.
used to, as a basis, not the only one, to establish dimensions of the other work that was done in analysis at One Meadows, correct?
Correct.
You can take that down, Mr. Wolk. You know that the ring camera at One Meadows, in existence when Aperture did the work on October 2nd, 2024, was different than the ring camera that was in existence on January 29th of 2022, the date where you went through to see if those two vehicles align. Is that correct? The cameras are different.
That is correct.
And you know that the cameras are different, and you knew that as part of your analysis, correct?
Correct.
Did you document the differences between the two cameras as part of any work performed at One Meadows?
Yes.
And did you measure any differences there might have been between the location of the new ring camera from the older one that was in existence on January 29th of 2022?
No, what we did is use the current ring camera in conjunction with the old ring camera, and with the laser scans, we're able to, again, map the points onto the scene. That's why I showed you the report from the photogrammetry software that reported our error.
Sir, my question was just measurement, not your process.
Oh.
Did you measure the difference
I don't believe so.
between where the old camera was and where
Listen
the
to
new
the
camera
question.
was?
No, it was angled slightly more to the right, though.
How would you know that if you were not retained on January 29th of 2022? How would you know where the original angles were?
Because when you look at the first camera, the one on January 22nd, it's here. The new one is slightly over to the right.
That's an eyeball approximation analysis. That's not a measurement, correct?
Well, I don't know that we actually measured it, but we accounted for it and corrected for it. But you
How
can
did you
see, for
correct
example,
for it if you
what
didn't measure it?
the original one shows, for example, to the left-hand side compared to what the new one shows to the left-hand side, and it's angled more to the right.
Sir, you have experience with ring cameras, correct?
I do.
And I think a lot of members of the public have experience with ring cameras. You can move just the camera portion ever so slightly and change significantly the angle of the camera, can't you, what it captures? Just a small turn,
Potentially.
right? Even a millimeter turn can make a change. A 2 millimeter, a 1 inch can make a significant change with regard to what the camera captures, correct?
Could, sure.
So, did you measure whether the newer camera that was present on October 2nd, 2024 was installed to the left? And I'm talking measure to the right, to the top or the bottom relative to the camera that was there on January 29th of 2022?
So we solved for the camera
I'm
position.
asking if you measured, sir.
Oh, no, we didn't measure.
So let's talk about some other differences with regard to cameras and ring cameras. Different ring cameras can have different levels of distortion, correct?
Potentially.
Cameras, well, are you saying that all ring cameras have the same level of distortion?
No, but again, they're mass produced, so you could have some that have the same exact distortion. You could have some that have different.
And you don't know the comparative distortion between what I'm just going to now refer to as the old ring camera that was there January 29, 2022, and the camera that you saw on October 2024, which I'll refer to the new camera. You don't know the difference in the distortion between those cameras as you sit here today, do you?
So we know enough information that if the distortions had been different, our errors would have been too high. And so the fact that our errors are within acceptable, or what's called an RMS error, we know that the distortions are similar enough to give us accurate measurements.
Sir, that is speculation. That
It's
is
not.
not data. That is not a measurement. You didn't measure the distortion, sir, did you? If the cameras, you didn't have the old camera to do it.
We didn't, but we had images from the old camera. And then when we get images from the new camera and solve those camera properties and then overlay data from the old images to the new images
So you
with
just
the point clouds.
tweak the
if
camera
that
to make it fit.
distortion is
Guys,
too great.
how do you not get?
We will have too high of
Just
errors in our project, which is why I
Solve
showed
it.
the error report from the photogrammetry process to show that we have checked for that and documented that our errors are an acceptable range so that we have confidence in our results.
You do not have information from the manufacturer of ring. You didn't present it and you don't have it as to what is the acceptable level of distortion for the analysis that you did, do you, sir?
The
You have
photogrammetry,
that from ring.
I don't have it for Ring, but I don't
Thank
need
you.
it from Ring.
So now let's go to, if cameras have different levels of distortion, that would change the analysis in reconciling the difference between their angles. That's a pretty straightforward proposition, sir, wouldn't it?
So it depends on how much difference it is, but we have accounted for that.
With which model of the ring camera was present at One Meadows on January 29, 2022? Which model?
I don't know. I'd have to go look through the data.
Do you believe I'm not going to take up the time to have you look, but do you really believe you've got the model of the ring camera that was in existence on January 29th of 2022?
I don't know. I
You
need to
didn't
look through the
present it
report.
in your direct testimony, did you, sir?
I did not.
So do you have the model of the ring camera that was present at One Meadows on October 2nd, 2024?
No.
So you don't have even the model for either one of them.
Nope. But we have videos from both of them and scans of the scene.
So now let's talk about another aspect of ring cameras. They have mechanisms, as I was talking about earlier, that allow the user to adjust the camera angle, correct?
Correct.
And do you know whether there was a difference in the camera angle between the two cameras?
Yes, as we already discussed, there was a slight difference in the
But
angles.
you don't have a measurement of that, right, sir?
Correct.
Okay.
But we accounted for it.
So wouldn't a difference in models of ring cameras be relevant at all to your analysis of trying to reconcile any differences between them?
So if you have the video from both of them and you have laser scans with three-dimensional geometry of the scene, you can go in and it's called a reverse camera analysis and solve for the distortion properties. The scans give you the real world dimensions. So once you know the real world dimensions, you can then go in, and then solve for the camera lens properties based upon the real world distortions. So for example, if there's a little bit of bending at the end, the laser scan data will show that, and you can correct for that knowing information about the laser scanner.
I'll
Or
ask
the later
question.
scan data.
I'm sorry, I thought you finished, sir. I'm going to ask the question again because it's a narrow question. Wouldn't knowing the difference in the models be relevant? That's all I'm asking. Wouldn't it be relevant to your analysis of reconciling the differences to them? Wouldn't
No.
it be relevant?
No,
So you think the different models are irrelevant to any process you occasioned at one? It's irrelevant.
so the analysis of the video itself is more important than the models?
I'm not asking if it's more important. I'm just asking, would it be relevant?
No, I don't believe it'd be relevant.
Now let's go to another aspect of the cameras. Are key parameters in a camera that the software needs to know focal length?
It is?
Is imaging size something that is an important parameter in a camera?
Yes,
Are sampling characteristics an important parameter in cameras?
can be.
Is it the principal point? You understand that concept, sir? Is that an important parameter in a camera?
Define how you're using principal point.
Sure. A principal point of an image is the point where a camera's direct line of sight, called, as you may know, the optical axis, intersects the image plane. Does that
Gotcha,
sound
yes.
familiar?
Mm-hmm.
So isn't that the image's mathematical center, the principal point?
More or less, yes.
And for high accuracy photogrammetric work, it's important to know if the lens is mounted centered over the image sensor due to the small manufacturing variances, correct?
Could be important.
And if the principal point is the center of the image. That's relevant. So doesn't that affect the mathematical calculation of the light ray geometry?
It could.
So the variance in manufacturing between cameras is a known issue. Do you agree?
I do.
There's small manufacturing variances that affect one of the key components of the fundamental parameters of the camera, namely the principal point, right?
Correct.
Did you perform the camera calibration of the camera in place in October of 2024?
Yes. So within photogrammetry, we calibrated the photogrammetric analysis to the camera.
Did you address the principal point in that calibration? Do you have documentation that you addressed that important factor, the principal point?
So the checking of the RMS
He's gotta
error
play with his ear
in
when he
the
doesn't have his
software
safety blanket.
takes into account, sums up all the potential errors in the measurements, which would include that.
Okay. Sir, you know the importance of all of these topics because the output of all the work Aperture did at One Meadows, almost all of it springs from that camera, correct?
It starts there.
Okay, it starts there.
Versus
and if the
springs
starting
there.
point is wrong, then where you go from the starting point is going to be at least potentially wrong, correct?
Potentially.
Would you agree that Ring cameras have a swiveling mechanism so that the user can adjust the camera angle?
Some do.
Do you know whether the camera that was in existence on January 29, 2022 had a swiveling mechanism?
I believe it did.
Believe, do you know?
I do not know for a fact, but
you-
those style of Ring cameras on the surveillance have adjustability that includes angle.
But you don't know whether the camera that was there, the specific camera on January 29, 2022, had a swiveling mechanism or not, correct?
Correct.
And do you know whether the camera that you saw in October of 2024 had a swiveling mechanism on it?
It did.
And where did you document the fact that it had a swiveling mechanism?
I think we have photos of the camera.
Did you document it in writing, and did you document the tolerance of the swiveling mechanism?
No.
Let's go to, and again, all of the camera, this camera that you used is the starting point for your laser scan and photogrammetry process, correct?
Correct.
All right. Let's go to another topic. On your direct testimony, as I recall, you stated essentially from various information that you lined up in the video, and we're talking about the lining up of the Lexus with the Traverse. And this is at One Meadows. And so, as I understand what you did, sir, is you took what are called point clouds, 3D images, created them for the Lexus. You took created 3D images, synonym point clouds of the Traverse, and then you attempted to line them up to determine, among other things, whether they would align sufficient so that the Lexus could line up and potentially hit the Traverse such that the tail light of the Lexus could be broken. Was that at least part of your analysis?
That was part. There was more.
So
So,
you showed a few slides, and with your honor's permission, what I'd like to do is to start with slide 90.
All right, do you have any problem with Dr. Welcher keeping his printed copy that he was using?
I have no problem with the printed copy, your honor.
So, I'm sorry, what slide again?
90.
Your Honor, my printed copy is tiny.
Okay.
Can I
Can
pull
you
it?
see the,
Yes, yeah.
just look at the screen.
Does that slide that's part of your presentation depict a view from the top of the Lexus on the right and the Chevy Traverse on the left?
Correct.
And is that depicting contact between the two vehicles?
It is.
Now let's zero in a closer look, and that is a contact point, am I correct?
Correct. I mean, there's multiple points. There's more than
Multiple
one.
points, but it shows more clearly the contact
Correct.
between the two vehicles. Now, if we could the next, and that is number 91, Mr. Wolf. So Your Honor, 91. I think these are just going to go in order for a few, and I'll keep announcing them. So this is 91, same vehicles, just a different viewpoint. Is that correct, Dr. Welcher?
Correct. This and the next
I
slide.
just want to stay
I know.
with this one. I just
Hold on a
asked the
second.
question, does it show the contact?
right, so go ahead and answer now.
This slide and all the other slides, we're trying to show the angle of contact, but because it's two-dimensional image, you're losing some perspective. For example, here you're seeing the chrome piece on Mr. O'Keefe's Chevrolet, which is on the right. You're seeing it obviously behind where the Lexus is. So we were trying to show it at a whole bunch of different angles to try and illustrate the degree of closeness or lack thereof.
All right. So
Thank you.
is it correct that on your direct examination, you said in sum and substance, we looked at the degree of overlap, and there's only about a 2 to 3 millimeters of overlap between the vehicles? Is that what you recall saying on direct?
That is correct.
And that you stated that supposed 2 to 3 millimeters of overlap was insufficient to cause the tail light of the Lexus to contact the rear of the Chevrolet. Do you recall saying that?
That's correct.
Now, I would like you to look at that. This is from your slide presentation. Is that not showing contact between the two vehicles?
Oh, it absolutely is not. What you're seeing is a portion of the vehicle that is behind the area. Keep in mind the angle, the Lexus is angled off to the left. So the area that you see here is actually, in this case, in front of where the taillight is. This is why we tried showing it from a whole bunch of different angles, because when you try and take a two-dimensional image and look at it, you see stuff in the background. So and again, this is why in the computer, we overlaid them, looked at the measurements, in the computer where you don't have this, we have the three-dimensional measurements, and it does not hit.
Where did you show in your slide presentation what you just said that it doesn't show in overlap?
So
Where?
it shows a contact. It definitely contacted, I'm sorry, Mr. Reporter, down below here. It does not show a contact here. So to answer your question, all the next slides were our attempt to do that. So all the next slides is your answer.
We're going to go to those next slides. So just to be clear, you're saying that that depiction does not show any contact between the taillight of the Lexus and the Chevy Traverse.
So the upper taillight, just to be clear, because the lower taillight is much closer.
Well, it's not only much closer, it's in contact, isn't it, sir?
It's very close. It's probably within an inch being in contact.
Oh, so you state that even the lower part of the taillight is not making contact?
So again, maybe there's a photo we could show or a scan. That is on the rear of the vehicle, and it contacts on the corner, which is just around, so maybe like an inch or so in front of it on the corner.
I'm just going with what you presented in your slide.
What does
Let's
that
go to the
even
next
mean?
slides, and then
Sir,
maybe
I
see.
will determine which slides we go to on my questioning.
I'm just hoping
So
to
now
answer your
let's
question.
go to Mr. Wolf, the next slide
Alessi's had it.
in your presentation. My question is zeroing in. Are you saying that that slide does not show contact between the tail light of Ms. Reed's Lexus and any part of the Chevy Traverse?
Yeah, absolutely. It's exactly what it shows. You can see a little better here. Again, we tried all these different angles, which is why all these slides are in there. But you can see some of the geometry of the light. This structure, and again, remember I said the Chevy kind of curves in as it goes up a little bit.
Let's go to the next slide. 40. 40, yes, please. Is it working? 41, Your Honor.
Right, thank you.
Yeah, her sail light does stick
That's
out
exhibit 41?
quite a bit there from the back,
No, I have a question because it's not
like
my
a
slide.
protruding tail light.
So, Mr. Alessi, is this exhibit number 41 or is this from the PowerPoint? Because,
Slide 41. Slide.
okay.
Yes.
So I'm putting this up because I want to show an actual photograph of that tail light, and I would like you, sir, to focus on the quarter panel tail light in each. Do you see a jutting out of the quarter panel tail light in that photo? Do you see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct. Now, what I'd like to do is to go back
Little fins.
to the depiction we were just looking at. And that depiction doesn't show the jutting out, does it?
No, it does. Those are actually more on the side of the vehicle. You can't see them in this image.
Correct. You
But-
can't see that.
Hold on a second. I wasn't finished. But
Sir.
they are 100% there. We actually did special hand scans with a hand scanner of the taillight to put it back on to the vehicle.
You say they're 100% there, but you can't see it in that depiction, can you? The jutting out that you could see in the two-dimensional one we just saw. You can't see it.
I can't see who's behind that wall because it's being blocked by something. I can't see on the side of that taillight because it's on the side I can't see. It's being blocked.
Sir, My question is simple. You cannot see the jutting out of the tail light in this depiction, can you?
Correct.
Okay, now let's go on to the next question in this topic. You could have easily solved what you consider to be the issues you had with trying to show it lining up, couldn't you, sir? You had an easy solution for that.
I took the best solution. I'm not sure what you're
You had
referring to.
3D images, correct?
I did.
You could have shown and measured 3D images to get almost the exact contact point and almost the exact dimensions if you had just used the 3D images that you had available to you. Isn't that correct?
That's exactly what we did. When I went through the video analysis, I showed you how we overlaid the point clouds, the 3D scans on top of each vehicle. So we took the, we took
Sir,
the vehicles.
please don't interrupt.
Hold on.
Your Honor, he keeps referencing my hand and saying I'm doing something when I'm not. And I think that's distracting to the jury. I'm not interrupting him.
Hold on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps saying that I'm doing
Mr.
something.
Alessi, please.
All right.
Go ahead, finish the answer, Dr. Welcher.
Again, in the photogrammetric analysis, I showed the video. I showed how we overlaid the point cloud on top of the video. That proves that the way we solved it, correct camera characteristics, matches. Otherwise, that would be distorted. We overlaid the scans of the Lexus into the photogrammetric analysis. We overlaid the scans of the scene into the photogrammetric analysis. We overlaid all that stuff into the analysis. We did exactly what you're suggesting.
You could have easily addressed this issue by the following. If you really believe there was no contact or not sufficient contact, you could have produced a graphic that shows a gap between the two vehicles. A graphic, couldn't you? That's not a graphic.
What is that?
Sir, I get to ask the questions and you are to answer them subject to the judge's ruling. So my question is, couldn't you have created a graphic that would have better shown the issue that you are creating or talking about today? That's my question. Couldn't you have created a graphic?
We did. We created a whole bunch of graphics.
You called what we just saw a graphic?
Yes.
Well, if there's a gap, why isn't there then something that shows a clear gap?
Because when you have the angulation of the vehicles, you have perspective. When you're looking at it, even if you do a top down, you see everything projected onto a single flat plane. So you can't tell the height of things. So when you see things in this dimension, you can't necessarily see depth of things. So you lose in two-dimensional images, you lose one dimension depending on which way you're looking. That's why I showed it from all these different angles to try and show exactly what you're saying. We had graphics to do that.
A 3D graphic?
3D images allow you to show perspectives for 360 degrees, correct? Is that correct?
That is correct.
So none of what you presented in your slideshow shows the contact points from 360 degrees, does it?
I don't understand your question. Are you asking if I showed it at every single, I went through 360 slides?
You could do a
that showed
little
it at
video
every single
graphic.
degree?
Rotate
Sir,
them.
Let's move on. I think I've made the point.
So I'm going to strike the comment,
Okay.
Mr. Alessi.
Dr. Welcher, let's go to the next topic. And keep with these two depictions. Are these two images point clouds or 3D images? Are these two?
Those are one and the same thing. Yes.
I would use them as synonym. Which term of the two do you want to use? Point cloud or 3D images?
Both are fine. It's a 3D image composed of points.
So let's just call them 3D images so we
Okay.
can do this more quickly. The Lexus and the Chevy Traverse that are depicted there are both 3D images of those vehicles, correct?
Correct.
And Aperture created the 3D images, correct?
Correct.
Sir, did you do these scans and did you personally create these images?
No, one of the assistants at Aperture did.
So you're speaking about what somebody else did at Aperture, correct?
They were doing it at my direction. And for example, the Lexus scan, I showed the photographs. You can see the gentleman that works at Aperture, Mike Morelli, was scanning them for me while I was doing the rest of the inspection. And then the hand scanning of the rear tail light was done by another engineer. I was out there with him doing it, taking measurements. And then same thing with the Chevy Traverse.
My question is, you didn't do the creation of these 3D images, did you?
The individual images, no.
All right, so let's go to these individual images. These are 3D images, is that your testimony?
Yes.
Let's look at the taillight.
Okay.
That's not a 3D image, that's a Photoshop, isn't it?
Nope.
Oh, so it's your testimony that that taillight is a 3D image?
That absolutely is a 3D image. The way you can tell is
Nope.
when you get up near the chrome, because lasers don't like shiny objects, you start to get a scatter. So see all these dots here? If that was a photo, you wouldn't have these dots.
Let's go to the Chevy Traverse. Let's, Mr. Woke, zero in on the content, yeah. There's grain on that taillight, in the taillight. That's a 3D image of a taillight, isn't it, sir?
They're both 3D images.
Well, I just want to stay with one. That taillight is a 3D image, and one of the ways you can tell is because it's got all that grainy material on it, correct?
Correct.
Now let's go back, Mr. Woke, to the Lexus. Let's now go to the bumper.
But do you want me to explain the difference?
No,
Okay.
thank you. I would like to go to the bumper.
You're welcome.
Do you see any grainy, the predominance of any grainy image on the bumper?
There's a little bit. So for example, when you get near edges, it has a hard time with edges.
I'm sorry, the bumper cover.
Right.
See the bumper cover up above?
This whole thing is the bumper cover. That's the step pad. That's the rear body panel or the rear deck lid.
I'm talking about the step pad, sir. Just the step pad of the bumper?
Are you asking about just from here to here?
Correct.
What he just said.
The bumper
You
step.
just
we
called
zoom
it
in on it?
step pad.
Pardon me?
Can we zoom in on it?
Sure. Do you see any?
Yeah, I see graininess.
Let's go over to.
Right in here. You can see it all through here. You see it through here.
Well, I'm talking about the step pad, not the entire bumper. I'm just talking about the step pad.
Right. So you're zooming in on the bumper.
Right.
Step pad is this structure up here.
We're going to move up. It just takes a while. So your testimony is that is a,
Can you zoom in more?
that's, you would like it zoomed in?
Yes, sir.
Sure. Your testimony is that that is a 3D image, not a Photoshopped step bumper cover. Is that correct?
So we have mapped the color over the 3D scans. We used two separate scanners. If you recall, when I got out to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the bumper cover, not the taillight.
Okay, I'm explaining the process.
I just asking
I
about
didn't
the
ask
bumper
you
cover,
about
not the
the process.
process.
So focus your answer on the bumper.
That is a laser scan.
Okay, so your
That's a 3D
testimony
model.
is the step part of the bumper cover is a 3D image from a laser scan, and it's not a Photoshop. That's your testimony.
Absolutely.
And you didn't perform the work for the 3D that you claim the bumper step up is. You didn't do that work to produce that depiction, did you, sir? Somebody else in your firm did it.
So this is all done at my direction. The engineers that work for me, so I'm telling them what to do. I'm not the one punching the keys.
That's
I'm
my
saying,
question.
I need you to do this, and this. Use the hand scanner, go scan the light. I need to put this back in
How
because
does
it was
defense
missing
know
when we
this
got
is
to it.
Photoshop?
So no, I'm not punching the keys.
Okay, so
Okay. Come on over, please.
So, Mr. Alessi has just moved on to handling the task at hand, which is getting him nailed down on his position and moving on. We don't have to establish at this point whether his position is right or wrong, because all we're doing now is foreshadowing what the defense is going to be doing, I would anticipate, with their own experts. And so inches matter. Indeed, they do. Just ask your mom. Inches matter. He's foreshadowing that somebody has an analysis of this photogrammetry process, and they're basically saying this is shit or it's unreliable because you can't, you can't. You need to mathematically correct for the differences in the angles and so forth. And all you did was eyeball it, basically. You're like, well, it looks a little bit over this way, so we'll just, move this photo like that. Just kind of like we'll add a few seconds here, add a few seconds on the other side. We'll just kind of move these pictures together until they fit. So I'm getting the foreshadowing that there is going to be more of a defense analysis of this that we'll hear about once we get into their case. The broken bumper glass, we already kind of heard about that. We already knew that was an issue. So all we're getting into is his basis. And what, if any, explanation he has for the glass that was found on the bumper? And he doesn't. He just assumes it came from the glass in John's hand. But it does imply maybe defensive materials analysis.
Back up, Mr. Wolf. Isn't it correct that 3D images allow for proper and most accurate measurements as opposed to 2D images? Is that a correct general statement?
I mean, generally, yeah.
Okay, that's my question. So let's go to the next topic. Let's talk about hydraulics on the Lexus SUV.
Hydraulics. We heard about this. It's got like a built-in air ride.
What type of hydraulic system does the Lexus SUV have?
So it has a mechanism, I believe it's actually pneumatic. It's air-based system that raises it up and down.
Do you know what the name of that system is, sir?
No, not off the top of my head.
Do you know how it works specifically?
I do. Well, I mean, I know generally that there's a button on the interior where you can raise and lower the ride height.
And is that the extent of your knowledge of that system on the Lexus?
No, again, I know when you park it, it'll drop down the ride height. When you adjust it for different roadway conditions, it'll change the ride height.
Do you know what the height tolerances are? In other words, the lowest to the highest?
I believe it's around 1.25 inches. At one point in time, I measured it. I don't remember off the top of my head.
So you believe it's
what
an
is
inch and a quarter up and 1.25 inches down? How do you apply the 1.25 inches?
I recall the total being like 1.25 inches, but I measured it at one point in time. I just don't remember off the top of my head.
Would you be surprised to hear that the tolerance is 5 inches on that vehicle?
I would be surprised. I don't recall it being that much, but I would need to double check.
Assume that the manual, as well as other informations, support that the tolerance is 5 inches and that specifically the vehicle can be raised 3 inches high and it can be lowered 2 inches. That's the basis for the 5. What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr. O'Keefe? If it was even possible, what did you use for a measurement of the suspension?
Matched the measurements from when the vehicle was tested, I believe on February 1st, at the Canton Police Department.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus to match that.
Did you
Match what?
in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document it all?
Yes.
Where?
Slide 107.
Can we have slide 107, Mr. Wolf?
Good observation, Eric.
And then if you could zoom in on the lower photograph, the gentleman with the blue shirt. Zoom in a little more, please.
Is this a Trooper Paul photo?
So
Oh, look
if I
at
may,
that.
we matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
Sir, my question is, where did you document whether the suspension was at 0, whether it was +3 or -2? Where did you document that?
Right here.
And what are the numbers of the documentation of that?
I don't know. We were matching the photos. So I don't care what the numbers are. I care that the height is the same.
Okay, so I just heard you say, if I heard correctly, you don't care
I don't
what
care.
the suspension is at. Is that your testimony?
No, I don't care what the suspension number is as long as the heights match.
I understand. I understand. So what was the suspension height of Miss Reed's Lexus at 5:07 a.m. on January 29th, 2022, while at One Meadows and colliding with the Chevy Traverse? What was the suspension height then?
We assumed it was the same as when it was
Oh, you
at the
assumed.
Canton Police Department.
Exactly. You assumed, but there's no measurement like was just on that depiction. There was no note that said, okay, we're doing this very important and inches sensitive measurements to see whether the tail light on the Lexus makes contact with the Traverse, but there's no measurement and no documentation of what the suspension height was at One Meadows, correct?
So we took the closest measurement in time to the One Meadows event, which is when it was at the Canton Police Department. That was the best information we had.
Well, that information isn't very good because the vehicle had to go from Canton to One Meadows. And when the vehicle drives, the way the suspension system works, it's automatic. When you go above 20 miles an hour, the suspension comes up. And when you turn off the vehicle, it goes down so you can get out easier. So it would be improper to assume that the suspension at One Meadows would be the same at another location.
That's the only, sorry,
Was there objection?
No.
Go ahead and answer, please.
that's the extent of the information we had. We had it when it was at the Canton Police Department.
That's-
We matched that height.
Sorry, sir. I understand.
But
We get it.
actually, you brought up a good point. It's going so slow when it's backing up that it wouldn't raise up. So the static position when it's backing up would be the static position.
But it wouldn't be going in backup from the Canton Police Department to One Meadows. It wouldn't be going back up when it's going in other locations, sir, right? It would be driving forward. It had to get from point A to point B.
Right, but as you pointed out, when you turn it off, it drops down, and then you turn it on, and then once you go above 20, as you indicated, it goes up. But when she's backing up, she never goes more than a couple miles an hour. So it's going to be at the same position as when you start,
So it's
which
going
is
to be a little
approximately
bit
the same
lower
position
than you
when
accounted
it's
it
off
for
at the
after
Canton
it
Police
was at Canton
Department a couple
PD.
days later.
Do you know whether the suspension system locks when there is testing of the infotainment system?
Well, the suspensions, I don't know.
Okay. Let's go on to the next topic. You're aware of the vehicle control, excuse me, Your Honor.
These are just breadcrumbs he's leaving. He's leaving breadcrumbs.
Thank you, Your Honor. I'm changing topics to go back now to Fairview, 34 Fairview. You don't know what the suspension ride height at 34 Fairview was on January 29th of 2022, do you?
Correct.
So therefore, if you don't know what the suspension height was, because of course you weren't there on January 29, 2022. Therefore there's no measuring stick, as you say, you assert that you would have accounted for it in your methodology. So you don't have the suspension height for that key day, do you, sir?
I only have it 2 days later.
All right. So when you talk about key measurements, such as the spoiler on the top of the Lexus and the inches that are important as to whether things such as, is there a contact with the front eye, you don't have some data that would be relevant to that calculation, the sum data being the suspension height of the Lexus at that time, do you?
So we have some data. We have photos of the vehicle 2 days later. We don't know the exact height outside because, as you alluded to, we don't have a measurement on January 29th of it, but we do have it 2 days later. That's the source of the measurement.
You don't have the suspension height or the setting of the suspension of the Lexus that existed on January 29th, 2022, do you?
Correct.
Now let's go on to another topic. Within the 34 Fairview on January 29th of 2022, I'm not going to go over them, but you asserted various measurements, height, width, with regard to the Lexus, correct? It wasn't just for the spoiler at the top, correct?
Correct.
And for all those other measurements that you talked about, you did not have the suspension height and the suspension setting of the hydraulic system of the Lexus on January 29th, 2022, did you?
So the hydraulic's only going to affect the vertical dimensions. It doesn't change anything left to right. It doesn't change anything down the side of the car.
Understood. But for the measurements that are affected by vertical, you didn't have the suspension height of the Lexus system on January 29, 2022.
Again, I only know what it is 2 days later.
So now let's go on to vehicle control history. Sir, you understand what I mean by vehicle control history of
Do? This is text stream information.
Are you aware of what is called the Bosch crash data retrieval system in Lexus vehicles?
Of course, we showed it on my slides.
And the Bosch crash data retrieval system in Lexus vehicles is sometimes referred to as the black box.
No, you're mixing up two things. So the Bosch is like the tools.
It's a question, sir.
So you answer that with a yes or no?
Is the Bosch crash data retrieval system the black box on Lexus vehicles? I just wanted to repeat it so we can.
I didn't hear what the objection. You objected?
I'd like him to be able to finish his answers.
Yeah. So the question was just asked. Can you answer that question?
No, it doesn't make sense.
Okay, next question.
The question doesn't make sense.
I'm going to ask the question, sir. The Bosch crash data retrieval system in Lexus vehicles, you're familiar with that? Are you familiar?
Come on, glitchy stream. Don't make me freeze on this douchey guy. So it's just NBC 10 having an issue here, or is it all the other streams that are broken too?
By Lexus as a diagnostic tool for their technicians, Lexus technicians, to assist in vehicle repair and maintenance. Is that what that is created for?
That's their stated purpose.
Right. And is a synonym for VCH TechStream?
Sort of. TechStream, similar, like Bosch is the hardware and software to access the black box data. TechStream is the software to access, for example, the pre-collision system, the PCS system, and the VCH, which is the vehicle control history. So TechStream which does a lot of other stuff, but does access that information.
You just mentioned Bosch, didn't you, sir?
So Bosch is not in the Lexus. You use Bosch stuff sold by Bosch, Bosch software and hardware, and you walk up to the Lexus with all the Bosch stuff and plug it in and download the event data recorder, the EDR, the black box. That was my problem. There is no
Understood.
Bosch stuff in the Lexus.
I understand, sir. That was going to be the question that I was trying to get to, but you've explained it, so I don't have to answer the question. Let's go to the VCH database that you say the stated purpose is to assist technicians at Lexus in vehicle repair and maintenance.
So I didn't say that was a stated purpose. I'm saying that's what Lexus or Toyota says is a stated purpose.
Oh,
It's being
you know
used
better
in
than they do?
litigation all the time. All I know is that's what Lexus and Toyota says. But again, it came about right when we started seeing all the sudden accelerations in the Toyota vehicles.
So my question is the VCH database specific to Toyota and Lexus vehicles?
So it's not a database, it's software.
Is the software specific to Lexus and Toyota, the VCH?
Those particular acronyms are, yes.
Want to move to another topic, and we are almost finished. We have just two more topics, sir. How common were VCH events when Miss Reed owned the Lexus?
In 2022,
Do you know the ownership period of Miss Reed with respect to the Lexus? Do you know how long she owned it?
I have that documentation. I don't know off the top of my head.
Do you have an approximate?
No, I mean, it was a 2021 vehicle. Our accident's January 29, 2022. But I did get that information.
Do you know how many VCH events were associated with the Lexus of Miss Reed?
I did not count them, no. I have them all.
Do you
I was
have-
only focused on the ones around our time period.
Exactly. But do you have the number of events? Do you know how many there were?
I could get it for you.
How long would it take, sir?
3 minutes?
Why don't we come back to it?
Okay.
And we'll see if it's.
How about I start this so that we don't have to wait for it to boot up?
Oh, he really wants
And
to
then
get
when
in
we
his
come back, it's
computer.
ready to go. You
As
okay
long
with
as
that?
that's all you're looking at, sir.
Yep.
Thank you. And then pick your head up, please, so I can finish these two
Please,
topics.
go ahead.
So how often were VCH events recorded on the Lexus before January 29th of 2022?
Man, I have to pull this data up.
Fair
to
enough, fair enough.
answer that
I
question.
assume that's going to be in what you're also pulling up.
That's the goal here.
Would the number be about 15? Does that sound right to you?
Let's see, 1, 2. There's 18.
18. So there were your records show that there were 18 VCH events recorded on Miss Reed's Lexus, correct?
Before the subject one.
Right. Did you conclude that any of those events, other than the 1162-2, were a collision?
No.
Now let's go to reverse recorded events. Can you tell how many of those 18 events were reverse recorded events? And you know what I mean by reverse recorded events? The
Yes.
vehicle going in reverse?
Right.
How many of those events were the vehicle going in reverse?
And this is before.
4. Other than,
He asked
No,
you,
I said
is this
before.
before?
yes, I'm sorry.
Oh, I would have to pull up the PCS file.
Could you start that and I can continue on with the questioning?
I got to, so the PCS file is I have a second laptop that
Here's
has
what I'm going to
texturing.
do. That's not important for me to keep going and get through it,
Okay.
so let's just stay on the events, okay? Only one of all of those events, those 18, are you concluding that there was a collision associated with them, correct? Just one?
No, all those 18 are before. The collision's number 19.
No, I'm saying, I understand what you're saying, but for all the other events that are recorded, you're not, other than the January 29, 1162-2, you're not concluding that any of those were collisions, correct?
I didn't look at them. They were so far mileage away from everything.
But you're not concluding, even though they were so far away and you didn't look at them, you don't conclude from the information you have that any of them were a collision, correct?
Sustained.
Let's go to 5:07 a.m. on January 29th, 2022 at 1 Meadows, the home of Mr. O'Keefe.
Okay.
There was a collision between Miss Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided, they made contact.
They touched.
Right. But the actual collision at 1 Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. It's too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No, the impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily. I mean, it'll cause fault codes and things like that, but that's not what it does. The trigger here was transitioning into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred, because the tech stream doesn't tell you that.
Thank you. That
You're welcome.
is exactly my point. The tech stream information doesn't tell you when a collision occurs, does it?
Correct.
That's all the questions I have at this time, Your Honor.
All right, why don't we take our morning recess, James?
Well, that was quick. He had estimated 4 hours yesterday. So, since, I mean, if he doesn't get to ask about Trooper Paul and Scorty Bello and his reliance on their stuff and why he agreed with it or disagreed with it, even though it was presented to him and he evaluated it, since they don't get to ask him any questions about that, I guess that has perhaps truncated this cross-examination. So a little bit of a different vibe today, huh? He did not take my corner advice, which is totally cool. It's not obligatory. My suggestion had been maybe try to find a way to laugh at this guy a little bit, but no, he didn't. What he did instead is he got more aggressive. He just got more aggressive to pinning in the witness. And it seemed to me like perhaps the witness, maybe he's just not warmed up yet today. Is there something going on in there? Oh no, I think that's Welcher. Welcher wants to know about his flight. Well, anyway, it seemed like potentially the witness might have also been advised, perhaps considered, maybe tone it down just a little bit. Not a ton though, because he's still up to the old tricks. So here's why, your question is wrong. A lot of those types of answers, the answering the stuff he's not asking, asking you a question about does it match? Well, there's broken glass. I didn't ask you if there's broken glass in both of these places. I asked you if you knew that it matched. And so Alessi was staying a lot more focused on, here's what I need to ask. And then instead of like responding to what Welcher is answering that's not responsive, Alessi is just turning it back around to keep it responsive. So it's just maybe a little bit more effective than he was yesterday at being able to pin the witness into, this is my question. You're here to answer the questions, not to ask them. You answer my questions. And didn't he? Okay. He just went right into compliance. Okay. So like I was saying before, what I'm getting out of this is a little bit of a shift in strategy, that instead of trying to get concessions from Dr. Welcher about why he's wrong or how he's wrong or where his analysis is flawed or anything like that, because you're never going to get it from this guy. You're never going to get that from this guy. And we already know, we can anticipate there's going to be disputes between the experts, like there always are. That's why you have experts testify. If the experts were in agreement, you wouldn't maybe necessarily need them to do that. But we know there's going to be defense experts coming in to testify. So all he's doing in this cross, my read on it is he's anticipating the criticism that's going to come from ARCA. And he's kind of giving him a chance to pre-address it, respond to it ahead of time, and see what he does with that. And his answer has been to double down on things like the photogrammetry, right? Big foreshadowing through all of this. Inches matter, okay? The location of that camera, the angle of the camera, all of those things change the perspective. And so that would need to be mathematically adjusted, calculated in order for that reconciliation to know that it's accurate. You just eyeball adjust things, you could be deceived. I mean, that's the whole point. That's the whole point of issues with optics and lenses and stuff like that. It can be deceptive. It can be misleading. So I sense that is simply coming. And so all he's done is just nail down this guy's position so that once ARCA comes in and testifies, here's the gazillion problems with this photogrammetry analysis and why it's trash. He doesn't necessarily get to come back and rebut it. I mean, he can try, but he's already sort of answered, well, it's fine. We did it. When we reconciled the videos with the overlays, and we tied it in with the 3D scan, it was fine what we did. So to be able to, build on that or change that or something like that, at this point, he's locked in to his position on that analysis and that methodology. I suspect we're also going to see a pretty big, I mean, we'll see. We'll see. I'm waiting to see what ARCA can do and how it's going to correspond with. We already know these guys got paid minimum in the ballpark of $400,000 for this, for what we've heard about, for this. Didn't want to break a crash test dummy, you know, limited testing and image production and things like that. Yeah, you could, I don't know how you, if you have 3D scans, could not make a 3D image and you can simply rotate it, show it, you could do a video of your 3D image and show it, you know, rotate it, flip it, look at it from any and every angle. And that would be an effective graphic as opposed to turning it back into a two-dimensional image that doesn't really show you anything. So I wonder if, for example, ARCA is able to do that. Is ARCA able to take their 3D scans and then do it correctly? That would be fun. So then we got into the hydraulic system. Well, actually, no. First, we got into Photoshop. This has got to be a breadcrumb. That has got to be foreshadowing. Somebody thinks that's Photoshop. And we don't know why they think that. We don't know who thinks that. We don't know what their basis is. But for him to be asking those questions, somebody thinks that's Photoshop. So I wonder what that's going to be about. Very intrigued by that. Then we got into the hydraulics, which of course are pneumatic. You know, it's not using hydraulic fluid to lower and raise the car. It's an air system. The air ride systems, guys, those things are super cool. A friend of mine at the boxing gym put one of those in his car. He's been trying to get me to put one in my Subaru, and I don't want to. I like my car. I like it. I don't know. It doesn't need to be a low rider, you know. It's cool. I like being able to like go over speed bumps and stuff without having to, you know, go at weird angles and everything. We don't necessarily have the best roads up here as far as like hitting a dip and things like that. But they are pretty cool, you know. It's just an air compressor, basically. You know, this aftermarket one is just an air compressor that sits in the trunk, and it plugs into the, you know, suspension system, and it's got the air, you know, air controlled lift basically. And it's pretty much like he described. You turn it on, the car lifts up to where it's at driving height, but you can adjust it. You know, you can set it at different levels. Turn it off, it lowers down to the ground. Makes a lot of sense with an SUV type of vehicle because they're up high. You got to kind of climb into it a little bit. So being able to lower it and raise it, you want it high for visibility and just, you know, maybe it's not really more comfortable to ride higher, but you get some advantages, I guess. But then lowering it makes it a lot easier to get out. So they are cool. They are cool systems. And I had seen online, I think over the last couple of days, some folks had caught on. Oh yeah, Karen's Lexus has this air ride system built into it. And yeah, he would be surprised to learn that it's 5 inches. This is a foreshadowing. They know it's 5 inches. And so sounds like they know that at least in part from the manual. You just read the manual for the vehicle and it might tell you that. He thinks it's 1 1/4. That's definitely you bullshitting, because I don't know how you would think it's 1 1/4. If it's actually 5, that's some pretty messy measuring or whatever that you did. And so that's a huge variable for all of this analysis. How high is the car? How high is the car makes a huge difference in terms of what's going to happen, you know, with an accident. I guess that's now that I think about it, maybe not so much backing up. It would make a huge difference if this was a frontal collision, because we talked a little bit about that over the last couple days. If the car is really high, it's riding really high, it's more likely to hit you above your center of mass or center of gravity, which I went down a little rabbit hole about. Are those really the same thing? I don't need to necessarily get into that. Technically, I think we should be talking about center of gravity here, but I don't know. That might be nitpicky. Maybe Gray Space can tell me. Should I technically be using the concept of center of gravity? Seems to be like just that's more what we're talking about than center of mass, like per se, anyway. Linguistic, semantic stuff, perhaps. If it hits you above the center of gravity, it's going to knock you down. If it hits you below your center of gravity, it's going to lift you up onto the hood and potentially over the top of the car. So with a front collision, it make a huge difference. This could potentially be a massive game changer in terms of what sort of accident would result. A 3-inch difference in the suspension height could absolutely be the difference between launching somebody over the top and dragging somebody under the wheels. With a rear, I mean, you'd think it's still going to have some effect, but what effect that is, maybe just more out versus down. You know, still, if it's hitting you up high, if it's hitting you above your center of gravity, I would think the inclination is still going to be then that it's going to push you down. If it hits you more like at or below your center of gravity, it's gonna more like push you back. But that would seem to be a pretty important variable for all of this analysis. Obviously, for things like did the spoiler hit him in the eyelid? One of the more ridiculous things we've heard over the course of this trial. Does the bumper line up with his knee? Does his elbow line up with the tail light? All of that type of stuff. And then, of course, just going back to one Meadows, how do these cars interact with each other? Kind of depends on the height, doesn't it? If it's higher or lower, what height did you use? Oh, they just used the one that it was at the Canton Police Department. When it was at the Canton Police Department. Apparently, if it's sitting off, it's different than when you turn it on and it raises. Apparently, it's different. And then beyond that, according to Mr. Alessi, this system is like variable while you're driving. The system is going to adjust itself while you're driving. So then another little preview. He doesn't know if the suspension system locks when the infotainment system is analyzed. Huh, intriguing. Somebody probably discovered something. Seems to be what that sounds like. So a lot of these things, we're not getting anything from Dr. Welcher with this. This is just a preview. This is a preview of what we can and perhaps should expect from ARCA. And so if ARCA doesn't deliver this, it might raise some questions about, was this a good cross? What was going on with this cross? What was the basis for these questions and so forth? If we hear it from ARCA, it makes sense. Of course, that's why you've laid this groundwork. If we don't hear it from ARCA, then maybe it sounds a little bit more like you're spitballing critiques, and they may or may not have landed. So then the CDR stuff, text stream is for diagnostics. I thought we established that pretty clearly. He admitted it, then he denied it, then he admitted it again, then he denied it again. Like we talked about that. He talked about that on his direct. I'm pretty sure it's a diagnostic tool. It's not made to register crashes. In fact, according to him, it does not register crashes. It just registers these various trigger events that, yes, would seem to have something to do with maintenance, monitoring, and stuff like that. Potentially liability. He's suggesting that it has something to do with acceleration problems these vehicles were having. And so when a manufacturer has something like a vehicle with an acceleration problem, the manufacturer has a potential products liability issue. The design of this vehicle is unreasonably dangerous, kind of thing that can get you sued, and sued like on a class action type of scale, because there's, so many of these cars produced and out on the roads and stuff. So that type of thing, could be related to addressing some kind of design issue with the accelerator, or maybe maintenance issue with the accelerator, something like that, just to be able to keep it safe. But bottom line, that's what it's for. It's to track how the vehicle is operating, how it's working, not whether it is being crashed or not. So we already know there's nothing in the black box. We heard that from everybody. And there were 18 trigger events before the one on January 29th of 2022. Not a single one of those he is concluding was a collision. That's not actually what they're for. When there was a collision that we know about, it didn't register. And that's because the trigger is not about here's where a collision happened. So this may come off as a cross that doesn't land points or something like that. Again, there's no smoking gun. There's no gotcha, because this guy is never, ever, ever in a million years going to admit that anything he did was wrong. At best, he's going to say, I don't care about that. That's not that I was wrong to not look at it. I don't even care. Which is not, I'm sure, exactly the winning answer that he's reaching for there. But maybe it is. What do I know? Maybe the jury is really impressed by that. Oh, the expert doesn't care. Well, then I don't care either. It's possible. We don't know how this is landing. So you might get that impression sometimes if there's no big explosion, no big gotcha, no big, ooh, this guy has been completely destroyed, that the cross has been ineffective. And if that's your goal for a cross, then that didn't happen here. But that's typically not going to be a realistic goal for cross-examination. It's just not most of the time. Very few, if any, experts are going to ever get on the stand and be like, oh yeah, now that you pointed out to me, I did mess up that one thing. Only if you have them so completely cornered and it's so completely undeniable that there's just no way out of it, then they might. And of course, there'll be a gazillion excuses and explanations for why it wasn't really their fault. Like we saw with Shannon Burgess. Well, it was Maggie Gaffney's fault. It was Aperture's fault. They don't admit mistakes. Experts just don't do that. So it's not a realistic expectation for a cross-examination of an expert to think that, you're going to get some big gotcha moment, some big smoking gun or something like that. All you're really doing is you are planting the seeds for how you are going to undermine him with your own expert. And so the jury's heard it. It may not register. It may not matter. It may not be anything that they're hanging their hat on right now as I'm going to pay close attention to that. But when ARCA is on the stand, assuming ARCA comes in and now picks up this trail of breadcrumbs and leads us to the loaf, then that, can trigger, oh yeah, I remember they talked about that with Dr. Welcher. You can even work that into your questioning if you want to. We heard testimony, the jury heard testimony from Dr. Welcher about, XYZ. Dr. Welcher explained that, the photogrammetry is fine because they eyeballed how to correct it and there was no distortion, so it's good. What's your response to that? You can do little things like that sometimes, although of course in Judge Bev's court, you never have any idea what you're going to be able to do or not. But there's nothing improper about, relating the testimony of the witnesses to each other. So, it's not dramatic. It's not dramatic. And it's one of the things that we may not really know how effective it is until we get to the defense experts and see how well they pick up on some of these little breadcrumbs. So sorry, we've been staring at the fan the whole time. I wasn't even really paying attention to that. Well, you guys have had some things to say this morning. What's up with everybody? How you doing? Fere nature. I was on rewatch yesterday, but do you think it helped or hurt the Commonwealth to show extensive injuries in other fatal graphic case? Trying to show no bone breaks, but I bet ME didn't wonder about car acts. Yeah, I called that out at the time too, that I'm not sure this was particularly helpful to the Commonwealth because that guy was pretty mangled. It just highlights the difference between the injuries that he had and the injuries John did not have. And so, yeah, okay, the point was to show he didn't have a broken bone. He did actually. He had all of those broken ribs. He had all the internal injuries. He had massive, abrasions and contusions and stuff like that. It just didn't break a bone. Okay, but John didn't have any of those other things either. If it hits you in the liver, yeah, it's going to probably like lacerate your liver, explode your liver, break your pelvis. The 2 collapsed lungs, all that type of thing. So it seems like to me it's just not a smart counterpoint because the cost of getting that example in. This guy didn't have a broken leg. Well, no, because he had busted ribs and collapsed lungs and a lacerated liver and all these other problems with him. And John didn't have any of that either. So, Kim Neighbor, will ARCA be able to speak directly to what they have seen in Judd's report? They better be able to. I mean, that's pretty classic and routine. It's part of what they're hired to do is rebut this other expert. And so, yeah, if Judd put in his report XYZ, they should absolutely be able to ask ARCA about XYZ. And what do you think about that? And what do you think about the process that Mr. Welcher used to reach that? And was that a valid methodology? And how would you do it differently? And is there peer-reviewed studies on this and things like that? Yes, they absolutely should be able to. But of course, as we have seen, robust cross-examination, apparently the judge giveth and the judge taketh away at her whim. But hey, they can still call Trooper Paul, right? They can call Trooper Paul. We called that yesterday. They can call Trooper Paul. I think maybe they should, but we'll see. Steve F. worked 38 years with hundreds of academics, researchers, business professionals, clinicians. Never saw anyone so intent on getting the last word or so unctuous as Judd. He is a special animal. I was thinking about this the other night. Is he in fact the worst expert witness I've ever seen? He's really bad. You know who he actually reminded me a lot of? He reminded me a lot of Dr. Hughes. Dr. Hughes from Depp v. Heard. And what reminded me of Dr. Hughes about him is the assuming, the assumption, the assuming the facts. Taillight found all around his body, for example. There was no taillight found around his body. Nothing was found around his body. There was stuff that was found that was alleged to be in the general vicinity of where his body was. And that's about all we got. The only stuff that's documented is out there in the street, at least 7 feet from where his body was. But that doesn't help his analysis to get into the details. So we'll just, it's the begging the question. It's the loading his description of what the facts are, taillight all around his body. That's not actually the evidence. And that's part of what makes it so infuriating if you've been paying attention to the details, recognizing that the details matter. So very same thing that Hughes did. Her testimony, it was built into her testimony that men are abusers and women are victims. And that was the assumption that underlied everything. And she was very explicit, really, about coming out and saying that. And so it's very frustrating, not only in a case where a woman is actually, like, we have her on tape being abusive. Okay, she's abusing him on tape in front of us. We can see it with our own ears. It's very gaslighty. you know? So very similar, I think, approach to cross-examination and effective that as a result. That's just part of what makes it so obnoxious. But yeah, he's up there in the upper echelons of annoying and difficult witnesses to have to deal with. James Casatelli, how is it acceptable to be arguing this after the witness has already testified? Bev sucks, man. Went to the limit of the scope of the cross-examination. So that's why they're dealing with it now. He hasn't finished his cross yet. Of course, now he has. He's allowed to go into that stuff. Brace
afternoon.
ourselves for
Good afternoon,
redirect.
Mr. Brennan.
You were asked some
Actually,
questions.
it's morning, but yes.
You were
Shut
asked some
up.
questions about
Nobody's
the
amused by
ring
you.
video from Meadows, which was John O'Keefe's home. And you were asked whether you're aware if the cameras had changed over time.
Correct.
The fact that the camera was replaced, does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions relative to that touching between the cars?
Absolutely not. It would have shown up as increased error when we overlaid the point clouds onto the photos or the point clouds onto the video. If it was an error, it would have showed an error.
Do you have any concern whatsoever that any of the information from the scan is in any way tainted, compromised, or inadequate?
That would be very hard to do. You literally press a button and stand there and watch it, and the laser does its thing. So I have absolutely no reason to disbelieve it. Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
You were asked questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
Yesterday, you were asked a number of questions about formulas. You took out your calculator and you were asked about different variables. Were those variables hypotheticals or were they related to this specific case?
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out. When you spread the load out, you don't sink in as much. So same thing
spread
with
your load out.
forces on your body. If you
Life
take
tip
this
here,
pencil, I don't have to
guys.
press very hard for it to pull in. But if I spread it out, I have to press much harder. So you have to look at the distribution of the load when you're talking about the failure. So when you look at the failure loads, it depends on what you're doing it with. If I hit you with a 5-pound 2x4 or a 5-pound pillow, they're both
like
5 pounds.
That's why the
But you'd much rather get
PSI
hit by the pillow than the 2x4.
would be the best measurement to use.
When you
that
were asked questions
it
about
incorporates
communications,
the
when you
distribution.
would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
No, I don't have any of those.
So the form of the question, ask it differently.
When you were communicating with members of the Norfolk County District Attorney's Office, did you ever use encrypted apps like Signal to communicate?
Objection, scope, Your Honor.
I'm going to allow it.
Just gonna allow it's
No,
completely
I don't
beyond the
even know what
scope
that
of
is.
cross, but
Would you ever use an
That's
encrypted
okay.
app so those communications couldn't be tracked?
No.
Would you ever have any reason as a professional for doing that?
Objection, Your Honor.
Sustained.
You were asked about confirmation bias. You remember those questions?
I do.
Could I have slide 33 of your PowerPoint, please?
I'm sorry, what number?
Slide 33.
Give me a second. 33.
You could zoom that in, please. A little larger so we can see it.
I cannot do it with one monitor.
You can't do it any closer than that?
No, not since I took down. Oh, hold on. Oh, here we go. Which part do you want me to zoom in?
Miss Gilman can zoom in for you.
Sorry? Which part?
Miss Gilman's going to do it for you.
Oh, there you go. Perfect.
If you could zoom in, please. Okay. On shift position signal, going forward, then neutral and reverse. Does that data suffer from confirmation bias?
No, that's strictly electronic data.
When we look over at the vehicle's speed, can we go to the left a little bit? Down?
Of course, the data is not confirmation
Vehicle
bias.
speed,
Confirmation
ending at
bias relates
23,
to your
61
use
miles per
of
hour.
the
Does that
data.
suffer from confirmation bias?
No, again, these are direct readings from the vehicle. Again, that speed on this here, you have to correct for the slippage, which I do later on in the slide, but that is a direct reading from what the speedometer is seeing.
Acceleration at the end of that 10-second window, 74%. Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
I have no further questions. Thank you.
Oh, great. That's it.
Anything, Mr. Alessi?
Your Honor. Yeah, Your Honor.
Yes.
Thank you. Dr. Welcher, you were just asked questions about slide 33, which is a slide about text stream data. You acknowledge that text stream data, what you've called a trigger, like was on that slide, does not tell you if a collision even occurred, correct?
Correct.
With regard to the topic of confirmation bias that you were just asked about in slide 33, am I correct that all of the questions that Attorney Brennan just asked you were about data on that slide, correct? All that's on that slide is data, correct?
Now he asked me more questions than just this slide.
But were the questions just about data?
On this slide, it was just about data.
Correct. But confirmation bias is really aimed at opinions and conclusions and alternative hypotheses. Isn't that what confirmation bias gets at?
So generally, yes. Again, I started this case with
There was
the
just a question.
hypothesis,
Go ahead, sir. Go ahead.
with the hypothesis that the Lexus didn't contact Mr. O'Keefe.
Oh, sure. And
so
how did you
I
disprove
start what's
that?
called the null hypothesis, that this didn't happen. And then I look at evidence to either include or exclude the null
No,
hypothesis.
That's not
So
how you do
theoretically, my
science.
confirmational bias starts with a bias that it didn't happen.
Can you point to one document that shows that you analyzed whether there was no contact between the Lexus and Mr. O'Keefe? Can you point to one document? Was there one document on your slide presentation, for example, that analyzed the null hypothesis, as you call it, there being no contact at all? Was there any slide in your direct testimony?
So remember what I said, we start with hypothesis, we get more data, we whittle down our hypothesis to the final answer. I mean, I had 130 slides. I suspect I bored some of these people to death already. So I didn't include everything. There's thousands of photographs in here. There was a bunch of testing I did with the Lexus about backing, pedestrian detection, that, you know, removed certain hypotheses. So if I was able to eliminate a hypothesis, I didn't present it here.
Sir, my question is not about you.
All the slides show that, to answer your question.
Sir, my question is there any slide that says
You didn't show it, so all his slides show it.
alternative hypothesis 2, whatever the label is, whatever the term, it says no contact between the Lexus vehicle and Mr. O'Keefe. Is there any document that you presented to the jury that shows that?
Any document where those words are written on it?
Correct.
No.
And to work through hypotheses, different ones, and to see whether there's confirmation bias, have you heard of scientists refer that as showing your math, so to speak, in working through hypotheses, documenting each hypothesis and how and why you rejected them? Have you heard of that term in the scientific world, show your math with confirmation biases and alternative hypotheses? Just a question. Have you heard the idiom, the phrase, show your math?
Your question is, have I ever heard show your math, period?
Associated with the application of various hypotheses to avoid confirmation bias. Have you heard of that term used in that conjunction?
Not really in that
Okay.
context. It's probably, I understand where you're going with it.
Thank you, sir.
You're welcome.
No further questions.
Dr. Welcher, you are all set.
Oh my God, thank you. Give me a minute to pack up and I will be out of here.
Okay, so when you have a null hypothesis,
Oh, I am plugged in, yes, thank you.
you're comparing it to the alternate hypothesis. And what you are doing is you are gathering your data, you're doing testing to show if you can either reject the null hypothesis or not. You are trying to disprove the null hypothesis. So I dare ask, if the null hypothesis is that Karen Reed did not hit John O'Keefe, how is that disproven? How is that disproven? That has not been disproven. It hasn't remotely disproven. They don't even have data to try to prove she did hit him. They have, that's why we have to have the testimony and the you know, the statements of the people and the cherry picking from the medical records and so forth. You guys like understand this way better than I do. I understand it in a,
Mr. Brennan?
you know, kind of get the gist of it, 10,000 foot sort of way.
Commonwealth moves to introduce and play clip 26.
So I thought, could I run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out, and David said, yeah, then you have some element of culpability.
Exhibit 207.
Your Honor, the Commonwealth rests.
We knew that was how he was going to end with her words. It's never been about.
Does counsel want to see me?
We do, Your Honor.
Okay, so should we send the jury out or should?
Probably, yes.
So jurors, so everybody can sit. So jurors, the Commonwealth rests. That means that the Commonwealth's case has been presented to you for your consideration. So I need to meet with the lawyers for a few minutes, so we're going to send you back out. I can tell you that it now appears that we're at least on schedule, if not a little ahead of schedule. So we'll send you back out for a short recess.
So we knew
counsel come
that
to
fact,
Sidebar,
science, and
please?
data was always a head fake. We knew that was always a head fake. That's never been what the case is about. It's always been I hit him 2.0. He called it the backup position, but it is in fact the real position. That's what he's hoping is going to sell the case. So that's why he concluded with that. Can't say I'm shocked. Oh, but I'm glad. How glad am I that the Commonwealth is rested? And now we get a defense. We get a defense case. Normally, at this point in the trial, you're doing what they call the halftime motion, the motion to dismiss, arguing the state has failed to meet its burden of proof beyond a reasonable doubt. Seems to be what they're doing here. They're going to make this argument. It's almost certainly not going to win. It almost never does win because you can infer just about every element of the crime, from something that has been presented. Oftentimes it'll be like, oh, you didn't prove the mental state. You might be arguing that here. They didn't prove Karen had a mental state. Well, but it could be inferred. It could be inferred from the card data. If she knew, it could be inferred from the clips. If that one clip that was sort of ambiguous where she's like, but he didn't look injured. He didn't look fatally injured. And if you wanted to interpret it in a way that made it sound like she was saying that night when she left, he didn't seem fatally injured, as opposed to the next morning when she found him, he didn't look fatally injured, then maybe you would be able to reach that conclusion that she had some kind of guilty knowledge. It's extremely weak. It's based on a very stretched interpretation of what she had to say in that video interview. But that's all it takes. All it takes to get over a motion to dismiss. Extremely unlikely is good enough, as long as we're not saying it's impossible. So I suspect that may be what they're doing, unless they're just talking about scheduling, which of course is also another very realistic possibility here. So my gosh, we get the rest of today. What do we have? About 2 more hours? 2 more hours, we get to have defense case. Hour and a half, something like that. I don't know, guys. I've been thinking about. I know Mr. Betterow has said a couple times now. It'd be great to start with ARCA, really get the counterpoint. I tell you, I'm really feeling that. I would be really happy to see Dr. Wolf walk in this courtroom, spend the rest of today and perhaps a good chunk of tomorrow with Dr. Wolf. That would just be like a balm for the soul after what we just went through with this particular guy. I definitely see the wisdom. Just the theatrical side of it, the presentation side of it, getting that contrast is very valuable. But also, this is how you reclaim the facts, science, and data. If your case is there is no collision and the facts, science, and data prove that, all they have are these words that they're trying to bring out to convince you mean more than the data does. We have the data, and ARCA is the one who can interpret that to show you that there's no collision. So it makes sense both from that presentation type of standpoint of how is this going to land? How are they going to take this, considering what they just saw from Dr. Welcher? But then it also really fits with how they want to dominate and win the case. They want to win it on the data. The data favors the defense. So pivot back to that and start with that. End with that as much as you can. Focus on that. I think that would be a very powerful sign. So got my fingers crossed over here that we might see Dr. Wolf walk through that door. Some of the upcoming minutes. Let's go ahead and catch up with you guys while we're waiting. Alyssa Ramirez, anyone catch the court reporter throwing her head back and saying, "Oh my God," at the end of Cross? I saw that. Somebody clipped that yesterday. It was when they were having the argument. They did the voir dire, and then Bev had asked Mr. Alessi how much longer his Cross is going to take. And he said 4 hours. And that was when the court reporter threw her head back. Not exactly very professional, is it? If that's what it was in response to. Not exactly very professional to do that. But maybe she was just tired and it had been a long day and it had nothing to do with the words that were being said in court. That said, because things can be misinterpreted, you really should mind your P's and Q's on your decorum when you're in open court, because it can look bad and you don't want to create a bad impression. So in general, the court reporter really shouldn't have done that. Not a good look at all. A cool breeze. The use of the second person from Brennan against the court and defense is inherently antagonistic and projecting. You know, I hadn't really thought about that. Hadn't really thought about that in particular as like being part of what makes Hank so especially annoying. I just find him because he can't not insult. You know, it's like he can't not belittle the other side or the other side's argument. And to me, that's just always a massive tell. If you have a good argument, you rely on the strength of your argument. If you don't have a strong argument, then, you know, you make fun of the other guy or whatever. And so that's just what has always bothered me about him, is he's got to like personalize everything, make it especially obnoxious. But I'll pay more attention to the second person and see if that maybe jumps out a little bit. Ginger Avenger 09. I hope prosecutions use every single one of Brennan's arguments against him in his future cases. That would be funny, wouldn't it? Hey, turnabout is fair play. The rural juror. It is unfair for the Commonwealth to be able to come to trial too with an entirely new theory and the defense not be able to ask and point out to the jury that it is in fact a brand new theory. It screams that they don't know what happened. Well, again, no, of course they should have been able to cross Welcher about this. But the fact that she did not allow them to cross Welcher about it doesn't mean that it's not ultimately going to make it in one way or the other anyway. And certainly, you know, the suggestion they could rely on, they could just call Trooper Paul. Yeah, they could. That's out there. He's on their witness list. They could try to. Why? Would you anticipate there may be like a problem with serving him or something, Hank? Why would it be difficult to bring in under subpoena a law enforcement witness? Why would they have any difficulty with that, Hank? Yeah, they can try to, and it's usually pretty easy to do. Cops are some of the easiest people to get into court. So that is one possibility. The whole problem with Trooper Paul's report not coming in is that Trooper Paul's report is hearsay. So bring Trooper Paul in to testify himself to what he did for 2.5 years for the Commonwealth before they shit-canned him after that first proceeding and then hired these guys to come in and redo a whole bunch of what he did at taxpayer expense. Another possible way you could get it in is through ARCA. ARCA relied on it. We're so in the dark about when hearsay is okay as a basis for expert opinions and when it's not, that I have no idea if Bev is going to allow that or not allow it. It seems extremely selective. Okay. When Judge Welcher is testifying about the reports he relied on and the autopsy and the this and then that, it's fine. Even though the rule specifically says they're not supposed to be able to do that unless it's independently admissible. And reports, police reports and so forth are not independently admissible. So why they can do that is really, really unclear. But that's what she's allowing. If it's good sauce for the goose, is it good for the gander? Always a question we have to ask in this court. Unfortunately, it shouldn't be hard to ask. We should be able to look at, oh, Judd Welcher was allowed to do this, therefore ARCA will be allowed to do the same. Because they very much looked at Trooper Paul's analysis and Trooper Paul's conclusions, relied on his data, etc. So that's potentially another pathway for it to get in as well. But yes, quite annoying, quite irritating. They absolutely should have been allowed to get into that on Cross with Welcher, but gotta stick our thumb on the scale when it comes to the defense here. Alessi's fantabulous lexicon. Every time Brennan comes up for argument, it's just a bombardment of gaslighting, casting of aspersions. I am left wanting to scrub my brain and ears. Yeah, you hear what I hear. It's the gaslighting I'm fairly immune to because I'm just so it's not even it's not even gaslighting. It's just Ipsy Dixit. It's just asserting things on the authority of me asserting them. I say it is, and therefore it is. That doesn't bother me so much because that's just run-of-the-mill pomposity. Kind of used to that. Kind of used to that in a lawyer's suit. It's not the most unusual thing in the world. But the aspersions, yeah, the way you constantly have to be, belittling, implying that the other side is shady, unethical, terrible, wrong, dirty, slimy. It reads projection to me is a lot of that. But it also just screams, why can't you just argue the point if the point is so good? You don't have to try to act like the other side is evil incarnate for having raised this issue. I keep things in perspective. Red Ronin, can something not be done about Bev? She keeps showing her bias nonstop. Unless and until they move to disqualify her again, there's really nothing. No, there's nothing. And if they move to disqualify her, what's going to happen? She's going to consider that motion. She's going to say, no, I've been absolutely fair. No problem whatsoever. And then what can they do? They can appeal it up to Massachusetts, and they can try to overcome the very strong presumption that the stuff she does as a judge, the rulings she makes as a judge, can't be used to show bias. The fact that she lets Mr. Brennan do one thing and doesn't let Mr. Alessi do it. Strong presumption you don't get to rely on that. So it's not a good appeal issue. Bad judges are a problem, guys. I don't know what else to tell you. Bad judges are a problem. They're extremely hard to get rid of. Very little oversight, very little ability, meaning like power to correct them, but very little inclination as well. You guys just saw the bar is recognizing her as the person of the year or whatever. This is the game. This is the club that these guys play in. They are not inclined to go in and make an enemy out of the judge. Not everybody's friends with each other to their face so that you can get some advantage from, your network, your connection with that person. That's literally the game. So they have no incentive to go in and like take Bev down and call her out for bias. They are far, far more. They have much greater affinity for the concerns of the judges than they do the concerns of us peons who are merely subject to the justice system. This is just a reality of the system, guys. It's not real pretty, but that's what we got. I guess I should maybe change my banner here, huh? Be a little bit more accurate anyway. Liz Hunter, between here and X, anyone that still thinks the Commonwealth is right is completely delusional. #FKR. Y'all are excellent at sleuthing. Look, I understand not everybody is super into watching trials. Not everybody wants to spend the 10 hours a day and so forth that we sit here to get every detail and hash it out and talk about what it means and go down the rabbit holes of what's available in public information and all that type of thing. Not everybody's inclined to do that. I get it. But it's just that there is a big difference between the quality of an opinion that is highly informed and one that's not. And I think what we see a lot of just in the kind of reaction sphere is just a lot of uninformed opinions, a lot of mental shortcutting going on. Even I'll just go back to that interview that they did with Juror Ronnie. He's done a few now, but the one that Turtle Boy did. And Juror Ronnie was like, look, she was there and he was dead and she was drunk. So the easy answer seems to be that something happened. It's a very easy mental shortcut. It's not correct. It is not logically sound. It is fallacious. It is confusing correlation with causation. Just assuming because Karen was there and these things happened, that therefore because Karen was there, these things happened. Quid post hoc ergo propter hoc, kind of similar to that idea. These events coinciding don't necessarily have anything to do with each other. Events coincide all the time. We could look up January 29th, 2022 at 12:31 p.m. in, Korea. Find out what happened then. Something happened then. Okay. Correlates. It was going on, but it has nothing to do with what led to John being found on the lawn the next morning. So it's just an easy mental shortcut that is logically incorrect, but one that it's very easy to do, especially if you don't want to put in the time and the attention and so forth to watch the 10 hours a day and so forth, and really be grounded in the details of figuring it out. So, I don't want to judge people too badly for jumping to the decision that she must have done something. But I do tend to think that that's more common. It's a more common opinion if you take the pool of who is informed, like highly informed about the case, and who is less informed about the case. I think you're going to find people highly informed about the case tend to be more in favor of Karen Read is innocent. People who are less informed tend to be more Karen Read is guilty. It's just a knee-jerk, perspective that I have from what I see in the commentary. And you can take that for whatever you think it's worth or nothing. The rural juror, Welcher must be wringing his hands behind that witness stand, just jonesing for his computer to look this glass stuff up. Did you see his eyes light up when he realized he was going to get to turn his computer on? But then the devastation that he didn't get to use his second computer. Oh, my Lord. Wow. Guys, if you need a safety blanket like that to be able to testify as an expert witness, you really are going to need to work on that. You're not going to sit in some federal court on the witness stand with your laptop opening, doing whatever you want, looking at whatever you want. You need to get serious. Just because Bev runs a shit show of a court doesn't mean that you are going to be able to get away with that elsewhere. Carolyn Smith, it really seems like Welcher is not intelligent enough to actually follow along with the nuanced points made by Alessi, separately from hemming and hawing to delay an answer. I don't know that I get this impression. I think he's very smart. He's very smart in the similar kind of way that Mr. Brennan is very smart. They're smart about detecting and being able to get out of traps. He's very good and demonstrates it at listening very closely to the question and critiquing it, breaking down the question. You ask two parts. There's, this question, it doesn't make sense because that's not what a CDR is, that type of thing. So I think it's not that he's not smart. It's that he is thinking about what Mr. Alessi is asking him in a very particular way. And it's not, how do I answer this question? How do I be helpful? What's the actual response to it? It's, how do I say what I need to say, given the limitations that this questioning, imposes on me. But it's like it's, a little bit
Gotcha. Thank you.
out of the trap, I think. But there's been a few times he's had to like gnaw off his own leg. Just been trapped a little too hard. Can't get out of it. But, who knows? Brent Mack, if you ask this dipshart if he was born June 6, 1963, he would say, well, my mom says she got knocked up on October of 62, blah, blah, blah. He'd be like, so... He would find a problem with the question. You're asking me multiple things, okay? Because it was a C-section, okay? I was not vaginally born, first off, okay? And so, yeah, something like that. Jason Bites, can you win an appeal based on cumulative errors, which individually wouldn't be grounds for reversal, but taken together would be? You have, in fact, just stated exactly what the cumulative error doctrine is. It's an idea that, yes, you have accumulation of individual errors that are individually not enough to affect the outcome of the trial, but if you take them in the aggregate, it renders the trial process fundamentally unfair. This is one of those errors that is out there conceptually and almost never applied. I literally had a judge on the Court of Appeals at a conference, where the judges are on a panel and we get to ask them about judge and they get to tell us about what it's like to be an appeal judge and their process and all that type of thing. Had a judge actually say outright, probably don't bother raising cumulative error as an issue. It's just almost never going to go anywhere. You're not going to win it. So yes, this is theoretically possible, but as a practical matter, you could probably count on one, maybe two hands, across the whole country, the number of cases that have been reversed on the cumulative error doctrine. It's very uncommon. Rocco Rockwell, the gentleman who talked about a Lexus blasting off into space yesterday, now talking about dimensions, is definitely something. Yeah, I don't know what dimension, what focal lengths do you need on the camera before the Lexus blasts off into space? Who knows what this guy would come up with? Well, guys, here we go. Here we go. Let's see what the defense has got. What do they got? Please show me Dr. Wolf. Please let me see Dr. Wolf's beautiful face. That would make me so happy.
All right, so jurors, we all, it happens several times a day, doesn't it? So we don't want to waste anybody's time. I know we've spent a lot of time at Sidebar, and we've had times that we've kept you in the deliberation room because we've been trying to sort through everything, trying to make this trial as efficient as possible, but also honoring and respecting all the hard work of the lawyers that's gone into preparing this trial. So sometimes I do understand that it's frustrating for you. But today we were able to spend some time this morning. I know we kept you in there almost half an hour, and we've just spent some time now. So I can tell you that we are ahead of schedule right now. I still need to talk to the lawyers about something tomorrow morning. So we're going to send you home now.
Yeah.
And have you come back tomorrow morning at 9:30, because today I know we kept you until 9:30, and it doesn't make any sense where I already know I need to talk to the lawyers tomorrow morning to have you here for a 9 o'clock start. So tomorrow will be a full day, and we'll have you here ready to start at 9:30. Okay, so those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And also please continue to be careful with your social media use. So we'll see you tomorrow.
Rise the jury.
There we have it. We're ahead of schedule. Ahead of schedule, of course we are. And so that's why, you know, if suddenly we're behind, it will be during the defense case. What a remarkable coincidence. So are they going to have an argument? I'm going to assume we still need to be here at 9 o'clock tomorrow. If they're going to have an argument in open court like they did this morning, then we'll watch that.
All right, so Ms. Little, if you can get me whatever you're going to get me within the next hour, so that would be great. And I'll see everybody tomorrow morning at 9.
Thank you.
Okay. Getting something from Ms. Little. And I guess that's going to be that. Guess that's going to be it for today. Well, we knew it was going to be a short day, but a little bit shorter than we anticipated. God, I wanted to see Dr. Wolf's face. I want to see those dimples, you know. It's just I was already ready. Already ready for it. I needed the you know, eyeball bleach, brain bleach, all of that. But it's okay. We can't always get what we want, guys. So it'll come. We know it's coming. We just have to be patient and wait. Well, I mean, gosh, do I even recap? Like I've already recapped. Like what is there? There was more Welcher. We finished the cross. There was no like boom standout moment from the cross-examination, but that's not a realistic expectation for an expert cross anyway, because they're never going to admit they're wrong. So what we do have is a bunch of seeds planted about things that we anticipate the defense is going to raise in their case, problems with the orientation of the ring camera and the photogrammetry analysis, problem with the analysis from failing to account for the suspension height, possibly an issue with one of the images being photoshopped. Possibly that's been hinted. So that's really what the cross achieved. It doesn't prove any of those points, but it brings them to our attention. And if it comes back with ARCA, we will know this is why, because they have critiqued these aspects of Dr. Welcher's analysis. So yeah, then we had that kind of lame redirect. It was short, at least. I'll give Hank the credit for keeping that short. Any evidence the presentation was photoshopped? No. Like laughed at it. Good. We'll see how that ages. He got back into the distributed loads, you know, like sinking into the bed. We got it, but every load on a human is distributed. It's a matter of degree. So to me, a hit on a taillight to an elbow seems pretty focused. Relative to the car as a whole and the body as a whole, those seem pretty focused. But if the problem with all of this, so you have to be very careful with kinematics, you know, human mechanics issues because of the load distribution, then just calculate it in PSI. Isn't PSI pounds per square inch? That's going to accommodate your distribution. So just use the right measurement. If that's such a problem for you, PSI shouldn't be hard to figure out. Surely there are studies on that. I don't know. I don't do accident reconstruction. Maybe nobody has figured out how many PSI it takes to break any of these bones, but that seems like a problem that doesn't really exist. It's just one that you don't want to address. And so you found this reason why you can't. But that to me seems like weaponized futility. No, he didn't use the encrypted apps to communicate with the Norfolk County District Attorney's Office. Hank is really on that signal. He's going to bring it up with ARCA. We already know he's going to bring it up with ARCA. It was beyond the scope, should not have been allowed. She doesn't care. She's going to let Hank do what he wants. Very crystal clear. And then, the confirmation bias, but these data points don't have confirmation bias problems. No, you dumbass, because confirmation bias is about how you interpret data. It's about how you select data. It's about how you choose what data is important and what data doesn't. What data do you in fact care about versus what data you don't care about? That's what confirmation bias is about. Confirmation bias is about all the data that was not on his slides. That's what confirmation bias is about. So that was the focus then of the redirect from Mr. Alessi. Oh my God, this guy is going to claim. I would love to know the backgrounds. I would love to know the backgrounds of the people on the jury. Because this guy is really going to sit up there and claim that he started his null hypothesis. His null hypothesis is that Karen's SUV did not hit John. Did not hit John. He's going to claim that's the structure of his analysis. Guys, I'm not a statistician. I don't do experiments. I understand the stuff. Like I said, only at a 10,000 foot level. I know here in the chat, there's people that like design studies and stuff. Okay. You understand in really very specific and nuanced detail what it means to have a null hypothesis versus an alternative hypothesis and what you're doing with it. But it's basically a way of setting up kind of a binary result where what you're doing is you're either proving the alternative hypothesis because you have disproven the null hypothesis. And so by necessity, that requires the alternative hypothesis to be established. Or you have been unable to exclude the null hypothesis, which means that if it's in a binary, you might be able to include the alternative, but you can't get a definitive answer really one way or the other. This is my 10,000 foot basic understanding of how null hypothesis testing works. But so the whole point is it's about disproving. Like the point is to falsify the null hypothesis or not. You're able to do that or you're not. So I don't know how on earth he got to he got to disproving the null hypothesis in this case. I don't know. Jeff is very supportive of me and knows a lot more about a lot of this stuff than I do. So he went and got me some good information here about null hypothesis testing. So I'm just going to share that. I'll read with you what Jeff sent me. It says, so the null hypothesis is a statement in statistical hypothesis testing that assumes no effect, no difference, or no relationship between variables. It represents the default or baseline assumption to be tested. For example, if you're testing a new drug, the null hypothesis might be that the drug has no effect on patients compared to a placebo. The alternative hypothesis contradicts the null, suggesting there is an effect or difference. Then we have type 1 and type 2 errors. Yes, false positive and false negative. When testing a hypothesis, errors can occur because conclusions are based on sample data, which may not perfectly reflect the population. So in a type 1 error, this occurs when you reject the null hypothesis when it is actually true. So the null hypothesis is Karen didn't hit John with a car, but if that is in fact true, and you're up here on the stand testifying that she did hit him with the car. If we have an error that can be demonstrated, it will be this type, the type 1 error. This occurs when you reject the null hypothesis when it is actually true. In other words, you conclude there is an effect or a difference when there isn't one. The probability of making a type 1 error is denoted by alpha, often set at 0.05, 5% significance level. That's like our standard deviations and stuff, I assume. or the confidence interval, maybe. For example, concluding a drug works when it actually doesn't. The analogy, convicting an innocent person in a trial. No shit, Grok, no shit. Type 1 error. The type 2 error is the false negative. This occurs when you fail to reject the null hypothesis when it is actually false. You miss detecting a real effect or difference. The probability of making a type 2 error is denoted by beta. The power of a test, 1 minus beta, measures the ability to correctly reject a false null hypothesis. For example, concluding a drug doesn't work when it actually does. And the analogy is acquitting a guilty person in a trial. So that's our difference between those things. Convicting the innocent person is type 1, acquitting the guilty person is type 2. So then we have some key points. The trade-off, reducing the risk of a type 1 error, lowering alpha, often increases the risk of a type 2 error, higher beta, and vice versa, unless you increase sample size or effect size. That makes sense in this kind of binary situation, because if you have a greater likelihood of, acquitting the innocent person, then if you're erring on the side of acquitting the innocent person, then you're probably going to also acquit some guilty people. That's philosophically kind of how the system is designed to work. We're supposed to have a certain amount of tolerance for acquitting guilty people so that we don't convict innocent people. The significance level controls the risk of type 1 errors. Common choice is 0.05, meaning a 5% chance of falsely rejecting a true null hypothesis. The power depends on the sample size, effect size, and alpha. Higher power reduces type 2 errors. In practice, researchers aim to balance these errors by designing studies with adequate sample sizes and appropriate significance levels, depending on the consequences of each error type. For example, in medical testing, a type 1 error false positive might lead to unnecessary medical treatment, while a type 2 error false negative could miss a critical diagnosis. So that is a very detailed description of the null hypothesis testing. Fills in the detail quite a bit better than I am able to do with my very, very basic understanding. But yeah, the bottom line, you're trying to disprove the null, and so I don't know how that was achieved here. But anyway, that's some good stuff. Good stuff. It always kind of makes, I'm able to visualize this type of thing in the context of medical testing or drug testing. It seems like that's the context where it's used a lot, or just maybe where it comes up a lot, and I see it. And it makes sense because of how it's described. Does it have an effect? Does it not have an effect? How do you translate that into this scenario where we're just asking, did the car hit the guy, or did the car not hit the guy? But it's still just, it's the alternate propositions. And so if the null and the default, consistent with our presumption of innocence, is that she didn't hit him, then we're disproving that in order to reach the conclusion that she did. And I'm not sure how that has happened here. Or we are, we're not able to eliminate it as a possible explanation. And if we aren't able to eliminate that as a possible explanation, then we can't say definitively. I don't know. A little bit of an issue, I think. Marilyn Manson cases, he answers like a politician with a non-answer. He just says what he wants to say. Like the politician, when you listen to the debates, like the political debates, I can't watch these anymore. I just, I'm way off politics anyway. It's just not an area of interest to me at this point in time. But I can't hardly watch the debates anyway, because they're just so, insincere, not doing what they're purporting to do. It's supposed to be a debate. A debate's supposed to be about issues. Issues are supposed to be about, facts and arguments and points and data and all that type of thing. And then I'm supposed to, you're supposed to make your points, and I'm supposed to rebut yours and make my own, and so forth. And that's never what happens. What happens is the people get on the stage, the interviewer asks them a question, the debate moderator asks them a question, and then they just go off on whatever talking points they decided they were going to deliver in this particular format, in this context. At this time, in this setting, to these people, they are going to say this. And what the question was absolutely doesn't matter at all. So, like, it's not a debate. It's just like a series of ads is really what they are. I find them really intolerable to watch anymore. Michael Muddragon, somehow this shit for brains is exponentially more aggravating today. Also, I'm pretty sure he just said height instead of height. Third eager beaver needs to stop and let the questions finish. He was very much starting to talk over Mr. Alessi this time. He was doing it yesterday, but nobody really called him out for it. Today, Mr. Alessi called him out for it. You need to let me answer. You need to let me finish my question. Yeah, you do. You need to let him finish the question before you jump ahead to answer it. I didn't personally find him more aggravating today. I found him moderately more compliant today, but only, as a matter of degree. It might have just been he hadn't really gotten warmed up into his full obstructionism yet. It is a little early still. If he said height, I missed it, but wouldn't put it past him. 40 Doherty, do you think AJ's cross style would work better here? No, I don't think it would at all, because AJ's a brawler and this guy wants a brawl. This guy's a troll. This guy is the expert witness equivalent of an internet troll. He's literally trolling Alessi up there. Okay, I was thinking about this yesterday. Things have to simmer a little bit sometimes, and you just you reflect back on stuff, or you see the clip and it like reminds you of something that you thought about before. So one of the things that grabbed my attention yesterday, after all this is over, is I see the reclip of when this guy is saying, when he talks about the Lexus could blast into space. It's improbable, but you're talking to an engineer about the difference between possibilities and probabilities. Okay, you've just given away the game. Okay, you're here to troll this guy. You're really here to troll this guy. If your job is to get on the stand and as an engineer and be like anything is possible in the one field I can think of where you have so much certainty to work with relative to other fields. Like, no, you're not actually a philosopher, dude. You're not here to talk about what the meaning of is. And, what if you woke up one morning and gravity didn't exist? You can't disprove that that'll never happen. Yeah, because this is like 7th grade level philosophy stuff. Of course, you can't rule that out, but that's not engineering. Engineering operates in a material world with material properties that behave in very predictable and understood ways. So you actually get to have certainty about a lot of what you put your hands on in engineering. And in fact, you can be so certain about it that you can often mathematically calculate how certain you are. So it really gave away the game. Anything is possible. He's there to troll. And you know how trolls are on the internet. You know how that works. They love when you get in the dirt with them. They want you to wrestle with them. That's the whole point. They're trying to provoke you. They're trying to get the reaction. So I think Alan would not be a good match for this, because he'd be trying to give it back. And it would just be messy. It would be, we've all seen that Twitter thread with the people. You try to go at it with the trolls, and a week later it's still popping up in your notifications because they're still at it. That's what would happen. So no, I think Mr. Alessi did exactly what he needed to do here, which was just keep it to the points you need to elicit, and that's it. That's it. Everage, it's like this dude took lessons from Daryl Brooks. He loves seeing the back and forth arguing semantics and the smell of his own farts. I just hope the jury sees it. Yeah, you just never know what the jury is seeing. You really don't. You really don't. And there's a way to look at this. What just happened? And somebody could have the perspective of, wow, that guy is really smart. He had an answer for everything. He was trying to be helpful. The attorney was not getting what he was saying. The attorney was not letting him explain. The attorney was asking him questions that didn't even make sense. The attorney didn't even understand what they were talking about. You don't know what impression the jury is getting from all of this. To me, yeah, it's easy to just, almost smother in the ew vibes that are emanating from the stand from, puffy Eric Clapton here, but you don't know what the jury's seeing. So always the $1 million question. Michelle, they couldn't scan the car while it was on because the car would have to be still. So the car was scanned while turned off. That's an interesting thought. Hadn't thought about that. There would be at least a tiny amount of vibration in the car, right? If the car is moving, or if the car is on, because the engine is moving, mechanical pistons and rotors and all that stuff, and it's heavy, and so it's going to move the car at least a tiny bit. So that would have maybe been a question to ask. I don't know. If they don't know the answer, you're not going to ask the question, but that's a good point. Would that potentially explain some of the distortion in those images? If it was that, the car was on, it was just, vibrating ever so slightly. I don't know. Probably not. Yeah, good point. I wonder if that will be followed up on, but that's a good observation. AP, auto air ride systems constantly adjust during travel. That is the damn point. It automatically adjusts to level the interior, not the exterior. Yeah, the exterior it seems to be just sort of consequential. It's not the point. It's not the point. It's about giving you a comfortable ride. It's about giving you visibility. It's about, giving you the orientation that you're most comfortable in this vehicle. Driving from up high is fun, man. It's fun. It's nice. You're like way up above all these other vehicles. You feel like you can see for miles. I drive my little sports car. It's completely different perspective. I'm not a low rider, but I'm pretty low to the ground, and it's just very, very different perspective. Now I can hug the turn so much better than that vehicle where I'm sitting way up high, looking down on the whole world, looking down my nose at everybody else on the road. So yeah, it's supposed to be about passenger comfort. The effect it has on the exterior is, maybe that's some of what people want. My friend I mentioned from the boxing gym, who's got one of these in his car. It's so you can make it a low rider, and it's pretty cool. It does. It looks pretty awesome. It's a pretty rad looking little car. But for something luxury like a Lexus, I doubt they're trying to, drop it and make it a low rider. It's about passenger driver comfort. Lawyer nurse, this is breadcrumbs setting up for Dr. Wolf of ARCA, as he has lots of experience and certification in Lexus vehicles. Oh, I can't wait until ARCA are on the stand. Alessi is doing a great job. That's my read of it. This is all just set up. You're not going to be able to, like I said, get this guy to admit he did anything wrong. If you didn't catch like a math, like bad math or something in his calculations, if there's no obvious error like that is undeniable that you can point out, then a lot of the criticism and the reason for the differences in the experts' opinions, it comes down to judgment. It comes down to judgment and what's appropriate to do here and what's not appropriate to do here. So it's not something that's real easy to prove or disprove definitively one way or the other. Now, in some cases, maybe there's like a standard. Okay, the standard defines this is what's appropriate. So we can just go and, establish that this standard applies or not, and then what you did. But barring things like that are sort of obvious contradictions. You just have differences in judgment to sort through. And so you're never going to get this guy to admit his judgment's off. You just have to count on these are the things that show or will be able to show when ARCA's on the stand that this guy's judgment is off and that ARCA's judgment is better. So that's what I think they're setting up. And we'll know how good a job he did when we get ARCA, which I can't wait for. I'm just please tomorrow. That would be a great way to end the week. Amanda Lang, vertical height does change width relative to elevation. Vertical height changes width relative to elevation. It definitely does. Definitely changes width relative to elevation. If you have a thing that's, like the tail light this low down here or this wide down here and this wide up here, and then you change the height, now it's this wide down here. So that's going to be a little bit of an issue when it comes to where was this tail light located when you backed it into John's car? And how do you know, and what were your assumptions based on, what it was like at the Canton Police Department? Not sure that's a particularly good assumption. So we expect to hear more about it. Stacy LeBruno, Brennan doesn't care about sound testing. He's counting on this jury being as dumb as the first. If ARCA hasn't tested with a vehicle and arm, my fear is that the jury will pick this guy. Thoughts? If the jury is really dumb, then the jury tends to, decide things on their gut. And so there's a couple of ways that could go. One is that we already have a gut impression about the case. We kind of think she did it. We kind of think she didn't do it. And so the gut level reaction is just pick a team. And whoever's team is on the side of my gut reaction is who I'm going to believe, kind of regardless of whether they're believable or not. I mean, we're just going back to like mental shortcuts, things that are easy to do if you don't want to work through the difficult task of figuring out fact by fact what's the proof of guilt in this case. On the other hand, another very common shortcut for dumb jurors to use is just, who do I like? Who do I like? There's been studies of juries, guys, and jury decision making. It would maybe alarm you to read some of these where they talk about the decision-making process and how it evolves over the course of the trial and what are the dispositive points and things like that. And often, guys, trials are decided by the end of openings. They're often decided by the end of openings, and that's because it has little to nothing to do with the evidence and almost everything to do with who do they like better? Who do they like? If they like you, they'll believe your witnesses. If they don't like you, they'll believe the other guy's witnesses. Sometimes it's really that simple. So, I mean, yeah, there's reason to be afraid that if a jury wants to mentally shortcut the analysis here because it's complicated and it's too hard and it's detailed and our notes aren't very good and we don't get to read a transcript and everything's selective anyway, and all of those limitations that you have with the jury deliberations, and they just want to shortcut it. Yeah, there's a risk that shortcut would work in favor of the Commonwealth. So it's hard for me to believe that anybody would be like, yeah, I like Hank better than I like these people on the defense team, but I'm not a juror. And I definitely don't walk in with a pro-prosecution mindset like a lot of people do. A lot of people walk into a jury selection process with a pro-prosecution mindset, whether like overtly, explicitly, we love to judge people. We love to throw the book at people. We want to string them up. No punishment's too bad. Real solid law and order types. Or even just implicitly walk into the room. Oh, look at her. I wonder what she did. Just that baseline systemic assumption that she's here. Therefore she's at fault. Law and Order, quick because Bev shut it all down. Shameful. Yeah, it's a terrible decision. It's a terrible decision. It's mind blowing to see. One one, the fact that she is herself a former defense attorney, as we know, she's a former public defender. And to just have such little regard for cross-examination and, you know, the need to confront the people who are trying to put you in prison. I mean, how she does not see what she's doing as, you know, tying the defense's hands behind their back. She's sending them out into the ring with a hand tied behind the back and thinks that's a fair fight. It's just very hard for me to reconcile those things. Then in addition, I mean, I looked at her appeal record before, and granted, it was limited to published cases, and published cases are the minority of appellate decisions, and they tend to be skewed towards like big high profile cases or really important or, you know, legal issues of first impression, things that are novel, not so much like your routine day-to-day decision making. Don't have a good record to be able to analyze that kind of thing. But even with the appellate record that she had, this does not seem to be her trend, guys. Her trend is not normally to be so anti-defense. She's gotten in more hot water for ruling in favor of defendants than vice versa, at least in terms of her published appellate opinions. So what the hell is her problem here? Why does she have such a problem with these people? It's so out of character with her normal just kind of pattern of rulings, the leeway that she normally gives to the defense into defense arguments. But here she's like interpreting everything as favorable to the Commonwealth as possible. And so she's running the risk of overstepping where her discretion ends and Karen's confrontation rights begin. So very bad ruling from my standpoint, but you get what you get. You get what you get. Legal realism means you just got to roll with it. And the judge is going to do what the judge is going to do, and you have to conduct yourself accordingly. There's no point at this point in being angry about it, upset about it, anything about it. Your job is to make your record of it and continue to make the best case for acquittal that you can, given the constraints that the judge is forcing you to operate under. And then if you are not able to achieve your success, then we deal with it on appeal. That's when we worry about it and get mad about it. What's going on here? Okay. Mary Frere, is it a strategic move on either side to keep an expert on? Oops. Something's going on weird with my. Oh, is my mouse dying? I think my mouse might be dying. Is it a strategic move on either side to keep an expert on the stand for long days to wear them down in hopes they screw up? It's not a very good strategy if it is. There are definitely some attorneys who are going to have the strategy of wear them down. You know, just lean on them, chip away at them, try to get them tired, try to get them annoyed, try to get them exhausted. I don't personally consider that a very good strategy because one, you very much run the risk that the jury sees you as the obnoxious person and not the witness. But it's may not pay off. It may not pay off. Like you're gambling on something happening, and that something happening being what helps you and wins you the case. But those are like black swan events. You know, we're talking about like you might get a Perry Mason moment kind of thing. It doesn't happen. It's not a good calculus to build your case strategy around. The cross-examination is got to be focused on the information I want from this expert, the information that this expert has, even if it's not my expert, that benefits my case. And if there is nothing, then I should sit down. I shouldn't have any questions. If there's nothing positive for me to elicit from this witness, then I should simply not ask the witness any questions. From a technique standpoint, that's how I see the cross. But some people just are not comfortable doing that. So maybe they would try something like this. You know, let's see if we can wear him down. You really run the risk that you look like the asshole in that situation. So yes, it's done, but it's not something I would particularly, recommend. Sandy B, I think he should have asked, why didn't you demonstrate the two vehicles in real life to see where they touched? I mean, he'll have some reason, he'll have an excuse. It's evidence, her car is evidence and we can't, and whatever. Can't damage John's car. I mean, I don't know. He would have a reason for why they didn't. If it's feasible, they can simply elicit from ARCA that would have been a feasible way to test this. They didn't. I mean, it does seem possible, doesn't it? Did Trooper Paul? Trying to remember if there was something from the last trial, like a last minute Trooper Paul ran out and did something to try to line him up, or did he just look at photos? Now I can't remember, but yeah, if this is a possibility, then they should elicit that it's a possibility, and then you can highlight the fact that they chose not to do that. They once again just cherry picked, what they thought was going to make it most beneficial to their position. Edward Kirkpatrick, look at the edge of the tail light in those collision 2D slides. Real life, it's a straight line. In the scan in his slides, the edge is a huge W. Wonder if somebody is going to have that. Somebody might have that up, screenshotted on X or something like that. So I'll keep an eye out for it and see if there's any kind of like detailed breakdown of the taillight in these scans. I have a feeling there's going to be some eyes on these scans. Just a guess I have. The rural juror. One problem I have with Welcher's Bob Ross moment is Judd is standing in a mid-stride stance, but in a way that would suggest John was mid-stride toward the road, not the house. What are your thoughts? I like the Bob Ross moment, the paint demo. I mean, this is just one of many problems with it. He has arbitrarily selected a posture that works with absolutely no knowledge of what posture John was in. And when I say it works, I just mean he can make it work because he is not an unknowing person being hit by this car. He knows that it's coming. He is reacting to it. And there's no evidence that John saw it coming or reacted to it. The whole, like the foot position and stuff like that, he has to pick this kind of foot position because if his weight's on the other foot, he's not going to be able to take a step over to the side. He's just going to get knocked straight down. So he has to do it. He has to do it in this way, where his right foot is on the ground and his left foot is not bearing as much of his weight. Most of his weight is over on his right foot. That's the only way you can take a step. If all of his weight is on his left foot and he's taken a step with his right, he's getting hit from the right. His left foot is planted. There's nowhere for it to go. He is going down. So, I mean, it's all just selective, what he's done to try to show, hey, here's a way I can make it look. I can make it look right. I can make it work. But he has absolutely no way of knowing what, as he even concedes, what John's position was and so forth. So he runs this one simulation, run the 1,000 other ones where it doesn't. Put your weight on the other foot. Do your little squat thing so you're not having your center. Make sure you're getting hit on the eyelid too, by the way. Okay, because that's an important part of this demo. You got to explain that eyelid laceration. So didn't see that happening in the video either. I mean, the whole thing is a train wreck. A lot of problems with that paint test, and I can so relate now to why Alessi was just dumbfounded that this was going to be allowed. When he challenged this, and not so much as a Delbert Lanigan hearing. Okay, The lady who has written studies about dog bites and seen thousands of dog bites and treated thousands of dog bites has to come have a 2-day hearing about whether she can testify about dog bites. This guy can play paint with numbers and no question whatsoever about the reliability. Of course, it's mind-blowing. The whole thing is just a disaster. It's such a mess. A geezer. Did they account for the height of the snow that Karen was backing over? I don't think there was enough snow in the driveway to really make a difference. It looked like it was just trace still at that point at the 5:07 in the morning. So they probably didn't. Would it be enough to make a difference? Maybe. Maybe. Josh H. Day 23 of trial, presumably the last Commonwealth witness, still no evidence John O'Keefe was actually hit by Karen's SUV, just some maybes. No, well, now we have a null hypothesis. We have a null hypothesis. Never heard how he disproved that null hypothesis with all of his testing. How did he test the universe of possibilities that Karen Reed did not hit John O'Keefe with the car? He didn't. He didn't. He looked for a way that it could happen and then said, therefore, I think it did. So he actually did like exactly not null hypothesis testing, but it sounded good, right? The word sounded good on the stand. It reminds me of how Brennan argues. Brennan just argues yesterday. He gets up during that voir dire. During that voir dire, he gets up and he's like, did you know that the source of this document was actually the CERT report, which was taken on X date by, you know. You made all that shit up because it sounded good. You made all that shit up. As Mr. Alessi pointed out this morning, CERT did not take a drone out there. CERT went out there at night for one thing, and that's all they did. So... but it sounded good, so he'll say the words. And I think they're very similar that way. Very similar that way. It serves the purpose, so they'll say it. 7, why didn't anyone ask how the taillight even broke? The physics it takes to break into 47 pieces. I don't know. Maybe we'll get more from ARCA about the material quality of the taillight. And I mean, we know that they tested it in terms of, you know, doing the Canon and looking at the different forces it was going to take, different speeds and the force generated and so forth to break the polycarbonate. So maybe they can break that down a little bit more in detail about how does this material break? What's the pattern going to be like? And not just with the material, but also, again, going to the physics of the accident. If momentum is operating on these taillight fragments, which I would expect they are, because momentum, you know, operates affecting everything on Earth, everything material on Earth, then they're going to want to stay in motion, right? If they're backing up, sudden stop, they're going to want to stay in motion. So we, you know, seems like we would expect some sort of like spray pattern for the taillight pieces. But if the collision is taking place in the yard, then, or in the street, then you would expect that pattern to largely be focused in the street. And yet nearly all of this taillight was found on the grass. Very little was found in the street. And what was in the street was only in the little 1 square foot area that O'Hara testified about. So maybe we'll hear more about this from ARCA. We'll just have to see. Donna ST, Alessi planting the seed. It's photoshopped. He didn't just make that up. He didn't just pull that out of nowhere. There's a reason why he's asking. So somebody thinks it's photoshopped. I don't know who. I don't know why, but it has my attention. So we'll see if he can deliver on that. Dawn on me. So how will the defense be able to prove the key cycles? I think they can still work backwards. They know that the mileage, it's in Welcher's report what the mileage was when Trooper Paul had the vehicle. So I think the only question, the only fact that isn't really established is what Trooper Paul claimed his key cycle was. He said it was 1164. So they just need to be able to do the counting again, like they did in the first trial. And might be able to get it in through ARCA. You know, like I said, ARCA reviewed everything that Trooper Paul did, and that was part of their basis, part of their analysis. Then they should be able to go into it. I don't know why not. And if they're not allowed to do that, then your option is to call Trooper Paul. Call Trooper Paul, put him on the stand, and let him be the one to say, I was wrong about it being key cycle 1164. Is he going to fall on his sword and say that? I don't know. None of these guys seem real eager to be the one that made the mistake. All seem pretty eager to justify their own decision making throughout the course of the case. So they just need to get those predicate facts in. I think it's ARCA or Trooper Paul. Donna ST, yes, he is like Dr. Hughes. I'm glad I'm not the only one that it was very vivid for me. So similar to Dr. Hughes, where the baseline assumption is just so built into everything that's said that everything is loaded. You know, every answer is loaded. You've already decided there was an accident, that there was a collision. And so your explanations are frustrating because of that, because you're not actually accounting for the possibility that there was no collision. You're saying you did that, but what you're showing us is showing that you didn't actually consider that. Nasir Puto, Welch won, but at what cost? You know, win, lose. He might have won the battle. He might have won the battle in the sense, again, that he didn't get blown up on the stand. But that's like kind of honestly the bar for competency for an expert. Shannon Burgess should not be the norm for an expert witness. Okay, you should not be able to blow a witness out of the water like this, because they shouldn't be committing those types of own goals. That's not really the expectation for what a good cross is. Most experts are going to be far more effective than that. They're not going to make those kinds of mistakes. They are going to be confident in their decision making and in their process and so forth. So, you know, if again, it's just what is a win in this situation? If a win is kind of going on our instantaneous satisfaction with the process, did he destroy Welcher? Absolutely not. Absolutely not. But you don't really expect that. Like, if that's your standard for a win on cross, you're not going to see very many wins on cross. You're just not. So yeah, he was able to get his explanations out and his answers and stuff like that. But the question with the cross and its success, I think, is with an expert anyway, it's just always going to depend on how it ages. You know, if we define it instantaneously, no, sitting here right now, we could be like, yeah, Welcher won that one, but we don't know until the game is over. The game isn't over until ARCA testifies. Kitten Fire Department. I can't believe MSP rigged the testing with bias by not telling Welcher the bumper glass does not match the snow glass. Well, it's in the report what they did. He said he read the reports. He just apparently missed that part. Well, he understood it was inconclusive. Well, you never asked for any follow-up. Never asked for any follow-up. Just went ahead and went with the assumption. Must be the same. They couldn't prove it was, but therefore we've disproven the null hypothesis. I mean, what even is this? Yeah, I don't know if this is MSP rigging it or if this is just Welcher's own way of you know, ignoring the stuff that doesn't fit his theory. Laura Potter, Bev gives Major Cornelius Fudge Order of the Phoenix Energy. I haven't read these books. So Don't get the reference, but I'll have to look it up. Let's just look it up. Cornelius Fudge. Cornelius Fudge. And I wasn't really into Harry Potter. I read them at one point, but they didn't have a huge impact on me. Mr. Cornelius Oswald Fudge was a British wizard who served as a 32nd Minister of Magic for the British Ministry of Magic, in office from 1990 to 1996. Although reliant on the advice of Albus Dumbledore at first, by the height of his power, he had complete control of the Ministry of Magic, as well as extensive influence over the publishing of the Daily Prophet. Today I learned. Sounds like a power-hungry guy. Is that what I'm getting? Guy that's drunk on his own authority? Something like that. Vlad Dracul. Brennan just skips half the witness of first trial. Yeah. I mean, he doesn't have to. He doesn't have to call anybody. I'm not shocked. I mean, Lally's case needed editing. There's no question about that. Lally's case needed editing. Now, did Brennan over-edit it? It's debatable. It's debatable. I think in hindsight, it might have been, I don't know, actually. The decision that Lally made to call everybody that was inside 34 Fairview, I think in many ways that was kind of helpful for the Commonwealth, because it really did let them shoehorn the defense into, Karen Reed was framed as your defense. You're going to have to prove it. You're going to have to back it up. And it allows him to kind of force them to do that with these people who would be the motivation for Karen to be framed by, Proctor and Link and all those people in the first place. And it's just very hard to do, to be able to prove that, all those connections, So it put them in a position of highlighting how they, you have inference and you have implication, you have a whole lot of shady behavior that can't be explained. But, turning that into proving a cover up and so forth, it's just other than inference, there wasn't a ton there for him. So it really called them out on that. This time around, they're much more mysterious. Brian Albert is now just this phantom in the rear view. We've hardly even heard his name this trial. Remember how important he was in the first trial? He was the boogeyman in the first trial. It was Big Bad Brian Albert. He's the corrupt cop. He's the guy that likes to hit people, gets in fights. He's a boxer, all that type of thing. We barely even heard about Brian Albert this trial. And my view is that I think that works to the advantage of the defense, because now they're just these shadows and you can project whatever you want on the shadow. It just becomes this question now of who are these people and what did they do and why would they have done this and so forth, instead of directly confronting that by putting them on the stand. Now the jury just wonders all these things. And if the jury gets too much in the habit of wondering about things, they might start thinking, hey, I'm wondering, that seems like doubt. That seems like doubt to me. So I think it was smart to do some editing, but was it all the right editing? I'm not necessarily persuaded. Nasir Puto, let's see if we can get comments like we are ahead of schedule for the defense. Yeah, we can do a poll on that. How long are we going to remain ahead of schedule while the defense is putting on their case? Let me pick the over-under on that. Should we set it in hours or days? Lauren Boborin, should defense start with ARCA? I think yes, and far from rebuttal. I'm sold. I really am at this point. I would love to start with Dr. Wolf. If that can be done, just the counterpoint of this guy being so fresh in their mind and then getting Dr. Wolf as a comparison. I just think that could be potentially powerful before you dilute it by distracting the jurors. Not distracting, but just there's other people now in the interim that they're paying attention to and other things that they're thinking about. And so then when it's time to shift gears and go back to, oh, remember what we were doing with Welcher, it's not as fresh. I think it makes a lot of sense to start with ARCA and preferably with Dr. Wolf. He's just so impressive. Not that there was anything wrong with Mr. Rentschler, but Mr. Rentschler was a little bit more of like a dude, Dr. Rentschler, a little bit more. You could picture him I could anyway. I don't know about you guys. You picture him in the bathrobe with the white Russian. He's like a dude. But Dr. Wolf, very polished, very professional, very good presenter. Trisha the Traveler, did the Commonwealth prove Karen backed into John without a doubt this time around? Well, it'll be up to the jury, won't it? It'll be up to the jury to evaluate how much doubt do you actually have, and is any of that reasonable? I haven't seen it. If you're asking me my personal opinion, no, absolutely not. Absolutely not. Far too many open questions. Where'd that bumper glass come from? I mean, that in and of itself is really enough for me. Where'd that bumper glass come from? It didn't come from the glass. So how did it end up on our bumper? And if you're going to plant that, what else are you going to plant? Not even close. Lori Webster, it's proven because Jen said so. It's like you might have just said that. The totality of the data. And if you're treating things that Jen McCabe said as data, and then you're actually, you're weighing that. You're counting it. Jen McCabe said it, so therefore it's true. TCP, can ARCA talk about Paul's report, or do they need him first? Well, this is the question. This is the question. Judd Welcher was able to testify about the things that he relied on. The materials that he relied on, the work of the other experts and so forth that he relied on, the reports of the other folks, even though it's technically hearsay. And you're not supposed to, in Massachusetts, the way their rule is written, be able to base your opinion on hearsay unless it's independently admissible. Trooper Paul's report would be independently admissible if he testified, just like, Dr. Scorty Bellows is if she testifies. The thing that I found interesting, her report's not in evidence, but like we're able to screenshot her report, put it into Dr. Welcher's PowerPoint presentation. She didn't testify to it. It's hearsay. It was never admitted, but he's allowed to use it and present it and have it be part of his analysis. So the fact that the expert relied on hearsay produced by one of the witnesses does not seem like it has been a bar to being able to discuss that in this particular case, in this courtroom. Welcher was allowed to do it. So if Welcher was allowed to do it, ARCA should be allowed to do it. But as we know, what they should be allowed to do does not necessarily correlate with what Judge Bev is actually going to allow them to do. So I don't know. If you're asking me my legal interpretation, of course they should be able to ask about it. It was part of the basis of the work that they did. It was something that they relied on. It was something that they responded to. It was produced to them by the Commonwealth as the Commonwealth's theory to be evaluated. So of course they should be able to talk about that. But I don't know if Bev is going to allow it. This is our legal positivism versus legal realism moment. In terms of the rules and applying the rules, of course they should be able to. But we're in Bev's court, and she's going to do what she's going to do. The rural juror. I know Alessi will be doing ARCA, but I really enjoyed Wolf and AJ's chemistry. I will miss them bonding about cool stuff. They did do a good job with that. It was cool stuff. That cannon that he got to build. Everybody wanted his job for a minute right there. Everybody wanted a kind of job where you get paid to build cannons and break taillights with it. Every little boy's Every little boy's dream about what to do growing up. If you get to blow things up, you got a great job. Yeah, I think part of what helped AJ is the fact that this was a witness that he wasn't really familiar with. They had the report, but they weren't allowed to do any, deposition or preparation, witness prep, really. So he's just kind of stuck with what he knows and eliciting that. And he's not trying to steer it too much like that. That can be, I think with ARCA, you have witnesses that they've put in the work and they present themselves very well. They present their work very well. Good communicators, good presentation and stuff like that. So I think it just worked out really well because they knew what they were doing and what needed to be done. It was in their report. It was even then, outlined by Dr. Wolf. Here's how to, break it down and present it in a way that makes sense. Although Mr. Jackson said, I don't think that he even got that before he did his direct of Dr. Wolf. But so he's kind of limited. He's limited by the report. And instead of trying to drive the witness the way he thinks that the case needs to go, you just trust the witness, trust the expert to have made some of those key decisions for you. And all you got to do is let him shine. So I think that worked out very well for Mr. Jackson last time. Mr. Alessi is going to bring a different skill set. He's going to maybe be able to nerd out with these ARCA guys in a way that, we can only dream of. Martha Chapman, any chance ARCA will have photo analysis that will prove the traverse was repaired? Think art exhibit that shows Degas original drawings painted over. Maybe. I don't know if there's tools for stuff like that. I mean, the Degas painting, we're talking about oil paints and like what's, underneath an oil paint and stuff like that. And that's not uncommon because back in the day, the canvases were rare and, harder to come by, more expensive. And so you would reuse canvases a lot. You just paint over something that you'd already painted. And so they've been able to discover now several artists, I think Van Gogh, maybe, I can't even remember now, but several artists would do that. They would paint over old paintings on canvases that they had. And so you can, there's like ways that they can scan it now and detect there's something else. There's a different image, beneath this thing that got painted on top. Automotive paint is very different material, than oil paint. But there might be some way to test that. Might just depend on what kind of repair you needed to do. If all you needed to do was pop a dent and buff it out, it's probably not going to show up. But if you had to go in there and do some metal repair, use a little Bondo, that might show. If you had to go in and sand it down, repaint it, refinish it, something like that, that might show. I don't know. I don't know what is available for that type of analysis, but I guess we'll just find out. Summertime, what do you think defense needs to do in order to get acquittal? Did Commonwealth meet the burden of proof? Thank you. I mean, the defense, of course, has options. Defense could rest right now. We're not going to do anything at all. We're just going to hang our full hat on the Commonwealth has not met its burden of proof, and we're calling that good. That would be risky. In my opinion, not because I think the Commonwealth has met its burden of proof, to my satisfaction, but there is a risk the jury would see it. And why? Because of those mental shortcuts. Well, the taillight was there. We don't really have a good explanation. And she was there and she was drunk. So she probably hit him. You have that risk that they would be leaning in that direction. So no, they don't have a burden of proof. They don't have to do anything, but they really do, at least implicitly, have the obligation to follow up on the commitments they made in their opening. And the opening is when they told the jury, this is why you're going to believe us at the end of the day. And so it's just not a good idea to not follow up on that, to leave those promises undelivered, in part because if I'm the opposing party and you do that, I'm going to be pointing out to the jury that that's what you did. That you got up here in opening and you said that they said you were going to hear texts that Michael Proctor sent to his buddies, and you didn't hear any of that. They never showed you any of that. You heard from the defense that Brian Albert and Brian Higgins were butt texting each other the next morning, butt calling each other the next morning, like 2 a.m. They told you were going to hear that. You never heard that. I'm going to be pointing that out if you don't live up to your commitments that you made in opening, because I'm going to be using it to suggest you're not to be believed. Your case is built on a house of cards. And you're just hoping that your inability to draw the ace in the hole, the jury is going to overlook that. If you didn't draw the ace in the hole, your house of cards is going to topple, and you're just going to hope the jury didn't notice that you didn't draw that ace in the hole. But they told you in opening exactly how they're going to show you that, exactly how they're going to make their case that Karen Reed is innocent, and they didn't deliver. So that's a huge risk. At a bare minimum, you got to follow up on the commitments you made in your opening statement. But I think in general, their strategy in this case is far more leaning into the burden of proof than it was in the first one. The first one, they really focused on the Karen Reed was framed. And I think that does. It just implicitly assumes a burden. It implicitly sets up a binary kind of situation where it's like either you're right or you're right. Those aren't the only possibilities, but it's the one that you kind of set up when they say Karen hit John with a car and you say, no, Karen was framed. Okay. It sounds like it's a one or the other type of decision. So by not going down that road this time, they're taking so much more advantage of all of the other possibilities in between Karen hit John with the car and Karen was framed. It was an accident and nobody knew. It was, the people in the house didn't know, but, Brian Albert and the dog came out and it was all just, nobody meant for him to die. And there's just all the ways you can brainstorm what happened to John. Those are now still on the table because we haven't kind of put the jury in the perspective in the standpoint of having to kind of choose, well, did Karen Reed frame, or did the police frame Karen Reed, or did she kill him with the car? So, they'll lean into the burden of proof. It's a structural advantage they have with the way that they presented the defense this time. It is a good argument. It's kind of always been the argument anyway. Even if we think Karen Reed was framed, it's hard to prove that. It's hard to prove that. That's the whole point. They didn't do the investigation to prove what really happened. So you don't have the data. Not having the data was the whole point. But, drawing out the sketchiness of the investigation, pretty important, I think. But I don't know. I'd say the bare minimum here is live up to the commitments made in opening. Kitten Fire Department. Was the entire Commonwealth case circumstantial? With no physical link between John and the vehicle, it seems like they want the jury to just infer a collision. Yes, this is absolutely a circumstantial case. Even if they had a physical link between John and the vehicle, it's still a circumstantial case. They do, in fact, have a physical link between John and the vehicle. They got that DNA mixture on the taillight, right? That Dr. Welcher wanted to make a big thing about. Ignore the other two people in the mixture, okay? They don't matter. I don't care about them, but John, we're going to care about. Why are we caring about one versus the other? Because we don't want to draw the inference that the other people have just as much of a relationship to that taillight as John did when those people were presumably not hit by Karen's SUV. Even that physical link, though, is inferential because you're being asked to draw an inference about why is it there and how did it get there? When did it get there? And that's what circumstantial evidence is. Direct evidence means there's an eyewitness who saw it happen It means it's on video and you can watch it go down, or it means somebody confessed to it. That's pretty much the only way you get out of circumstantial cases and have direct evidence of something. Everything else you're inferring. You know, you have a wound in a chest, and you have a knife at a scene, and you have a trail of blood, and the trail of blood goes to the couch where the person is sleeping, covered in blood smears, you know, all over their hands and in their face and their body and so forth. It's an inferential case. It's not direct evidence. So yes, it is an entirely circumstantial case. Jacob Turnbow, if I was Wolf, I would start some signal chats with the DOJ. And when Brennan asks if I used it for people other than the defense, I would say FBI. That would be funny, wouldn't it? That would be funny. I like how you think, Jacob. That's very clever. Sentient Dreamer, speculate between biased Bev and corrupt Bev, please. I still lean on biased. I do. You know, corruption means something very specific, and I don't see enough here personally to say that she's anything more than just an extremely biased judge, the kind that you don't like to run into, but they're not uncommon. They're just not uncommon. They're stubborn. They're arrogant. They have, you know, very inflated sense of their own authority and self-importance and so forth. And she's just made up her mind about what she thinks the right outcome is here. And she's going to put her finger on the scale to make sure that that happens. I don't have anything that would tilt me from that towards she's literally conspiring with the Commonwealth. It's possible, but I'm not going to say, you know, that seems likely, or she's been paid off, you know, or something like that. To me, I don't see enough to get us outside of the realm of just, she's just a bad judge, guys. And unfortunately, it's not that uncommon. It's not that uncommon. I will maintain, I will definitely continue to maintain that she is nowhere near the level of monster on the bench that we saw in Delphi. She doesn't even enter that universe. Bev is just a kind of routine, not very smart, kind of malicious, kind of control freak, makes up her mind and then is going to be right no matter what kind of judge. That's my read. That's my read. But that's just me and my thoughts. I understand a lot of people have different views and different reasons for thinking that, and that's, you know, not unjustified. I get it. I know she's friends with Morrissey and that weird payment from Julie Nagel and all that stuff. I get it, guys. I do. It's just not enough for me personally. Isabel Park, I'm from New Zealand. Could we do our well-known traditional haka in front of the prosecution? It won't be friendly. Well, that would be fun to have New Zealand witnesses come in and do the haka, the prosecution, do it as part of closing maybe. No, it would not be friendly. And sure, more than a few people would appreciate that demonstration. Andrea McBurnett, Hank's closing clip proves Welcher based his theory on Karen's words and not data and science. What a waste of $400,000. Gives it all away, doesn't it? The head fake. Gives away the head fake. This case was never about fact, science, and data. In fact, Mr. Fact, Science, and Data that you said was going to support your theory, your own expert has testified you don't have enough information to know pretty much anything. You don't actually have fact, science, and data. Your own expert just gave it away. He ratted you out. So we know this is actually about I hit him. We know this is about Karen's words because you don't have the data to prove it. So it's just going to be a question of, is the jury going to weigh Karen's words heavily against her? Or is there going to be other evidence that tends to show that Karen's words aren't correct, aren't valid, that isn't the right interpretation of them, you know, whatever. They got a lot to work with. Tell you, the defense has a ton to work with here. You dream sometimes as a defense lawyer having as much to work with as these guys have to work with. I tell you, do some time in the public defense trenches and you'd love to have like 1/10 of what these guys have to work with to put on a defense. Jen Lux with the super chat. Thank you so much for that, Jen. Appreciate your support. Pure jealousy. In my opinion, defense witnesses are more likable. Jurors care. Jurors can absolutely care about who they like and who they don't like. And that's just normal. Just normal. We all do that. And there's just another one of the mental shortcuts we make. We think that guy looks good. We probably like him. We probably think he's more competent. One of the advantages Dr. Wolf has in this whole scenario. We like the tone of that person's voice. This other person has an unpleasant tone of voice. I mean, we'd like to think it shouldn't matter, but the reality is it does. This is perhaps our positivism versus realism type of distinction again for today. It shouldn't matter, and people shouldn't judge based on kind of superficial sorts of considerations. But if you pretend that just because they shouldn't do that they actually aren't doing it, you're going to have a hard time because people are going to do that even if they shouldn't. Nicole K, does defense get to play any clips that Commonwealth played from interviews? Also, I'm more nervous than last trial about a guilty verdict. Are you? No, I can't say I am. I can't say I am. I think we're still largely in the same position of it takes that mental shortcutting and the just kind of throwing up our hands and like, well, we don't know what happened, but she was there and she was drunk and that's where they found him. So it was probably her. Like that's still to me the easiest mental shortcut in all of this. If we don't want to have to solve the problem of, how'd the taillight get there and when and the clock discrepancies and so forth. There's just so many details you could get caught in if you're so inclined. If you're not inclined to do that, very easy shortcut. And that's the same thing as we were in last trial. But I think the big difference this trial, we got a lot more doubt to work with. We've just positioned the case a lot better to be able to focus on all the things you don't know. And instead of trying to turn it into a definitive, the fact that you don't know about the taillight means that Karen Reed was framed. We don't have to go down that road. We can have all kinds of explanations for the taillight. The bottom line is we can't put a lot of weight in the taillight because the taillight wasn't properly handled. And you can't, they're pulling stuff out of the bag that they can't even identify. Twice we see this. 3 times if you count Buchanan with the shoe. They're like, I don't know what this stuff is in the bag. Oh, go ahead and take it out of the bag now and admit it. It's a mess. We don't have to tell you why it's a mess. You just need to know that it's a mess. And so you're being asked to make all these inferences about it from the party who couldn't be bothered to follow their own rules so that it wouldn't be a mess. That's why you err on the side of Karen Reed. So I think that they have more of that advantage to work with this time. As far as playing the clips, any clip that's already in evidence, the defense should be able to replay it. The question is whether they can introduce new clips, and that is not clear how they were handling that. If they negotiated kind of clip by clip, what was going to be, rule of completeness, what the defense gets to add on to whatever Brennan wants to present. Instead of just presenting what Brennan wants, they say under the rule of completeness, we need more context. They may have negotiated that clip by clip. If she took a narrow view of the rule of completeness, meaning, Karen gets to finish her sentence or something like that, you can't cut her off mid-sentence, then that's probably how they handled it. If she took a broader view of the rule of completeness, then Karen may have the ability to present her own clips as well when it comes time to doing her case. So we don't know at this point. That hasn't been done in the public eye. Melanie Gore, if they split the baby, what is that charge? It's probably the manslaughter. It's probably the manslaughter. That's why you overcharge somebody in the first place. Charge them with something you have almost zero chance of proving, so that you are positioned for the compromise verdict that's not as serious, but it's still a conviction. But it's not as serious. So if you're going to split the baby on a charge and with a conviction in this particular case, I think it's going to be vehicular homicide. We'll see. We'll see. TB85, shut up, has me dead. I just, sometimes I can't help it. I'm at home, so he can't hear me. I'm not in court. I don't need to have court decorum. I can tell the witness when he's annoying as hell. Just shut the fuck up, dude. Nobody cares. Dan Greenwood, the whole prosecution has been photoshopped. Kind of the corruption equivalent of, bumper sprinkles, materializing apparitions in and out of the Sally Port. Yeah. Melissa Garcia, I bet the Mythbusters can do better than Aperture. Mythbusters are pretty good at blowing stuff up and running things into other things and collecting data and analyzing it. So wouldn't surprise me if Mythbusters would be more comprehensive in what they did than Aperture. Rotorman Dan, if I were Alessi, I would call Paul next to clarify the key cycles. That trigger event the Commonwealth claimed was the event that killed John was more likely when they loaded up the SUV 1162. That would be a possible way to do it too. Get the foundation in for the criticism of the key cycles with Trooper Paul and just establishing you used it. You used 1164. 1164 was at this mileage. That's all you need from him. So that's a possibility, and then handle the rest of it through ARCA. But yeah, I mean, Alessi told us this morning in this argument, no, this is not a surprise. This is nothing new. They went down this road in trial 1. We already know there's a problem with the key cycle count. It doesn't math. It doesn't math. You can't make it work in terms of the number of times the car has been turned on and off. So whatever they need to do to lay that foundation seems like a good idea to me, because I think that is an important piece of the case. It's 1162 trigger event. Why are they even looking at it? Why are Welcher and Burgess even looking at it? We're supposed to buy that they just independently looked at all the text stream data and decided, oh, this 1162, that's the one that fits. No, they said they did it based on the mileage. And that's the one that they thought fit based on the mileage. They got the mileage from Trooper Paul. So, I mean, they should have been able to go through all that, but yeah, it's annoying when you have a judge that is going to, not just be inconsistent with the rules, letting the Commonwealth do things that she's not going to let the defense do, but then just being so micromanaging and hyper technical about the requirements. It's very, very obnoxious. 11-2 Limes, aren't they done at 1 p.m.? Won't they just end now? Yeah, they did just end. They had like 90 minutes left. Go ahead and just come back tomorrow. Nick Starrow, every test Welcher didn't do that he claims couldn't be done, and ARCA can. I want the start of every answer to be yes. It was very easy and simple to test. Yes, and in fact, we avoided a lot of the problems that plagued this analysis because we did this. Things like that would be fun, wouldn't it? Yeah. Yeah, we did in fact hit the crash test dummy with the exemplar Lexus over and over and over again. Simple as that. Yeah, I'm with you, Nick. I think that would be a lot of fun. I'd love to see it. And not just that they did it and it can be done, but let's not forget Aperture was paid $400,000. And this is what they did. We've been paid so far, we know about $25,000. Here's what we were able to do. Potentially some room for comparison there. What does your money actually get you when you hire Aperture versus when you hire ARCA? My Mini 67, the occiput boner. To a reasonable degree of engineering certainty, it is a clown show. It's such a ridiculous little hocus pocus. It makes the legal system look ridiculous. In my opinion, it's just one of the reasons why I have such a problem with this idea of like you have to formulate it in this magic words kind of way. It makes the legal system look ridiculous because any engineer is going to know this isn't, you want to talk about your question doesn't make sense. Okay. What is engineering certainty? What does that even mean? Potentially criminal. I wonder which subreddit Welcher moderates. I don't want to know. I don't want to know which subreddits that vaguely creepy guy is moderating. Rotorman Dan, the 21 Lexus LX570 lowers itself depending on conditions and settings the driver can punch in. I wager she had it in full height settings for snow mode. It would have been likely in highest position. Yeah, get better clearance. Makes sense. I mean, we saw her just in that drive in Dighton. The drive in Dighton. And she's having to plow through the snow and she's got at least, looks like 8 inches, 6-8 inches, clearance to the front bumper. Would make sense. You're going to be driving in the worst blizzard in Massachusetts history in January. You're going to be driving through that. You're probably going to make sure your clearance is as good as you can get it. So that makes a lot of sense. Greg, I kind of have a hard time getting excited for ARCA. Bev's going to sustain their entire testimony into the abyss, and it'll be like it never happened. There is definitely going to be frustration with Bev. I don't think there's going to be any way around that. We know that Hank is going to be obstructionist. He's going to object a lot. The old opinions, probably not so much leeway to do that, but anything new that they've done, he's just going to be objecting over and over and over. It wasn't disclosed, Rule 14, this, different, Oh, there's going to be some nightmare components to it. Never fear. Never fear. That's not ARCA, that's the judge. I mean, we're going to get what we get from the judge. Oregon Joe, null is opposite of what you're trying to prove. If null equals no accident, it means you're trying to prove an accident, not the other way around. You assume null to disprove. I'm pissed. See, this is like the level of detail about what that kind of thing means that I don't necessarily have. I don't know which one you start with and which one you don't. It does make sense to me when I take it back into that kind of pharma realm, that if I have a drug and I'm doing a test on a drug, what I'm actually interested in is does the drug work? I'm not interested in does the drug not work, except to the extent that that tends to prove that the drug does work or not. So yeah, I want to know if the drug works. So my null is that the drug does not. I mean, that's how I understand it. Makes sense. Makes a lot of sense. Interesting little tell there. If anybody on the jury has a technical background, the kind that would understand that type of thing, I wonder if that caught their attention. Lawyer Nurse, I'm still wondering what his methodology was and why he thinks it's okay to use evidence 50 years old. I want to critique his references as I bet they're all old. Even the injured PED shown did not say the height of that vehicle. No, it's true. It didn't. It's very limited information about this, sort of similar, but also very not similar incident. The methodology of proving that a guy can get hit by a car and die and not have a bone broken, not have a leg bone broken, for example, is not at all proof that somebody else wouldn't go through that same collision dynamic and get a broken bone. We don't know if this guy is the extraordinary tough skeleton guy or not. It's just, you know, the logic doesn't even follow. There's no necessity that flows from a conclusion that this guy didn't have broken bones in his legs on this one occasion. This is nothing about other occasions. The whole thing about the accidents, the injuries from the accidents and his data being 50 years old, that's a little bit of an own goal. Like, yeah, you need to update your medical information if you're still relying on 1979. Been a lot that's happened. In data collection, data analysis, just the understanding of the human factors and stuff like that. A lot more that's known today than was known back then. Yeah, what was his methodology? Well, it seems to be, now we know, assuming that there was an accident and then having this null hypothesis of there was no accident, and thinks he disproved the null hypothesis, or says he did, but doesn't show us how he did it. So his methodology, just to break it to you, is Ipsy Dixit. John Beattybot. Point of soft plastic bumpers is to squish inches. Yeah, the bumper is supposed to have some give. It's the crumple zone. It's the whole point of having the crumple, so it absorbs the force and doesn't transfer it into other parts of the vehicle. So the whole point is to be a little bit collapsible, a little bit flexible, stuff like that. Absorb it. What were they talking about yesterday with the? He's talking about. They talked about the load distribution, but then they were also talking about how it affects the acceleration. And I was trying to think that through in the sense of like, okay, but you have like falling into styrofoam peanuts versus falling against a concrete floor. The one is going to slow you a little bit more. So maybe that's what he's talking about with that relationship. Similar type of thing with the plastic bumpers, right? The plastic bumper is going to be a little bit more like the it's going to be a little bit more like the peanuts, because that's the whole purpose, is to make contact and slow you before you come to a full stop. Robin Hall, I dream that one day someone will love me as much as Welcher loves pontificating. Well, I want that for you too, Robin. It's good to have high dreams and expectations. Catalina, how is the Commonwealth allowed to sprinkle those clips, cut up however they want throughout the trial, not all at once? Seems like it's a really weird rule, because Bev is letting them do it how they want it. Normally, you have to have a sponsoring witness to be able to present something like video evidence. She's not requiring it in this case. Not clear if that's because she was going to allow it anyway, or because the defense has stipulated to let them do it this way. Yeah, it's weird. It's very weird. It's very weird. It makes him look like a, carnival showman, a carnival barker, right? And now for my final act, we have, the elephant going through the flaming hula hoops. It's the impression it gives me. Occiput boner. Does Karen choose a ride height? Driving to Dighton through snow would be highest setting, so the setting at Canting PD would be wrong. Testing moot. Yeah, this is a good observation. It does make sense. You're going to drive through that massive amount of snow. Yeah, you're going to have it up as high as you can possibly go. So makes sense that that's where it was. And was that where it was when she drove to Fairview? Who knows? The conditions are not the same. We don't know her habits. I don't know if there's data for any of this that could be downloaded somewhere that would say, I'm assuming not, because surely it would have been accounted for, but don't know. Moira Carey, Andrea, why do you think Hank said they could try to call Trooper Paul? Sounded like they might not be able to. What's your take on this comment? My take on it is that it means Trooper Paul is not yet under subpoena. That's my take on it. And so he's implying that they may not be able to get him under subpoena, and that they may not be able to like coordinate a time when he'd be able to get there. Trooper Paul may just coincidentally be scheduled to be on vacation this week, and maybe next week too, and maybe for the next few weeks. And it's just an unfortunate thing because he didn't get subpoenaed, so he didn't know he needed to make himself available. Something like that. But that's my interpretation of it. They may be able to, or they could try to call Trooper Paul because they'd have to get him under subpoena. If he was already under subpoena, there's no try. There is just making the phone call and you will be there, or the folks who serve the material witness warrants will be showing up to make sure that you make your appointment when you're expected to be there. That's my interpretation of it. They haven't subpoenaed him at this point, so they would have to do that. Lucy Fair, what about force required to shatter polycarbonate? Glancing impact explains lack of injuries, but contradicts tail light. They want it both ways. Thanks, Andrea. This is why I kept being like, can we talk about Newton's third law at some point? Can we talk about the third law at some point? Because if John and the tail light are colliding, then the force that's acting on John is the same force that's acting on the tail light. And so we need to have some kind of convergence here between the amount of damage on the tail light and the extent of the injuries on John, other than just it looks like they match pattern wise. So I think this is a very good point. It's exactly the kind of thing that should be something ARCA could get on the stand and say, yes, this was actually very simple to do because there's a lot of information. There's known stuff about the material and its tolerance. There's tolerance testing from NHTSA from when they, manufacture, when they design and manufacture this Lexus. I don't know what's out there, but I kind of always assume with automobiles, there's tons of data out there about design and tolerance and things like that. Yeah, I would think so, because if it's going to be enough force to shatter the polycarbonate, then that's the same force that's going to be acting on John's arm. And so what would be equivalent? Emily Morgan, can't the defense bring up Trooper Paul's report through their own experts, ARCA or DeSogra, if they reviewed it? In a normal universe where the rules are being applied equally to both sides, yes, they absolutely should. Will they be able to? That's the $1 million question. Luke Fitz, was the 8 miles an hour to break the taillight anywhere on direct? I don't believe it was. I think that just came up. On Cross. And he said that as little as 8 miles an hour. I'd have to go through like all of my notes from the last couple days. So I'm not going to do that right now, but my gut reaction to this is no, it did not come up on direct. He brought that up on cross-examination. TCP, with regard to the hearsay in the PowerPoint, would justification for it being allowed be that you didn't object at the time? Well, I mean, what's at the time? We already know there were lots of objections to Welcher's PowerPoint and stuff in it that was objectionable. They had a whole argument about that, and Welcher was going to go revise his PowerPoint and remove the stuff that was inadmissible, and then he didn't do that. So I don't know if there was a specific objection to like Dr. Scorty Bellows' cut and pasted portion of the autopsy report. But I'm also, I guess, not 100% convinced there needed to be. If this whole issue of it relies on the inadmissible hearsay stuff is already like the general issue is being addressed. But, Bev being hyper-technical possibly could, hey, in limine rulings, they're just preliminary anyway. Hey, we caught yesterday when she told us how she wasn't going to, I got to find that ruling. She came right in the morning and said that he can, wait, no, it wasn't that ruling. God, what am I trying to remember here? when she said, what exactly did she say? There was no objection at the time. Oh, it was yesterday. It was yesterday when she walked in and said he's an expert and his testimony is based on reliable methodology and there's been no objection to it. And we're all like, there was an entire motion in limine and request for a voir dire, a Delbert Lanigan hearing. Of course they objected to it. But guys, if you want to be really, really super technical, lots of times a motion in limine, it's not a final decision. It's considered preliminary. So for example, if you want to go and appeal a decision to exclude something, motion in limine might not preserve it. There's many, many cases that will say if you don't renew your objection at the time of trial, you may have waived that issue. So it could be something technical like that. You know, if she's already hinting at perhaps that, when we all know, there was an entire Delbert Lanigan challenge to Judd Welcher. Of course, they challenged his methodology and his reliability. But I don't know if they renewed that at the time of trial. If she's thinking in those types of technical terms, then maybe she's thinking about it in this context too. Hey, you objected generally to his slides containing hearsay, but you didn't object to this particular slide and this particular incident of hearsay. Maybe. Shireen Johnson, YouTuber Be in Trouble 31, shows a test of car reversing and hitting the arm and breaking a bone. Yeah. Be in Trouble 31 has like been our test guru for so much of this stuff with the car, with the taillight and everything. I haven't seen the arm video. I did hear about it. So thanks for bringing that up. But does it surprise me it would break an arm? Absolutely not. It's a thick 6,000 pound vehicle, 20 some miles an hour. Of course it's going to break. Of course it's going to break the arm. Melissa R is a new member. Welcome to the channel, Melissa. T. Shaw, at 24 miles an hour in reverse at 75% throttle, would the suspension lower 2 inches? He is 1.5 inches shorter than John O'Keefe per Welcher, so his reenactment would be 3.5 inches off. I thought he was 1/2 inch shorter. He was 6'1.5" and John is 6'1". That's what I thought. But he is slightly off. I have no idea, you know, if the suspension adjusts automatically, I have no idea what's going to make it, you know, go one way or the other. In general, the car is lifted higher. The car is going to be more top heavy. So the car is going to be less stable on things like turns and accelerations and in the wind and stuff like that. So I don't know if the car would automatically adjust for that type of thing. It might, but I don't know really one way or the other. So we're gonna, I think, have to wait for ARCA to tell us a little bit more about the, or maybe DeSogra, you know, some other defense witness to tell us a little bit more about the characteristics of Karen's vehicle. Brent Mack, please do Andrea a solid. She give us the best coverage of this. Give her a thumbs up. It's free. Andrea Jeff Mods, thank you, kids. Don't be a Mr. Bungle like Brennan. Hit the knowledge button, foo. Thanks, Brent. Thanks, Brent. Appreciate you looking out for me there. Like having the support, you know, acknowledge the stream is great. Appreciate you giving us the call out. Jim Tussing's a new member. Welcome, Jim. Appreciate having you with us on the channel. Tis madness. Will it be difficult for Judge Bev to field future juries because so many of us now have no regard for her ability to be ethical or fair? I guess it just depends on how pervasive this trial watching is. You know, it's one thing to be aware of the case, see it in the news, follow the reporting and stuff like that. And it's quite another to be deep diving it to the level of kind of being aware of what Bev is doing and how it looks bad and stuff like that. So it probably just depends on how pervasive it is. I do wonder if this would come up in voir dire. If you have if I am evaluating a jury and we're going to be in front of Judge Cannoni for this trial, and we have just had this high profile case that's been televised, yeah, I'm probably going to be inclined to ask the jury, any of you watched that trial? And if you get any ideas from that trial, have any biases against the judge, any ideas about the judge based on that trial? I mean, it's going to be something you're going to want to explore. So I can see it coming up. Is it going to be a problem? I think that just depends on how pervasive the deep level interest is. Russell Jones, Bev's multi-generational ties to Morrissey go back far enough to explain her awful rulings. It might. It's just that Morrissey is a constant in Norfolk County. That's the case. He's present in every Norfolk County criminal prosecution, at least since the time that he was elected. So it doesn't explain why is she behaving so differently in terms of her rulings in this particular Morrissey case versus all the other Morrissey cases where she made defense-friendly rulings and got reversed on it. It doesn't explain that difference because he's the common denominator in Norfolk County. She's a judge in Norfolk County. So that would be the case all the time. But it doesn't seem to fit the pattern that, this is deviating from. Sentient Dreamer wanted to understand difference between bias and corrupt. Thank you. Oh, if I if I got maybe a little too down the rabbit hole with Bev about that, sorry. The bias is just your inclination to, favor one side or the other. Corruption, at least in the legal sense, means you're getting a benefit for going one way or the other. Classic is a bribe. Classic corrupt official is a bribe. You get bribed to do something rather than to apply the law the way that you're supposed to. It's a problem. Obviously don't want that happening, but it's also, much more distinct and kind of less common than just judges having a bias. Judges being in the courtroom, seeing the same people every day, getting to work with this prosecutor, getting to know how things go, getting the pattern of things, deciding who they like and who they don't like. Seeing the volume of cases that come through and kind of making judgments about, most of these people are guilty. Oh, most of these people are being abused by the police, things like that. Those are what trigger bias. But corruption is real specific. Phobos 258. When they kept zooming in on the bumper, there was a reflection of a blue sky. How was that picked up in a 3D scan? Clearly photoshopped. I didn't see a reflection of the blue sky. I have a feeling there are going to be screenshots all over X today. So we'll see. We'll see what folks can sink their teeth into with those scans. Josh H. Didn't Welcher testify he got the suspension height from 2-1? Isn't that from Trooper Paul's report he said he didn't rely on? I don't know if he got it from the report, if that's what he meant, or if he just meant nobody's changed it, so he turned the car on and it went to where it was. And he just assumes. I mean, I don't know. I don't know enough about how this car suspension works. If there's like a default that you change or anything like that, I mechanically don't know really what the options are for being able to move the suspension. So I don't know if he got it from the report or if he, got it from the car. If the car just reset, I don't know. Of course, there's been 100 key cycles between the time he got a hold of it and the time that Trooper Paul did his testing. So probably it wasn't that. That would be an extremely bad assumption at that point if that was the case. So yeah, maybe he did get it from Trooper Paul's report. Good observation there. WW, did Alessi ever get to cross Guarino? Yes, he passed. There was nothing to ask. Guarino was really minimized this trial. He just kind of became the utility guy who took the phones and performed the extractions, and then the analysis is all coming from everybody else. So there really wasn't anything to cross Guarino about. Now, I, again, would have loved to have nailed down a little bit more of the mystery of John's phone. And Guarino was very much a part of that. Somebody gave the phone to Guarino. Who was that? We need to follow the trail of John's phone. We need to know who is the first responder that Carrie Roberts gave it to, because nobody has ever stepped up and claimed it and said, I'm that person. And then I gave it to whoever, and I gave it to whoever, and I gave it to Guarino to do the extraction. So I would have liked to have asked about that. But that's not part of the defense strategy. You know, they were not going down that particular rabbit hole. Another rabbit hole I maybe would have liked to have followed up on a little bit, the password. His whole argument was they had to wait to be able to break open her phone because they didn't have the passcode, and their extraction program at that time didn't support being able to break into Karen's iPhone. And so it was like they got a gray key update in the fall, and that's what enabled them to finally go in and open up her phone. The problem is during the first trial, both Buchanan and Proctor testified they actually got her passcode. They sat there and watched her put it into her phone. When they asked her during the interview up in Dayton, they asked her for contact information for Mike Camerano. They watched her put her code into her phone and then verified it with her. That is in the testimony. So they knew her freaking password. Wouldn't have minded hammering on that a little bit too. But so the quick answer to your question, yeah, he did get to. He just chose not to. The way that the case is set up this time, there just wasn't much to get from him. Thankful Q. Thankful K. Coming soon, Revenge of the Crash Daddies. I wonder if they got a little pissed at that voir dire. I'm not sure a pissed Dr. Wolf is who I'd want to be facing on the stand, but we'll see. We'll see. If all he's got is you texted by Signal because they asked you to, I think Hank is going to struggle. We'll see. I'm now kind of back wondering. I'm second guessing myself. I said way back in the day when we watched that voir dire, holy shit, there is no way Hank is going to behave like this with this witness in front of the jury. So rude, so snide, so condescending, so insulting, so belittling. I'm starting to wonder if actually maybe he will. Maybe he will. Signal. Completely inappropriate. Everage. I hope they call Paul first just for funsies. I see the attraction of this too. If the issue with calling Paul does have to do with the fact that it does have to do with him not being under subpoena, if he's not under subpoena and that's why it's a question of trying to get him in or not, then I don't know that they can solve that fast enough to get him in tomorrow. It would be kind of, not possible, but just probably trickier than if we have to go and subpoena him and plan to work him in sometime in the next couple of weeks. But I see the upsides to it for sure. Lucy Fair, if Easter testifies, he can show chain of custody issues negate all further testing. Only question left will be what Karen's plumber had to fix. Yeah, if Easter testifies is the million dollar question and all that. As we sit here right now, Easter is not testifying. He's not allowed to. They had to address whatever they wanted to address with procedures and cross-examination. Whether they did that sufficiently, is going to be up to whatever standard Judge Bev decides she thinks is appropriate. And at the end of the day, is she going to reconsider herself and say, yeah, you know what, you're right. Cross-examination didn't give you a fair chance to elicit information about what the appropriate policies are and so forth? No. Let's be real. Of course, she's not going to reconsider it. So, yeah, I think this is a great thought, but I don't think we should get our hopes up. Serious problema. If Brian Higgins is called, could he have knowledge of the new evidence being presented, i.e. video in parking lots and hallway? He shouldn't know about it being presented at the trial. He may know about it having been produced. I mean, it's been in the public record. The fact that this video is out there, it's just nobody saw it until trial. So he would know that it's there. That wouldn't be a problem. The fact that it exists, exactly what it shows. I'd be interested to know if the Commonwealth did any witness prep with him. Wouldn't you? Commonwealth didn't call him. They did put him on their witness list, though. Did they bring him in just to be able to show him the video? I would love to know that. No, he's not supposed to know about the trial and what's happened during the trial. So he's not supposed to know whether it was shown or not. But I think there are permissible ways that he could know that the video exists, and then he could, possibly infer from that. If they have it, they probably showed it, but not for certain. That Southern Blonde Lawyer, watching on my way home from speaking at Bitcoin 2025. Stack sats, y'all. Remind me why the F. Welcher is testifying about injuries, the result of one of Bev's many bogus rulings on motions in limine. Apparently, the biomechanical guys get to testify about injuries this time. Maybe it's just Judd. I don't know. Maybe Dr. Rentschler still doesn't get to testify about injuries, because he didn't in the last trial, because in the last trial it was only medical experts. But we needed to drop that for this trial so that they could bring in Dr. Crosby to talk about the dog bites, when Dr. Crosby is not a medical doctor. He is a PhD doctor. So that rule needed to be relaxed. Once it's relaxed, how do you justify letting one side do it and not letting the other side do it? So my expectation is that Dr. Rentschler better be able to testify about injury causation, because he has this similar, if not perhaps slightly better qualifications for that than Judd Welcher as far as the biomechanics goes. It is part of what he analyzed. He just wasn't allowed to testify to it the first time. And doesn't that now give us a sense of how arbitrary some of these rulings are? We can just completely do it differently this trial. Why? Because the judge has the discretion, and the right to present a defense. It's of minimal consideration in the equation. Texas Sister 2. Yes, you can measure the thickness of the paint. My husband is retired LEO, accident reconstruction, and builds and paints cars now. That is good to know. What a cool thing to know. I mean, yeah, I believe you can definitely measure the thickness of the paint. It makes sense to me. It does. That there would be some way to detect a small repair. Now, what about like if they just replace the entire bumper cover? Would that be detectable? Could we just like swap out the part? Would that be detectable? I don't know. I'm just kind of thinking this through, but it's an interesting thought about how they might go about attacking that particular piece of information. To me, I don't. Of all, like, you got to pick your priorities in the trial, right? And everybody's going to have different judgments about that. And that's why different lawyers will run trials different ways. And it doesn't mean anybody's right or anybody's wrong. It just means there's different strategies. But I probably wouldn't prioritize this too much, just because it's possible to not cause any damage. I mean, that's my own experience. You hit the car, broke the taillight, not a dull spot on my husband's car, not a scuff, nothing, no damage. So, for the damage to be enough to break the taillight may not necessarily be enough to either, dent the paint, damage the paint, or damage the underlying structure. So to me, it's not like the biggest priority. If his car wasn't damaged, to me, that doesn't mean her taillight wasn't broken. But I guess it just, it depends. It depends. People could see that differently. It's just we have it on video. Obviously, she hit his car. Obviously, she hit it with that part of her car. Something came into contact. I don't know. I have to think about that a little bit now. Amerigator, if you watch Blue Man experiment in slow motion too, you can see him lower arm to hit tail light. More importantly, his hip makes contact, especially from the top angle view. Can you imagine hip damage at 24 miles an hour? Yeah, he does. He does do the whole rolling like from his hip, because you'd have to have If your knee is going to be lined up and your eyelid is going to be lined up and your elbow is going to be lined up, I don't know how you get your hip. I don't know how you get your hip away from any of this. Your leg is in the way. Your femur is in the way. To me, yeah, I watch these slow motion replays of his reconstruction. It does. You can see him anticipate it. That's like the biggest apples to oranges problem, that I have with this whole idea of this as some kind of test, is that you're aware that this is happening and you are anticipating it and you're reacting to it. You're not blind. You're not blind. Now do it with your eyes closed. Or are we assuming that John also knew it was coming? John braced it. Why would we make that assumption? We have no evidence of it. Just because that's the way to make it fit? Yeah. A lot of problems with this this little blue man demo. Not particularly persuasive from my perspective, but Nick TTT, shouldn't there be some penalty for not calling Proctor? Pieces of evidence not allowed in. How could everything get in without him? Missing witness instruction at the minimum, right? Oh, not necessarily. I mean, we've talked about that. Normally, the missing witness instruction is going to be appropriate when... So what it's really for is for when you've there's a bad witness out there and you've kind of disappeared them or you've encouraged them. Make yourself scarce. Don't be around for this trial because the implication is that you're trying to hide something. Otherwise, it wouldn't be an issue. It's gotten that kind of idea and that framework. It's been expanded a little bit to the situations where if you have one witness that's particularly associated with one party or the other, or that party has unique access to them or something like that. And then if that party chooses not to call them, you can infer that, that's why, because the evidence would be bad for them. But it's not really always clear in practice how that's going to be applied. If the defense has the power to go and subpoena Michael Proctor and call him in for themselves, then can they really say he's a missing witness? You didn't try to bring him in. If they're not able to bring him in for some reason, then maybe we're on stronger footing. But if it's just a choice that they made to not call him either and then try to blame the prosecution for him not testifying, it's probably not going to get him the instruction. As far as the stuff that shouldn't come in, they just let it come in through Yuri. Yuri authenticated the bag that contained Michael Proctor's taillight pieces from the 14th. And there's no objection to it, so it came in. Or the 18th, I think, is what I'm thinking. It was 7-14, I think was the object. So it could have been. Potentially could have been objected to. Yuri doesn't have personal knowledge of, he specifically disclaimed being there, knowing anything about the search and so forth. So probably could have been objected to, but wasn't. At the end of the day, probably not that important whether the taillight pieces come in or not. What's the other penalty for not calling Proctor? It looks bad. It just looks bad. It looks bad. They don't have to call him. They don't have to call anybody. Nobody has to call anybody. But people will think for themselves about what your trial strategy means. And so if you don't, the penalty is it looks bad. You may not be able to formally argue that like with a missing witness, but people can infer. People can infer stuff. Weird how that lead investigator didn't show up and he seems to have all these problems and his hands all over this taillight. And that's the stuff the defense has leaned into already in their opening. Michael Proctor is everywhere. So where's Michael Proctor? Sandy B, in the 70s, you could easily break a taillight and explode. It was made the same. Oh, I don't know much about other than, like I said, taillights used to be incandescent bulbs and now they're LED. But other than that, I assume there have been massive advances in material science, especially plastics, since the 1970s. So I don't know if they're using the same materials or anything like that. Don't know. But if he's, relying on information from the 70s, then maybe that would explain why we are visualizing this happening like it might have happened in the 70s, or the injuries and the damage and all that. Well, guys, I mean, hey, we got through it. I knew we could, and we did. And all we had to do was persevere, and it's over. It's over. We made it through that very, very challenging cross-examination. Didn't take the 4 hours after all. Didn't even take our entire half day. In fact, we're still ahead of schedule, but now that the Commonwealth is rested, I suspect we might need to start rushing a little bit, but we'll see. We'll see how generous the judge is with her time now that we have moved into the defense case. And now we get to be on pins and needles all afternoon, wondering what are we going to get tomorrow? How are they going to open? How are they going to start? Oh, I so hope we get Dr. Wolf to start. So my plan for tomorrow, I'm going to assume tomorrow is a normal day for our purposes, that when she says we have to do stuff with the attorneys in the morning, that means we're going to do it on the record. Not that we're going to do it at Sidebar, but I don't know that. They might do it at Sidebar so that we don't get to hear what it is that they're talking about. But it might be like this morning where they're having argument on the record in open court. So I'm going to err on the side of thinking there may be court tomorrow. So I'll just be here normal time. And we'll expect that the jury isn't going to be in till a little bit later. But then we got a full day. It's a Friday. We got a full Friday. And it's been that short week. I'm still a little just, not quite right. It's still May, but it's after Memorial Day, and it's a short week. And so it's almost Friday, but it still feels really early. It's always the first full week after the long weekend that really messes you up, isn't it? You guys notice that? It's like the short week is fine. It might feel a little weird, but then you go back and you have that first full week after the short week, and it just feels like it takes forever. Feels like it's so long. But it's going to be all defense case next week, so it'll be new. It'll be a little bit unpredictable. We already know there's so much more new stuff from what there was in the first trial, and all we got to do is just show up and patiently wait for it to be delivered to us. See what kinds of questions we can have answered. Kathy, your realtor living in New Jersey, says, thank you for going through this with us. I love your shut up. Well, good, because I'm not sure I can stop it at this point. I'm not trying to be dramatic or anything, but sometimes somebody just really bothers you. And his little smug responses, they just really bother me. So he can shut himself right up. GV, Karen outside courthouse, first witness, Matt DeSogra. I'll take it. Data. We can start with the data guy. I don't have any problem with that. We don't know him. We haven't seen him before. He's new from the first trial. So the impression that I've gotten is that he's kind of the substitute for Richard Green. It's not that they dumped Richard Green, but they hired Matt DeSogra, I think, to do more. And then since he was doing more, just the impression I've gotten, but we'll see. So, hey, data, phone data, digital data is how we're going to start it off. Hey, it works for me. Sandy B, it wasn't made the same. Sorry. Okay. Yeah. I assumed it was made different. If nothing else, the incandescent bulbs are different, but we'll see. Well, guys, pretty good day. Not a bad day. I think if we had expectations for a big explosive bomb drop cross exam, mic drop like we had with Shannon Burgess. No, it's not a good expectation. Most experts don't make those kinds of mistakes. So that would be setting yourself up for disappointment, I think, to expect something like that out of this cross. So if we set our expectations at success being simply we've highlighted what we need to highlight, we've pinned him down to his position on certain issues that we are going to come back and address when we have our own expert on the stand, then we're only going to know whether we have a success or not once we get the defense expert on the stand, once we have ARCA there. So got to be a little bit patient to gauge that. But just in terms of a feelings standpoint, no, not a big like, ooh, the defense really won that, but also not really a huge, ooh, Welcher won that either. I don't think. Yeah, he came off as having explanations, having answers, but he also just, came off as being extremely selective and extremely pompous and rather rude. These just tend not to be good things that work in your favor. So not a big day from a feelings kind of standpoint, but that's okay. You're not going to get that every day at trial. The reality is most of the time spent in most trials is actually fairly boring. So it's just part of what it is. Sandy, if you have time, can you review quickly the witnesses the jury heard from and their point? Well, let me see if I can pull that right up here, because I have been kind of doing my little summaries, and I'll see how fast I can do this. Why not? Day one of trial. Take yourself all the way back there, guys. All the way back to day one. We had Timothy Nuttall and Kerry Roberts. Timothy Nuttall's there for I hit him. He's a firefighter, first responder. Kerry Roberts was the friend of John who was there in the morning. Karen called and she went on the search and so forth. Also claimed she's the one that picked up John's phone and gave it to a first responder, but we don't know who. Day two, we had the conclusion of Kerry Roberts. We had Peggy O'Keefe testifying about just that day from her perspective, who John was and so forth. Also kind of the dynamic with Karen, which frankly didn't come across making her look very good. Not to me, but Nicholas Guarino was on the stand for the first time on day two, talk about his extraction process. Daniel Whitley, he was the firefighter who came and sectioned Karen. The point of him seemed to be her making this comment that nobody who knew Kerry Roberts would say she's a good support system. That really seemed to be it. I'd like to tell you more, but that was like the big takeaway from Daniel Whitley testifying and his role that he played in it. Day three, we finished up with Daniel Whitley. We had Jean DeMoulis and Bridget Meehan. Those were both the manager folks from the bars. They just authenticated the surveillance video from CF McCarthy's and from the waterfall. Mike Camerano testified. He was the one that the friend of John's that met him at the bar. His kid was over at John's house. He went and picked up Kaylee in the morning. All that. Nicholas Guarino came back on the stand to introduce a whole bunch of Celebrite reports. And then day four, we had Dr. Gary Fowler. He's the one at Good Samaritan who testified about the protocol for drawing blood, not forensic, but clinical blood draw, and the result of it. Jason Becker, the second guy who was involved in sectioning the Karen, and his point seemed to be that she made a comment to him about her last conversation with John was an argument. Day five, Ian Whiffen, cell phone data. We did the voir dire of Arca on day 5. Like, how long ago does that seem now? It seems like a million years ago. Voir dire of Arca. Day 6, we continued with Ian Whiffen and his data analysis. Then we went on to Jen McCabe. Jen McCabe is on direct. We know what Jen's about. It's the same thing as trial 1, basically. Day 7, day 8, all Jen McCabe, cross-examination, and so forth. So, you know, what she says she saw versus issues with her credibility. Day 8, we had Hannah Knowles. She was the retrograde extrapolation expert. She testified that you get a range of 0.14 to 0.28 blood alcohol content at 12:45 a.m. for Karen under a whole variety of assumptions that may or may not be the case. She finished up on day 9. Day 9, we also had Ryan Nagel and Heather Maxson. They were there to talk about arriving. They were in the F-150 that followed Karen's car over to 34 Fairview, saw it sitting there, passed it when they left, and saw Karen sitting alone in the passenger side and in the driver's seat and nobody in the passenger side. Sarah Levinson was the friend of Brian Alberts who was in the house. And yeah, just that they left. She got the ride home with Jen and Matt, and her story didn't add up with Jen's. Jen had the whole story about nobody saw John because we were joking about bread. Sarah says I didn't see out the window because I was looking at my phone. She has us talking about the bread at a different point in time. We had on day 9 Katie McLaughlin, the firefighter. She's the first responder, second first responder that puts I hit him into Karen's mouth. But like Mr. Nuttall, her story doesn't add up, although we have not seen that specifically be contradicted so far. The defense might need to call Seraph and Good, Officer Good, if they, want to attack that. We'll see. Paul Gallagher, God, wasn't he a million years ago? He's the Lieutenant Gallagher, who was the on scene or the shift detective, I guess. So he's the one that showed up with the snowblower, and it was great. And he's also the one that knew we didn't need to bother to get Chief Kelleher's camera footage because I picked up packages there, and it doesn't show you what you need to show, what you need to see, like the right angle and so forth. Finish with Paul Gallagher on day 10. We had Robert Gilman, the meteorologist, back on day 10. How much snow there was at different times, temperatures, wind chill, etc. All in all, not clear why this guy was a Commonwealth witness rather than a defense witness, but hey, we'll take it. Finally, Guarino, this was when he concluded with the last of the things he was going to introduce, just more reports and stuff like that. No cross-examination of him. Charles Ray on day 10, he's the one that drove to One Meadows Ave for the welfare check at 8:30 in the morning. He got that image on his dash cam of the back of Karen's SUV. Then we got Kevin O'Hara testifying about the CERT search. Day 11, Connor Keefe, he was present for the CERT search, testified about how he was the one who put the stuff in the bags, but unfortunately his initials and stuff are not on the bag, nor was it entered into custody, apparently by him. Jessica Hyde on day 11, she told us about pizza and fried chicken and waffles, and we're not entirely sure what else. She is there to talk about the 227 search, and if you got through her word salad and the way she was kind of talking around what the issues actually were, you end up with, she doesn't know if a search took place at 2:27 a.m. She just knows that a tab was opened and the search was run at some point, and then the tab is closed or backgrounded or whatever at the later time. So then day 12, we started with Yuri Buchanek. We know about Yuri. He's the proctor surrogate. If we're not going to get proctor, then he's going to be the pretend lead investigator. So that's what he did. He was also on day 13 and 14 for his cross-examination. Day 15, Zachary Clark. He took photographs of the search warrant execution on Karen's car in February at the Canton Police Department. That's pretty much all that he did. He documented the braking and acceleration tests by Trooper Paul. Isn't it ironic? It's kind of ironic that Hank raised this guy in his argument this afternoon. You know, well, Zachary Clark took the photo, so now they want to, well, you called Zachary Clark as a witness to testify about that. Like, if it's an issue to ask about that, why'd you even call the guy? I mean, I don't know. And then Evan Brent documented the planned excavation, the February 3rd search, when Tully, Proctor, Buchanek, DeChico, and more all went back to the scene to find some more plastic and glass. And they found, 12 things or something like that, but only took photos of 5. A little bit of an issue. Brian Gallerani, a Needham police sergeant who took swabs from Proctor and Buchanek to do DNA collection. Maureen Hartnett started on day 15. She's the crime lab forensic specialist that looks at body fluid collection and analysis. She's the one who went to the Canton Police Department on February 1st to examine the car. There's no blood under the car, all that type of thing. Scorty Bello on day 16, forensic pathologist, undetermined manner of death, injuries, etc. Day 17, Andre Porto, who was the DNA analyst from the crime lab. He's the one who told us about all the mixtures all over John's clothing. And, John's DNA is on John's own clothes. The mixture of 3 males on the taillight, the exterior portions of the taillight. We then had Ashley Valier. She's the physical match analyst from the lab. She's the one who put the taillight back together. And then on day 18, Nicholas Bradford, he was the DNA analyst for Bodie, testified that Yuri and Proctor were not contributors to the taillight mixture. Okay, so we know who 2 of the men probably weren't, but still not sure who they are and what they're doing on the taillight. Carl Miyasako is another Bodie DNA analyst. He did the mitochondrial DNA testing on the hair, the shaft of the hair that was found, the magic hair, that the heroic hair, the heroic hair that clutched the SUV all the way through that storm driving and then ended up in the Sallyport to be collected. John could not be excluded, although 99.895% of people, the population, could be excluded. So we do the math, that's 357,105 people that are potentially included as that hair belonging to them. Day 18 is when we started with Shannon Burgess. Day 18 was when we started with Shannon Burgess, including we got to start in on the cross, and boy, it was a fiery one, wasn't it? It was this one was the kind of one you have fun with from a feeling standpoint. Burgess gave you a lot to lean into. So he also went on day 19 with the cross. He's, of course, the data analyst with the the CV inflation problem. Christina Hanley is the trace analyst. She's the one who testified that the glass that Yuri found on, I believe it was the 10th, matched the cup, but the bumper sprinkles did not. She didn't do a materials examination, but it's not clear. Why would you not do that? Did you not want the answer to that question? Day 20, Isaac Wolf, the neurosurgeon, the guy who does 4 surgeries a day. He's seen more brains than the pathologist does. told us this looks a lot like when you slip and fall on the ice in Minnesota and crack your skull when you're drunk. Okie doke. We came back to Hanley at that point at the end of day 20 and concluded with, the glass comparisons. Day 21 is when we started with the direct examination of Judge Welcher. Day 22, of course, was yesterday, where we concluded his direct examination, got into the cross and all of his testing, his blue paint, all that stuff. And then we have today finishing with Judge Welcher. So that is the very brief rundown of the witnesses that have been heard from, what they've had to say. I have been, working towards putting together kind of a summary and outline that my plan is to ultimately get it up on Substack. I'm just not, the number of hours in the day right now when we're, spending 10 watching the trial, it's tending to not spend them doing other computer stuff. So not quite ready to put that up yet, but probably have some time this weekend to plug away at that. So do keep your eyes open if that's something you'd like to have a quick reference. I am working on getting that out. Z, do you think Norfolk County DA MSP office corrupt? Well, I'd say that, again, corrupt has a technical legal meaning. And I think that if it was corrupt in a way that could be proven, we would have seen charges from the FBI. And so what I've said many times is that, one possible explanation for why we haven't seen charges here is because it is technical. And you have to show basically a quid pro quo. You have to show there's been some kind of benefit that was received in exchange for doing something else. And when you just have a good old boy system where everybody knows their role, everybody knows the part that they have to play, you don't have to do things explicitly. You don't have to say, here's what I want you to do, and here's what I'm going to do for you. Everybody already understands. You do your part, and then when you need a favor, you'll get it. Everybody understands. Someday I will come to you and I will ask for a favor. That's the deal. So, proving it explicitly is very difficult. There certainly seems to be a problem with, at the very least, bias. Real problem with bias when it comes to law enforcement being potential subjects of an investigation, because we see these patterns of inexplicable incompetence, both in the Sandra Birchmore case and in this one. That to me is enough to raise my suspicion. It doesn't get us to corrupt in the technical sense, but it gets me to, they will not prosecute a cop. They're going to bend over backwards to find reasons not to prosecute a cop, even when the feds are going to prosecute a cop, an ex-cop, and seek the death penalty. Have they said they're going to seek the death penalty? Actually, I take that back. They maybe can. The option is on the table. I don't think they have said that, but the option's on the table. You're still going to stick with suicide. That, corrupt? No, it's not corrupt in the technical sense. Is it a huge problem? Is it a rules for thee, but not for thee, for me? Is it some animals are more equal than other animals? Oh, 100%. Absolutely. I have reason to think there's serious concerns about stuff like that with a lot of these players, but corrupt, I don't want to be semantic, but it does mean something technical, and I don't see proof of that. Unless you want it, I buy, obviously, a old boy system like that. It's a corrupt system, not in the technical sense, but yeah, when it's your turn, they'll have your back. That's the deal. Is that corrupt? Yeah, it is. So, if that's how we're going to define it, then yeah, I think there's a big problem here with the old boy system, and everybody knows what you need to do. Marcelo, Bev's mindset. Tie defendants' hands because they are too smart, and if I give them what they are entitled to, the Commonwealth will lose. She thinks it's cured because Karen has good counsel. They can overcome her rulings. No, I think she knows better than that. She's trying to put on the record, oh, Mr. Alessi, you're so able. You're such a skilled cross-examiner. You'll be able to get, I have full confidence you can get everything you need through cross-examination. She's putting that on the record, so it sounds like she's being fair and she's anticipating that they'll be able to get there anyway, but she doesn't. She doesn't actually expect that or think that. She knows perfectly well these witnesses are not going to cooperate. They're law enforcement witnesses on cross-examination. Of course, they're not going to give you what they want. Of course, they're not going to say, why, yes, this was a terrible decision, absolutely appalling judgment that we had to throw these evidence collection and documentation and retention norms out the window in the investigation of the death of a law enforcement officer. Of course, they're not going to say that, and she knows that perfectly well. So no, she doesn't think it's cured. She's just trying to make a record that makes it look like she's being fair. That's all she's doing. Robin Hall, today, Judd Welcher stated that the hydraulics wouldn't have changed in reverse because Karen Reed didn't go faster than 1 to 2 miles an hour. What the fuck isn't the theory that she was going 24 miles an hour? This was only talking about the part when she was backing out of the driveway, when she was backing out of John's driveway at 1 Meadows Ave. This was not talking about 34 Fairview. It was during the questioning about, the 3D scan and what height was it at. And obviously that would change the angles and what comes into contact with what and so forth. So, if he based all of his assumptions on where it was set at the time it was at Canton Police Department, then if it hadn't lifted when it came out, then surely it would be lower. Seems like it would be lower than where he would have done it with his scan. Don't know. Sandy, thank you. I watched every day, but I thought maybe I missed the part where the Commonwealth proved that Karen hit John, but they just didn't present any evidence to that. The jury must be so confused. No, it is and always has been a very weak circumstantial case. The strongest piece of evidence they have, in my opinion, is the taillight pieces, particularly the cert ones, because you do have to, you have to entertain the possibility that either it's corruption, that those were planted, or that the evidence was so badly mishandled that we don't know what was what. We don't know if this is, Karen's taillight, if this ended up in the reconstruction or not. It hasn't really been spelled out for the jury, and it's very unlikely that they are going to deep dive the taillight like many of us, taillight truthers have kind of tried to do. I'm fascinated with the taillight. I feel like there's a whole story in the taillight, and not just what's in the tail, everything that didn't fit in the taillight. Like that's how's that not a thing? What's all this taillight doing all over the lawn if it didn't come from Karen's car? It's always been a circumstantial case, and it's primarily based on I hit him, and then just the little things that they can try to do to bolster that. So the taillight plastic to me is probably the strongest piece. She being drunk, doesn't help. And other than that, what? That's pretty much it. Pantoufel, Bev untouchable, appointed by former governor till 70, not accountable to anyone. Only way to fight guilty verdict is by appeal. Very hard. How can this be? This is how the Massachusetts Constitution establishes it, guys. This is why we have the federalist system, so that different states can try different things, see what works and what doesn't. And we also have privileges and immunities between the states because we are a union of states. We are united as a country. And so among those privileges and immunities of citizens of one state is that they may freely relocate themselves to other states. I don't know what else to tell you guys. Like this is structural. This is built into how it works in Massachusetts. I'm not sure that, we have elected judges over here in Washington. Is that a lot better? Not really. Not really. Nobody knows what to elect a judge based on. Nobody has criteria for like what makes a good judge or what doesn't make a good judge. And so it ends up being largely political anyway, just like a governor's appointment is. It ends up being a political process about, who campaigns for you, whose endorsement do you get, that type of thing. So it's just a problem with how we select judges, and we have certain expectations of them, but the power and privilege that we give them in that position is going to have the tendency to undermine those qualities that you actually want as a judge. It's the paradox we've always had with giving people power, all the way back to Plato's Republic. Socrates is the one who pointed out the people who are the least suited to rule are the ones who are best, who are most likely to want to do it. Whereas the people who are best suited are by nature going to be least inclined to want that kind of position and power. If you want to be a judge, not that there aren't perfectly good, perfectly valid, perfectly altruistic and honorable reasons to want to be a judge. It's a very important role. But a lot of people are going to want to be a judge, not because it's an honorable position and I want to rise to that challenge and I want to serve the community and I want to serve the justice system. No, they just want the status. They want the status and the pay raise, and it's kind of a cush job. You have to show up at 9 and go to work, and everybody kind of operates around your schedule. You got all the staff to run things for you. You're in charge of everything. You're the boss. Everybody looks up to you. It's just status is a lot of it. So I would love to be able to give you guys a solution, but other than paying attention to what's going on in your courts, paying attention to who you elect, who's in the position of being able to make these decisions about who gets the power and who doesn't, and then when they get that power, how they exercise it. We've got to police the government, guys. The government is not going to police itself for us. And I know that's just not very satisfactory, but it's just kind of the bottom line. We have to be constantly vigilant to not be tyrannized by the people that are supposed to be serving us in our institutions. T-Rex Trucking and More. Would you call Proctor or ARCA first? If you call Proctor, do you call someone like the dog bite expert to pad it so that you leave the jury thinking about Proctor over the weekend before Cross? I don't call Proctor first. He's too much of a wild card, just in the sense that you don't really know what you're going to get from him. He's not necessarily the important point anyway. If we want to focus on there was no collision, and that's our theme, then I think we start with the problems with the data, because you have to really twist the data to turn it into a collision. You have to make up explanations for things like the steps aren't steps. They're the car going over a hill and, stuff like that. So, you use what is going to most advance your primary theme of your case. And so if there was no collision, Michael Proctor is kind of an aside to that. Michael Proctor is getting to why you should have doubt. He's like another reason, but he's not the standalone reason why. We could take Michael Proctor out of the picture and we'd still have some concerns about why is Jen McCabe Google searching Hoslong to diet cold at 227. Is she in fact? And if she is, why? The guilty knowledge there. All the data in terms of the location and steps and, the health data and activity and so forth. I think that's where they're likely to focus. Melissa Garcia, Judge Kim John Canoni, Emily prosecuting versus Andrea defending. What does that trial look like? I would be glued to my screen. Love both perspectives. It'd be a challenge. Emily's no slouch. Emily knows her stuff. It'd be fun. I'd be down. We could do a moot trial of maybe Karen Reed. I don't know. We'll see. T-Rex trucking and more. If I'm a juror, I'm sitting here thinking, well, obviously the taillight spontaneously exploded, and that's why John O'Keefe is no longer alive. Hey, anything is possible, isn't it? Sorry about that. Mr. Engineer, Mr. Welcher, anything is possible. So it's possible the taillight just spontaneously exploded. And it's possible that all of those taillight pieces, they actually apparated from the Canton Police Department Sallyport, where they have a rip in the space-time continuum. And that taillight was actually sucked into a wormhole, and then it reemerged out here on the lawn of 34 Fairview. Disprove that. Anything's possible. Ethan Morgan, do you use Signal beyond the scope of redirect? Well beyond. That was crystal clear, but whatever. It's different rules for different people. Carolyn Smith, Reed just confirmed DeSogra is called first. So we're going to get into the data. So that'll be fun. The reconciliation of all the different pieces is a big part of it, especially the location, the people showing up at the different times, and then Jen doing the texting. Jen texting John, Jen calling John, all that stuff. Yeah. The reconciliation is where it gets a little tricky to look at this and make sense of it in a way that is consistent with the Commonwealth's theory. Leandra, 19 years ago, I was a juror in a long federal capital trial, 4 months plus. My brain still hasn't recovered. That is a very long time and a very serious trial. If you're not used to that type of thing, I can imagine, yes, it would make an enormous impact. It's serious. Very, very serious stuff. It becomes very real. I imagine the responsibility you feel in a position like this has got to be just overwhelming. So yeah, I would think that would be life-changing. I'm still waiting to call in for my jury summons. So excited that I got it. Don't think I'm probably going to be selected, but you never know. I could get lucky. Norman Corey, Be in Trouble 31, did a really great video to show people what real text stream looks like, not a homemade chart. I'm gonna have to go check this out. Be in Trouble 31 has really been on it with a lot of this vehicle stuff, a lot of really good data and videos and stuff like that. I have such a hard time keeping up with all of the good content that people are putting out. So many good content creators, guys. I'm gonna go check out. I started to catch Gray Space. Went on Ian Runkle's channel last night. Want to go listen to that. Be in Trouble 31 has been doing stuff. Microdots has been doing stuff. Yeah. You almost hate to start naming people because then it's like when do you stop? Then you might forget somebody, whatever. But there are so many good content creators really digging into a lot of these details and trying to find good information and get answers. So I appreciate a lot of the work that Be in Trouble 31 has done. Try to shed light on some of these technical issues that we don't necessarily know about independently. All right, guys. Well, with that, it is still a little bit early for today, but that's okay. We get our afternoon off. We were anticipating that. We were looking forward to it. Our short week got even a little bit shorter. I got that little bonus. The little bonus afternoon to go around and move our little bio machines here. Get all the fluids moving and the gases gassing and all the stuff doing what it needs to do to live this human life that we get to have on this planet. So I might I don't know. I hadn't given a lot of thought to how I'm going to spend my afternoon today. It's actually probably a good day to go mow the grass, because otherwise I'm going to have to wait till Saturday, and I think that might be too long. So I might do that. But I'm gonna be thinking about tomorrow. Matt DeSogra, huh? We're gonna start with Matt DeSogra. So we're gonna go in hard. We're gonna go in hard on the tech data. So everything that Ian Whiffen said, everything that Jessica Hyde said, that's potentially all back on the table. All the Celebrite reports that Nicholas Guarino got into evidence, but then we never heard anything about. Well, other than the Higgins text messages with Karen. That we certainly heard. But there was a whole bunch of reports, text between these people, text between that people, these calls, that calls, these texts, etc. They just got dropped into evidence, but never published, never discussed, not drawn to the jury's attention. So expect they're going to deal with it, because otherwise you can anticipate Hank is playing a sandbag game where he just has it in there and then he'll pull it out in closing, and say a bunch of stuff about it that there's no testimony about, but he'll tell you what it means once you've lost the opportunity to be able to, cross a witness who's taking that position on it. So I'd expect those types of things are going to be part of the analysis. I don't know how much or what, if at all, he's going to get into the vehicle data analysis like Shannon Burgess. Pretty sure he is. Pretty sure that was part of his role in all of this. So could be fairly comprehensive. Maybe we'll learn more from him about things like this air ride system that it has and how it works and how it registers and all that. But we don't know. Melissa R., we all know what happens when once you get past the Van Allen radiation belt. Do we? Do we? You run and Google this real quick. The Van Allen radiation belts are two donut-shaped zones of charged particles, primarily electrons and protons, that surround Earth within its magnetosphere. These particles trapped by Earth's magnetic field can pose a hazard to spacecraft and astronauts. The belts were discovered in 1958 by James Van Allen using data from the Explorer 1 satellite. Interesting. So it makes sense. Part of the magnetic field. Maybe I'll go down this rabbit hole. I love a good rabbit hole, to go down for an afternoon, learn something a little bit new. Maybe I'll learn about the Van Allen radiation belt. Actually, I bet Jeff knows something about the Van Allen radiation belt. He'll probably tell me. Oh, we got Phillies baseball again this afternoon. We got rained out yesterday, so I think we're supposed to make it up. Is it doubleheader today, or is it doubleheader on the weekend? I can't remember. Anyway, we should have baseball today if it's not bad again. So, hey, we got lots of ways to try to fill our afternoon. Occupy our minds, not get too caught up in the feelings of what one day brought versus another day. You get too attached to your feelings, that can be very addictive. It can be very addictive. So, not to say that anybody's above them or doesn't have them, but just can't put too much importance to them. They're transitory. They'll go. Everything passes. Even your feelings about how today went. It will go. It will change. It will turn into something else. So we come back tomorrow on day 24 to finally start the defense case. I'm all about it, guys. I can't wait to see. Matt DeSogra is brand new. Didn't hear from him last trial. So he's brand new. I can't wait to see what they have added to their tool belt from the last time. So with that, guys, going to call it a day. Thanks to all of you. Appreciate all of you. As always in the chat. So many good comments, clever comments, very amusing usernames. Appreciate all of you and your contributions, helping to make this just a fun place to hang out, watch the trial, and try to make sense out of it. Thank you for the mods, for your role. That keep things running smoothly, keep things on track. If there's an asshole that needs a warning, the mods will take care of that for us. So it's nice knowing that we can count on them to keep this place a good environment. Not because we're policing what people think or anything like that, but we do expect a certain standard of not being an asshole if you're gonna come hang out and chat. So hey, clear that bar. You shouldn't have a problem. If you're not clearing the bar, one of the mods will let you know, and we're very grateful to the mods for how they handle that. And just keep our vibe cool here. It's what we're trying to do. Trying to be welcoming to folks and to just shed some perspective and understanding. And if you enjoy that kind of thing, then you'll stick around. And hey, if you don't, then you won't. And that's totally fine. So day 24 tomorrow, I will be here at the same time, 5:45. We'll see if whatever Judge Bev has to do tomorrow morning with the lawyers is something that we get to participate in. So I'll assume it is. If it's not, then whatever. We'll find something else to talk about until we get into the defense case. Looking forward to it, guys. Appreciate all of you. Thanks for another good day. Thanks for a good conclusion to the Commonwealth's case. I feel pretty satisfied with how that wrapped up. It's everything we knew it was. The whole fact, science, and data. It's always been a head fake. It's always been a head fake. Your own expert concludes your case by telling us he doesn't have enough data to know what happened to John. And then we go to Karen's words, which is, as we all know, what it's really been about this whole time. So see what kind of effect that has on the jury once we get there. So with that, guys, one day closer tomorrow to the inevitable conclusion of all of this. Maybe, fingers crossed, we can hope for some kind of definitive conclusion this time. We'll see. Looking forward to the changes and the adjustments and so forth. Obviously, the new information. So we'll be here. Look forward to seeing you guys. Thank you again. Take care of yourselves, and we'll see you tomorrow.